Good morning, everyone. I hope everybody is on. We are starting. It is 9:30 prompt Eastern Time. And welcome to the second day of hearings on the application of CSXT and others to acquire Pan Am Railways and the other various requests we have received that are part of this whole proceeding. I'm not going to take time for them. I think everybody knows what they are. Before we begin, which we're going to do promptly, we have the couple of reminders. Remember to turn your cell phones off. Remember to keep yourself muted and off camera, except when your panel is up for presentation. And I just want to take a moment to give a shout out to the IT team that has this virtual hearing together, and particularly to Matt Cross, who I think is our principal director and producer, or whatever the title is. But to me, yesterday went remarkably smoothly from the technical and virtual point of view. I think we're all pleasantly not surprised, but delighted that this is working so well. So great work. Keep it up. It'll be another good day. We're going to begin with panel 5 this morning, but I see we have been joined by Senator O'Connor from Massachusetts, who was unable to stay as long as we needed him to stay. I assume he had other important obligations. So I think with respect to Senator O'Connor, I'm going to ask him to step up first and make his remarks, and then we'll go into panel 5, so we don't keep the senator waiting another day, however long this hearing is going to last. So with everybody's permission, I'm going to call on Senator O'Connor. Hearing no objection, you're on.
Thank you so much, and I appreciate the consideration to be taken out of order. Good morning to everybody, and thank you for having me. I'm here to testify in support of the CSX Transportation's application to the Surface Transportation Board to acquire Pan Am Systems and its subsidiaries. As the senator for portions of the Plymouth and Norfolk counties in Massachusetts, I believe that in this acquisition, the interests of my constituents on the South Shore will be met. Many of my constituents, especially with the expansion of the Greenbush commuter rail and other commuter rail services in my district, really utilize this form of transportation to get to and from Boston. And this proposal, in my opinion, opens doors to enhancing that commuter experience as well as the infrastructure itself. While Pan Am has served Massachusetts well, an approved merger would mean we can implement CSX's best practices to make freight and passenger rail more efficient, safe, and competitive. CSX's strong record of efficiency and compatibility with passenger rail services will significantly benefit residents and businesses here on the South Shore. And over the next 5 years, I was very encouraged by CSX's plan to inject a lot of capital into Pan Am's existing network to upgrade and modernize the infrastructure, where I think that Pan Am may lack the resources to do quite the investment that CSX has laid out. These investments will allow for increased competitiveness, better quality of service, and much needed maintenance on the rail network. CSX has achieved a 93.6 contract on-time performance level in its interoperability with passenger rail, and they plan to increase the track speeds to 25 from 10 miles an hour, which I think will just streamline the entire rail transportation process in the region. For the reasons that I've stated, I respectfully request and appreciate your review of this application, and I would hope that upon review, you would potentially see a favorable opportunity for this to go through. Again, I thank you for the opportunity to be able to be taken out of order, and I wish everybody the best as you continue the second day of this public hearing, and for everyone to have a great weekend as well.
Thank you much, Senator. Appreciate your time and commitment to come and speak to us. Does anybody have questions? Karen Hedlund. Unmute your Karen.
I did. Senator, thank you very much. I just wanted to note for the rest of the panelists that Plymouth County is the most historic part of the Commonwealth of Massachusetts, which I where I lived, not in Plymouth County. I lived in Cambridge for 5 years. But you might wonder what the colonists would have thought about where we are today.
I'm sure they would be very surprised in many aspects, both good and bad.
Yeah.
Yeah,
Thank you.
you made us suggest that Paul Revere could have taken the train to warn everybody. Anyone else have questions for Senator O'Connor? All right, Senator, thank you very much. Much appreciated. Let us then move right into panel 5. And so everybody knows who this is. It consists of the National Rail Passenger Corporation, which we all know and love as Amtrak, Dennis Newman, the Commonwealth of Massachusetts DOT, and the MBTA, represented by Robert Wimbish, and CP, represented by James Clements and David Meyer. So if you will all step up to the plate, we will begin with Dennis.
Thank you very much. Chairman Oberman, Vice Chairman Primus, board members Fuchs, Headland, and Schultz, good morning to all. My name is Dennis Newman, and I am Amtrak's Executive Vice President of Strategy and Planning. I appreciate the opportunity to appear before you today to talk about Amtrak's position on CSX's proposed acquisition of Pan Am. In the comments and final brief Amtrak submitted, we asked the board to impose 7 conditions on the acquisition if it approved it. Those conditions were intended to ensure that on-time performance of Amtrak trains on Pan Am and Pan Am Southern lines and on CSX's Albany to Worcester line was not degraded as a result of the merger. That the merger would not inhibit the addition, expansion, and improvement of Amtrak services, and that CSX would fulfill its statutory and contractual obligations to Amtrak and adhere to the representations about Amtrak services that it has made in this proceeding. Now, late Wednesday, CSX submitted a letter to the board from its counsel. The letter requested that the board impose as conditions on its approval of the Pan Am acquisition 6 of the 7 conditions Amtrak has requested. Amtrak is gratified by CSX's agreement to these conditions. It sets the stage for advancing the long-held vision of Amtrak and its state partners to expand and improve Amtrak service in northern New England and along the east-west corridor from Boston to Albany. Thanks to the Biden administration and the funding Congress has recently provided for investment in intercity passenger rail, that vision is no longer just a dream. Amtrak is committed to making it a reality, and to doing so with the cooperation and collaboration of CSX, which it has committed to in this proceeding. Now, the other condition Amtrak requested, condition number 6, was that Amtrak be allowed to operate the Albany, New York to Pittsfield, Massachusetts Berkshire Flyer over a 40-mile segment of CSX's Albany to Worcester line, and permitting these Amtrak trains to change ends at the Pittsfield station on track 1. The Berkshire Flyer is proposed as a seasonal 2-day-a-week extension of an existing Amtrak train that would provide an alternative to driving for weekend visitors to the Berkshires. The CSX did not agree to imposition of the Berkshire Flyer condition. Rather, it appended to its letter to the board a letter from Mr. Foote indicating that CSX would allow operation of the Berkshire Flyer in 2022 on weekends between Memorial Day and Columbus Day, but that CSX would require a commitment for a 1,000-foot station track at Pittsfield. Now, Amtrak welcomes CSX's proposal to allow for operation of the Berkshire Flyer. As the letter from Mr. Foote indicates, Amtrak and CSX would need to agree upon terms for the initial operation of the Berkshire Flyer in 2022 or 2023 as a special train. Amtrak will also need to evaluate, together with the service's sponsor, the Massachusetts Department of Transportation, CSX's request for a commitment to construction of an additional track at Pittsfield for sustained operation of the service, and the operating plan and cost associated with CSX's proposal. In particular, we will need CSX to explain why it believes capital investment is necessary for Amtrak to operate 80 passenger trains a year over a 40-mile segment of CSX's Albany to Worcester line, when CSX has agreed to allow Norfolk Southern to operate 730 nearly 2-mile long trains a year over the entire 160-mile line without any capital investment or capacity study. We've already reached out to CSX's NRPC officer, CSX's designated point of contact, to gather additional information regarding CSX's proposal for the Berkshire Flyer. And we hope that it will be possible for Amtrak and CSX to expeditiously reach an agreement that will enable the operation of the Berkshire Flyer and make it unnecessary for the board to take further action to address Amtrak's proposed condition. We will advise the board if an agreement is reached. Now, if Amtrak and CSX can reach such an agreement promptly, Amtrak is prepared to withdraw its opposition to CSX's proposed acquisition of Pan Am. Now, I would like to briefly address 3 things CSX's representatives said during their presentations. First, we were surprised to hear Mr. Foote raise safety as a major concern in the Gulf Coast matter, but we will address that contention in more detail in the Gulf Coast proceeding. Second, CSX's claim that it had achieved over 90% on-time performance on Amtrak routes is based upon a provision in CSX's contract with Amtrak that determines eligibility for incentive payments. It is not based on actual on-time performance or the customer experience, and it has no relationship to the on-time performance metric FRA adopted in its recent rulemaking under Section 207 of the Passenger Rail Investment and Improvement Act. That metric is customer on-time performance, the percentage of customers who arrive at their destination on schedule within an allowance. Of the routes Amtrak operates over CSX, the majority, about 60%, did not meet the statutory standard of 80% on-time performance under the Section 207 metric for the past 2 consecutive quarters. And then finally, Mr. Boychuk's statement that the planned installation of positive train control on the route of Amtrak's Downeaster would not have happened, quote, but for CSX's acquisition of Pan Am is incorrect. Amtrak had been actively planning for the installation of PTC on the Pan Am portion of the Downeaster route before CSX announced its intention to acquire Pan Am. And Amtrak, not CSX, will primarily be funding the installation cost. I also wanted to clarify one aspect of the letter CSX sent to the board on Wednesday. And CSX's letter asked the board to impose the 6 Amtrak requested conditions, quote, as the conditions relate to the PAR system and the existing CSXT network, unquote. The definition of PAR system in CSX's amended and supplemented application does not include Pan Am Southern. Pan Am Southern is the operator of rail lines impacted by the acquisition over which Amtrak operates and a party to this proceeding. Pan Am Southern and all of CSX, including any rail lines CSX might acquire in the future, should of course be subject to these conditions. And that is what Amtrak requested, and CSX has offered no reason for any modification. So let me close by saying that we are grateful for President Biden's affirmation of Amtrak's rights as expressed in his July executive order, for the board's recognition of the importance of Amtrak's services, for the U.S. Department of Transportation's support as expressed in its filings, and for CSX's commitment to ensuring that Amtrak's existing and future services are not harmed by the proposed acquisition. I thank you for your time, and I'd be happy to answer any questions you may have.
Board members have any questions?
I just want to say, Dennis, good morning, and thank you for clarifying the on-time performance issue that CSX raised yesterday. I was a little bit surprised as well in that description. With respect to the Berkshire Flyer and the additional track that's being requested by CSX, what do you think is the explanation behind it, or what do you think the reasoning is behind that?
Well, I mean, we really need to get into it and understand. I mean, we think that we really ought to be able to operate. Particularly, we're only talking about 2 trips per week and only seasonally. That we should be able to operate without causing any issues and problems. So we'll discuss that with CSX and really kind of understand from their perspective why they think that's required.
And how many trains pass through Pittsfield on a normal day, Amtrak trains?
Amtrak trains, we would really just be our Lakeshore Limited, so one each way.
Okay, and so they haven't required them to have a 1,900 foot track for the Lakeshore Limited?
We have not needed an extra station track there.
Okay, all right, thank you.
Thank you.
Marty, you're muted.
Do you understand what the logistical explanation is from CSX, why they want you to build another track?
We haven't had the conversation with them to really get into the details. So.
Okay, Karen, you had a question? You're muted.
Yes, Mr. Newman. One of the conditions that CSX appears to have agreed to is that they will commit to operate in good faith with Amtrak and other parties for the addition, expansion, or modification of existing intercity passenger rail services. Your Amtrak's vision for new service across the country, which it announced last year, includes new and additional service in Massachusetts along the line you currently operate from Albany to Boston, and some additional service up to Concord and then up to New Hampshire. Could you talk a little bit more about what specifically new services or additional services you were planning or contemplating in addition to what you have specifically discussed with respect to the Berkshire Flyer with CSX?
Well, thank you for the question. And the routes that we outlined in the Amtrak Connexus vision are the ones that we are looking to be able to expand to in the near future. So really all of those, the particular ones you just cited. So we are interested in establishing service between Boston and Concord, for instance. We're interested in expanding frequency on the Downeaster. We want to add service between Boston and Albany, as well as being able to add service kind of on the inland route that would connect Worcester to New York and Hartford to Boston, for instance. So each of those is one of the routes that we would like to be able to institute.
And would those be state-supported service or an extension of your intercity passenger lines?
Those would largely be state-supported service in almost each, probably in pretty much each case, those would be.
And have you had discussions with the Commonwealth about your plans?
We have been discussing with the Commonwealth, and we will be, we continue to have those discussions as their plans and develop, and then we coordinate with them so that we are really moving in sync.
And have you had any discussions about those plans with CSX?
We have made requests to CSX, but the detailed discussions we have really are to come.
Thank you.
Thank you.
Do you have a question, Patrick?
Yes, Marty, but go ahead.
No, go ahead. I'll wait till you finish.
Hey, thanks very much for being here, Dennis. Just a couple quick questions. First is, could you kind of sharpen your focus on what is the exact causal element, what is caused by the merger in terms of detriments to Amtrak? You document in the record some of your past experiences with CSX and their history in working with you. Are there other elements of the transaction that you feel would have a negative effect on passenger rail, and could you describe those a bit more fully?
Well, yes, thank you for the question. I mean, to the extent that there is then more, more traffic up on the routes that that we would be operating passenger trains over, that is then, could potentially have impact on the performance, the on-time performance of passenger trains. And so that is one of the concerns, and that's why one of the conditions that we had sought was that we would that there would not be detrimental impact on the performance of Amtrak trains along these lines. And then obviously we do have our concern about the our ability to obtain the access that that we need for expanding services on these lines as well.
Could you compare your relations with CSX compared to what you anticipate the outcomes to be in the absence of the transaction from a relationship standpoint?
We certainly are hopeful that we will be able to work cooperatively to CSX to make the kind of enhancements and improvements that we need. So from that standpoint, I mean, we look to work with them, before the transaction. We look to work with them after the transaction as well.
I guess what I'm asking is, in the absence of the transaction. So if you were to compare, what the likelihood is of, say, expanding service, et cetera, if CSX were not to step in, is it your contention that that likelihood would be higher?
I would, given our past experience, I would certainly have the concern that that it would be higher without the transaction than with. However, the conditions that we had asked include the requirement to work cooperatively with us in good faith to make those kinds of improvements.
You heard CSX yesterday hold up the Virginia example as instructive in terms of the possibilities of collaboration between Amtrak and CSX. Should we factor that example in evaluating kind of your history contention? That
is an example where there is going to be, there will result in increase in passenger service. Much of that transaction was between the Commonwealth and CSX. Amtrak was a participant with the Commonwealth in a transaction between us and them. And then, so just kind of switching to precedent, Amtrak in its brief cites a few different cases, and I'm wondering, Dennis, can you provide any example in a minor or significant transaction, which are the transactions subject to subsection D of 11324, and can you provide any examples where the agency has imposed a passenger rail condition? I could not cite that for you, but I could get back to you on that as I check with our team, Member Fuchs.
Okay. Has the board in the past indicated that the focus of subsection D might counsel against imposing a passenger rail condition?
I do not know. I'm sorry.
Does council? No. So, one of the things that stands out to me in some of our precedent is in the Metro DM&E case, which was also a significant transaction, the board indicated that the focus of subsection D, which is again what this transaction is subject to, the focus is competition, and use that as part of its rationale for denying a passenger rail condition. And there are other instances in these types of transactions where the board has declined to impose passenger rail conditions. And so I guess I'm sort of wondering the weight that we should give that precedent as well as how we should evaluate the underlying reasoning.
Well, I mean, I am not a lawyer, so I don't know that I'm qualified to comment on what weight the board should apply. I think that the conditions that we are asking for are in the public interest, and that the public interest of expanding passenger rail service and being able to bring the benefits of that passenger rail service and continue the benefits, the performance of delivering passengers on time, and making sure that is not harmed by the transaction. And I think there is more detail in our Amtrak filings with regard to our position.
And Marty, I got a couple quick follow-ups. If I appreciate your indulgence.
No, go ahead.
To what extent could some of these issues be resolved via Amtrak's existing contracts with CSX or contracts that would emerge after the transaction? We have contractual rights, but we have, and they certainly have some ability to get us the outcomes that we really need and seek. But it certainly has been the case that in the past, our contractual rights have been difficult to enforce, and so by themselves, they have not necessarily produced the improvements and outcomes. We always start with from the premise that we would want to work together and collaborate to be able to obtain improvements and benefits, but that has not always proven to be sufficient. And that's part of the reason for for instance, the FRA rulemaking on time performance metrics and standards. Well, I want to get to that, but another part that I'm sort of wondering about is the other aspect of the board's denial of passenger rail conditions in DM&E and Metra was that these issues could be worked out through existing contracts, and the board indicated great reluctance via mergers to insert itself into issues that were covered or partially covered by contracts. And that's in the subsection D context, but even more broadly in a subsection C, the major merger context, the board via its major merger rules, as well as a 95 case, indicated a great reluctance to adjudicate contract issues or things that could be worked out in contract in the context of a merger. And I guess I'm wondering whether or not you have any views on that precedent specifically.
I do not have a view on the precedent specifically. I do think we have discussion in our filings with regard to our views on the matter. I do think that the need for the both the current the future performance and the ability to expand passenger rail is as I said, in the public interest, and is a matter that I think is pertinent.
Last question from me is, I think, Dennis, you quite rightly identified that the board has other authorities in 24308, including, governing Amtrak's access rights and the board's ability to set reasonable terms and compensation. The board has the authority to order additional trains, which of course we are working on adjudicating right now between you and the CSX and NS. And the board has authority to enforce on-time performance via the FRA standards, which is what you specifically mentioned. So I guess in thinking about how the board has not typically pursued passenger rail conditions in these types of transactions, and against the backdrop of that the board's very broad authority over passenger rail across the country to make these types of judgments. I'm wondering whether or not you have any views as to whether or not these types of complex access issues and additional train issues, on-time performance issues, would be better resolved and the public interest would be better advanced if the board considered them more intensively with more evidence through those authorities as we are today.
Well, I mean, I do think that there is a benefit and there is a need for the board to be involved in such issues. We have had a history of having less success in moving forward with and obtaining the benefits and the rights that we have, and so.
But Dennis, sorry to jump in, but part of the issue there was that for a brief period of time, well, not so brief, the board's ability to enforce on-time performance was seen as enforcing an unconstitutional provision. That's no longer the case. You know, the DC Circuit fixed that in a way. And so now the board and the FRA has, finalized its rules, and so now the board does have the authority to address on-time performance issues. And we've long had the authority to address reasonable terms and compensation. And in fact, we have a case right now, as you know, between and CN. So, those cases involve a good bit of evidence where we can, evaluate things like what are the infrastructure needs, what are the effects on freight transportation, what should be the schedules, et cetera. And so I guess given that the board now has authority to address a number of the behaviors that you are concerned about in the record, I guess I'm wondering why it can't be properly addressed in those more robust contexts.
Well, I think those more robust contexts are helpful and appropriate, and I think to be able, though, to not end up in a situation where we must resort to that, I think can be more expeditious and really achieve the ends that were that are needed. I mean, the tools that you mentioned, the ability to have the board review and take action in the case of on-time performance is definitely something that we appreciate and think that is a very proper role for the board, and I would expect that would be something that we would see the board getting involved in. But
Dennis, do you think the board has enough evidence on the record to decide what infrastructure is appropriate here for expansion of service? What are the impacts on freight, et cetera? Do you think the record provides that type of evidence for the board to make a good decision on that front?
Well, I think I would leave it to the board to decide whether that is
what evidence is.
I think that from our standpoint, if we're talking about something specific like the Berkshire Flyer, where the condition for actually approving the Berkshire Flyer seems that it is there should be some evidence that is a problematic, that it could not be just
sorry, and I appreciate my colleagues' indulgence here, and I'll really wrap up my questions, but isn't it true though that the board precedent is that the proponents of a condition have the burden?
I believe that is well.
So isn't the burden on you to show that rather than the CS? Isn't the burden on you to advance that via evidence as opposed to CSX to prove a negative?
I think we do know that there are going to be, I mean, CSX has agreed to allow additional Norfolk Southern trains onto this route. And so we know that there will be impacts there. And so we certainly have some concern about what those impacts would be on our performance.
I appreciate it. And thank you, Dennis, for bearing with me. And thank you to my colleagues. And I just want to, I guess, close by saying that, I very much appreciate the importance of passenger rail within our national transportation system. So really appreciate you being here and for your remarks.
Thank you, Member Fuchs.
Karen, you're up.
Thank you. I've got kind of a follow-up question or point. The way you describe what you were asking for in terms of cooperating with Amtrak for expansion of intercity passenger rail service, you also say, including but not limited to service over the southern route, and this is important, and that CSX commits to sharing data with Amtrak, and that CSX cannot use traffic projections that differ from those provided in this proceeding. So I gather what this would imply is that if you wanted to expand service and CSX said, well, we can do that, but only if you put in X amount of infrastructure, that those discussions have to be based on the projections they're making today, not what it looks like at the time that you may be having these discussions, and if their traffic actually goes up well above what they're projecting today, that the import of this is that they couldn't make you pay for anything more than what would otherwise have been required to accommodate the projections that they are making in this proceeding. Do I have that correct? And do you understand that CSX understands that?
Well, I thank you for the question, Member Hedlund, and I don't know what CSX understands with regard to that. Our concern is that the projections, first of all, that there be transparency about what we're looking at on any given line, and appropriate sharing of data. But we are looking for consistency with what's being presented at this proceeding, with the kind of data that then we'd be looking at in the future, so that there is some connection with the views or the forecasts that are being presented now, and being represented now, with what the situation would then be represented to be when it comes time to hopefully add passenger trains.
All right, I'm a graduate of all the service outcomes agreements negotiated in connection with the air grants, so I have a pretty high degree of sensitivity of what those negotiations feel like.
Yes.
Thank you.
Thank you.
Were you done, Karen?
Yeah, I'm done. I'm done.
Yeah. Robert.
So Dennis, I want to get back to some of the following up on what Patrick said of the conditioning, because there are some on the board that believe that precedents and what was set in the past as it relates to subsection D and the authority of the board to set conditions is not limited to what was done in the past, and the courts have indicated so in previous and recent decisions. And so I want to ask you, you put forward those conditions to this transaction. State your reasoning as to why and why it's important to the transaction as to why these conditions needed to move forward.
Thank you, Vice Chairman Primus. we believe that it's important that these conditions exist, because they do help to ensure that the ability for passenger rail to be operated on time and with good performance, so that we can deliver to the traveling public and to our passengers, the promise of service that we aim to make, so that we can deliver them to their destinations on time. In addition, that we are able to make expansions and enhancements to passenger rail service, which provides mobility benefits and provides the also environmental benefits in the way of reduced emissions by taking cars off the road, and that we have seen both from in the past, our ability to be effective or be successful at being able to exercise and have our rights enforced has been a challenge, and also that we expect that there would be effects in terms of the volume of traffic on these routes that could have an impact on our ability and on the willingness of the host to move forward and make the appropriate improvements. So I think those are the reasons why we think that these conditions really are needed to be able to deliver those benefits. In addition, there has been significant public investment in existing infrastructure, and we think that past investment should be also protected.
And I think Patrick had mentioned also past relationships like the one in Virginia should be considered. Are there other relationships as well, maybe adverse, that we need to take into account as to how the relationship between freight and passenger rail existence, the operations, and its effect on the public interest?
Well, I mean, certainly the history of our attempts to add service, and I mean, as obviously there is another proceeding where we are looking to add service down on the Gulf Coast, and that has been a challenge that has led us to actually need to resort to the STB. That's one example. Generally, our moves to try to increase passenger rail service are met with resistance and difficulty. And for on-time performance, we certainly have had large challenges in being able to have our trains always get the appropriate preference that we have the rights to, and to be able to deliver our customers on time, and being able to make really kind of compel the performance that's necessary. Our long distance trains, our customer on time performance is hovers around 50% or less. So half of our passengers are not able to get to their destinations on time. So we certainly have seen a significant amount of adverse experience, both with on-time performance and with our ability to obtain access under reasonable conditions.
So you're saying that the conditions that you proposed were not just specific to Amtrak, but to the public interest and the health of that rail network in that affected region.
Yes.
And so, do you think that it is the job of the board to address that public interest region, that public interest concern, through any act that they're able to, including conditions, to bring about a balance and fairness to that transaction and to the network.
I do. I think that it is an appropriate consideration for the board to take into account.
Okay. Do you think it's within our power to do so?
I will leave it to the board to decide that. Again, I'm not a lawyer, but I believe so.
No, I believe so too, and I believe it. Though we've had cases in the past, and former boards have decided that, I think we still have the flexibility and we have the discretion to do that moving forward. And so, I appreciate you bringing those concerns up, because I think it is important to the success of the of this proposed merger. Thank you.
Thank you.
Dennis, I just want to be clear on the record as to what's agreed and what's not agreed. The filing we received on Wednesday says that CSX agrees to conditions 1 through 5 and 7 as they relate to PAR. So are you and CAX in agreement, at least as far as that goes?
Well,
I'm trying to dissect this. I want to know what's agreed to and what isn't agreed to.
Yes. Well, really our knowledge of what's agreed to is the letter that was sent to the board. So.
You mean this came without a discussion with you before they sent it?
Yes.
Well, you read the letter. So at least in terms of what Amtrak is seeking as regards the PAR system, it sounds like at least 1 through 5 and 7, you got what you asked for. As you understand it?
I think that yes, that is why I had said we were very gratified by CSX's letter and to the board.
There's agreement on that. What you're saying is you asked for those conditions to apply to PAS as well. And
Yes,
that they have not committed to, as far as you can tell.
Correct. And that is really still a question for us is why there's a carve out.
And as to condition 6 relating to the Berkshire Flyer, but for the condition of their precondition of 1,000-foot track, would that be acceptable to you, the 1-year experiment?
Yeah, that would be, that's why we hope to be able to work that out. But yes, being able to move forward, again, in consultation with Massachusetts Department of Transportation. But that is our aim is we were very, we were very hopeful in what we saw from CSX in that regard. So I think there's some detail for us to work out, but we think that there's some good forward movement there.
All right. So going forward, do you have any discussions or interactions planned with CSX to iron out what's not agreed to at this point?
That is our intention. So,
well, it's our preference. There have been a lot of agreements made by various parties to this proceeding to work out differences and to agree to conditions. A whole slew of them have come in over the last 2 or 3 weeks, including this one, as far as it goes. So I'm going to encourage you, and I am sure that our CSX friends are listening in, and we're going to talk to them later today, to get in a room and work this out. We would much prefer this all be done by agreement. I think wherever board members are coming from, I think we all agree that it is better if the parties work these conditions out by agreement. So I'm going to encourage, and I am sure that my friend Jim Foote is listening, that as soon as possible and before this record closes, you iron these things out. Otherwise, we'll have to act one way or the other.
Thank you. Yes.
Any other, are there any other questions for Dennis? Dennis, why don't you sit tight because you're on the same panel with the next two speakers, and so there may be some interaction there. You're still on, although you can turn your mic off if you want. With that, I'm going to call.
Thank you, Chairman Oberman. Thank
Yeah.
you. Thank you, all board members.
Thank you, Dennis.
Thank
I'm
you.
going to call up Mr. Robert Wimbish.
Good morning. Before I go into my presentation, want to make sure that I'm being seen and heard. I know there were some technical issues that way yesterday.
Yeah, right now I can see you fine.
Okay,
And
great.
I am going to absent myself for about 2 minutes. I'm going to hand the gavel over to Robert while you're speaking, but I will be back momentarily. But in case something needs to be done, Robert, you're in charge.
Well, all right.
That sounds like trouble.
Your job is to avoid trouble.
Well, I don't aim to start any. I suppose, good morning, Chairman Oberman, as you depart, Vice Chairman Primus, Commissioners Fuchs, Schultz, and also welcome to the Surface Transportation Board, Commissioner Headland. My name is Rob Wimbish. I'm with the law firm of Fletcher and Sipple in Chicago. Now, I am participating in today's hearing on behalf of the Commonwealth of Massachusetts Department of Transportation, or MassDOT, and MassDOT's concurrently supervised agency, the Massachusetts Bay Transportation Authority, which is also referred to in this presentation as MBTA. This is also known simply as the T. For purposes of today's presentation, I will refer to MassDOT and MBTA collectively as the Commonwealth. MassDOT oversees highways, rail and transit, aeronautics, and transportation licensing and registration for the Commonwealth of Massachusetts. Its mission is to deliver excellent customer service to people traveling in and throughout Massachusetts by providing safe, reliable, robust, and resilient transportation infrastructure. MassDOT works to provide a transportation system which can strengthen the state's economy and improve the quality of life for all. MassDOT, owns various railroad lines in Massachusetts which support passenger and freight railroad service. MBTA is one of the oldest public transit systems in the United States. It is also the largest transit system in Massachusetts. MBTA provides subway, bus, commuter rail, ferry, and paratransit service to eastern Massachusetts and parts of Rhode Island. As this record reflects, MBTA also owns various railroad lines in Massachusetts over which commuter rail service and, in many cases, also railroad freight service is provided. Given the extent of the proposed railroad transactions within the borders of Massachusetts, it is no surprise that the Commonwealth would be very interested in the proposed railroad consolidation and its impact on all railroad transportation services. It would be easy but unwise to focus strictly upon the freight transportation elements of the transactions, as those transactions' respective freight service impacts have been presented here by CSX Transportation, Norfolk Southern Railway Company, Pittsburgh and Shawmut Railroad, also known as Berkshire and Eastern, and all others allied with those railroads. Rather, for reasons I will offer in this presentation, the Commonwealth urges this board also to consider very carefully how the various interrelated railroad transactions that are the subject of these proceedings bear first upon the Commonwealth's extensive railroad transportation infrastructure holdings, also upon publicly provided commuter rail service in the greater Boston area, and finally upon publicly supported intercity railroad passenger service in Massachusetts and throughout New England. The interrelated transactions presented for your consideration, approval, and conditioning authority offer opportunities for private freight service and for public stakeholders interested in such freight service, to be sure. But the Commonwealth respectfully submits that the public interest is unlikely to be fully or adequately advanced or protected, for that matter, absent appropriate public-private measures, or in the absence of such voluntary measures, the board's exercise of its conditioning authority as requested by the Commonwealth in its past filings. To be clear, however, the Commonwealth has not opposed the transactions that are encompassed by the various filings in this docket, and it does not oppose them now. Those transactions stand to deliver important transportation benefits for certain shippers and traffic flows, and they stand to benefit the applicants and those carriers allied with them here. But those same transactions warrant that the applicants ensure, and not just generally assure, that the hundreds of miles of Commonwealth-owned railroad infrastructure that the applicants and allied carriers will operate are currently in proper physical condition, and that they will be maintained accordingly going forward. The applicants must also ensure that the proposed transactions will not result in deteriorated MBTA commuter rail service, where the applicants and allied carriers will share track with MBTA commuter trains, particularly in the face of future operating uncertainties and anticipated freight and commuter rail traffic growth. And the applicants must ensure that the proposed transactions not merely sustain an intercity railroad passenger service status quo, but rather facilitate and promote Amtrak services in New England. It appears from very recent developments that at least some of our conditions targeting intercity passenger rail service have been addressed, and I will address that briefly in the discussion following. The conditions that the Commonwealth has requested that this board impose as part of its approval of the transactions will ensure that the public generally, and not just the freight shipping public, will see the benefits of a stronger and more engaged Class I railroad presence in Massachusetts and throughout the region served today by CSX and Pan Am Railways. Those conditions are carefully designed to maintain the Commonwealth's extensive railroad infrastructure holdings, protect MBTA's innovative and growing commuter rail operations over the lines that are the subject of these proceedings, and to the extent that they may remain necessary, enhance intercity, that is, Amtrak, passenger rail service options while preserving the freight transportation benefits that CSX and others engaged in these proposed transactions hope to deliver. The Commonwealth has been engaged in an ongoing dialogue with the applicants, particularly CSX, toward a written accord on the Commonwealth's three general objectives. That dialogue has been positive, and indeed we are seeing substantial progress toward key Commonwealth objectives, particularly with respect to the applicant's commitment to expanding Amtrak service in keeping with regional and Commonwealth plans. For example, CSX recently has advised the board, as the board is aware, that it has reached an accord with Amtrak, accommodating Amtrak's requested conditions, including that it will agree conditionally to host a new Amtrak pilot service, the seasonal Berkshire Flyer between New York City and Pittsfield, Massachusetts. We are encouraged by such recent positive developments. We acknowledge the recent CSX Amtrak agreement, and we are actively reviewing that very agreement. And we are hopeful that this recently announced agreement and corresponding CSX filing from late yesterday adequately address our concerns and interests in post-transactions intercity rail passenger service. Discussions with respect to the condition and upkeep of Commonwealth-owned railroad infrastructure currently maintained and operated over per agreements by Pan Am Railways and Pan Am Southern have also been constructive. But these discussions have fallen short of the Commonwealth's proactive objectives. Specifically, the Commonwealth has urged a post-transactions assessment of Commonwealth-owned railroad infrastructure currently operated by Pan Am Railways and Pan Am Southern. As a proactive joint undertaking embodied in the Commonwealth's third enumerated condition, would be a constructive and beneficial first step in CSXT's expanded relationship with the Commonwealth and its various stakeholders. Indeed, the applicants have not impressed upon the Commonwealth that its proposal is overly burdensome or unfair, but rather that, in the applicant's view, such an infrastructure review is unnecessary given their promises and assurances on the record. Because such an infrastructure review would benefit all involved, however, the Commonwealth looks to this board to facilitate such an exercise by way of its conditioning power if needed. Finally, but easily as important as the infrastructure upkeep and intercity passenger service issues addressed previously, if not more so, the Commonwealth urges this board to consider appropriate conditions to protect MBTA's extensive commuter rail services, where such services would share tracks with freight trains operated in the future by CSXT, Norfolk Southern, or Berkshire and Eastern, or all three, as would be the case on the Willows to Ayer track segment, also traversed by MBTA's Fitchburg line service. We are told that the proposed transactions will benefit MBTA commuter service. That is a welcome assurance, but we have seen no proof that this will be necessarily so. And we have been assured that CSX's expanded freight operations and those of Norfolk Southern and Berkshire and Eastern also will not impair MBTA commuter rail operations. But those assurances conflict with MBTA's extensive knowledge of the railroad lines involved and the challenges associated with balancing freight and commuter rail service needs. And while we recognize that CSXT has experience in operating in commuter rail territories elsewhere and on a more limited scale presently in the MBTA service area, CSXT has not yet learned the intricacies and challenges of the railroad lines over which it will operate following implementation of the proposed transactions. The Commonwealth has proposed here, again, a proactive mechanism for dealing with potential commuter rail service harm, both by shifting train dispatching and by developing contingent infrastructure enhancement in the face of future disruption, should it occur. The applicants have thus far resisted such proposals on assurances that no such harms will befall MBTA commuter rail service. On that topic, we do appreciate CSXT's particular efforts to demonstrate to the Commonwealth why it believes MBTA service will not suffer from freight train service delays. Those meetings have proven helpful, but they have also revealed CSXT's incomplete understanding of the complexities of operations, for example, on the Willows to Ayer segment. And so, while the Commonwealth appreciates the assurances that the applicants have extended, those assurances by themselves serve little purpose if and when post-transactions freight train operations do begin to interfere with MBTA commuter trains. This board and the Commonwealth know very well that Class 1 optimism is no substitute for well-conditioned contingency plans, particularly where such contingency planning would include expanded infrastructure. In that regard, the Commonwealth's requested conditions to protect MBTA service, including transferring dispatching to MBTA, as set forth in enumerated conditions 1 and 2, are a far better measure than would be a reopening of this proceeding, under which this board could be called upon to ascertain what has gone wrong, what to do about it, and how quickly appropriate corrective measures can be implemented. And here also, the Commonwealth's requested conditions, which undeniably protect the public interest, are neither intrusive nor unduly burdensome. They would not stand in the way for the freight service benefits that the applicants and the railroads allied with them hope to deliver. Rather, we believe that such conditions would be the logical next step in the Commonwealth's dialogue with CSXT in particular. To be clear once again, the Commonwealth does not oppose the application or the related transactions, but the Commonwealth also recognizes that the proposed transactions, as currently structured and without appropriate protective measures, threaten distinct elements of the public interest, particularly, for example, elements of the public interest as spelled out in President Biden's executive order number 14036. We appreciate in particular CSXT's engagement and ongoing dialogue with the Commonwealth although such an engagement is also to be expected given CSXT's anticipated expanded regional footprint. But the Commonwealth respectfully submits that this board can and should use its conditioning authority to assist in bridging current gaps in this dialogue, as described previously, by directing CSXT to work with the Commonwealth to engage in more proactive measures, rather than falling back entirely upon confident freight railroad assurances of future events and circumstances. The Commonwealth appreciates the board's time and consideration of the Commonwealth's comments and requests for conditions. Thank you.
Thanks, Robert. I appreciate it. Marty's back, so there you go.
I am back, but Robert, I assume you have some questions, so go ahead.
No, I'll wait.
All right.
As someone else has. Happy to wait.
Anybody else want to go forward?
Marty, why don't you go?
Well, all I would say, Robert, is what I said to Dennis, that we'd like these conditions worked out. It sounds like progress has been made from your point of view as well, but you're not quite there yet. Is that a fair statement?
I think it's a very fair statement. I think we've remained engaged even to this moment in a dialogue with CSX, and we've continued to make progress. We're hopeful that in the not too distant future, you will receive yet another filing from CSX that indicates that we have resolved our differences. We have not yet done that. Obviously, one of the reasons is that on a number of these issues, CSXT remains confident that some sort of a definitive written agreement is not needed. But I do think that there is still a pathway to reaching an accord.
Well, I will just reiterate that I always think the parties are better off if they write things out themselves rather than requiring us to write them for you because you may not like it.
Right, and we're not asking you, to be clear, in our conditions, we haven't asked you to specifically write out what those agreements contain, but some of them are simply asking for the board to facilitate working toward an agreement.
I think that listen, there's obviously, and you can hear it in the questioning here, some discussion and debate about the propriety of our entering in conditions on a transaction of this nature relating to passenger. There are obviously public interest aspects to it, as has been discussed. There are other precedents as raised by Patrick, and we're not afraid, I think, as an institution to weigh into this area one way or the other. But if things can be worked out by agreement, then we don't have to weigh in. So I think we'd all much prefer that happen. But let me switch it to Patrick, who had a question.
Thanks so much, Marty. Actually, set aside this standard issue for a minute. Could you summarize the evidence in the record that would allow the board to make an informed decision about whether or not a shift in dispatching responsibilities would lead to overall better outcomes for the rail network, freight and passenger?
I think there's probably two elements of that. The first one is the evidence that you have on the record that CSX typically dispatches its lines from Jacksonville, although it has committed here for, as I think the term was, the indefinite future, to continue to dispatch these lines in Billerica. I think that's one piece of the evidence there. I think the other piece of evidence that is implicit in this is that, and there's another piece of evidence here, which is that MBTA is a predominant user in terms of the number of trains operated over a variety of these lines. Even though CSX in some limited instances expects to see some freight traffic increases that potentially over time could increase the amount of train activity on these lines, one of the issues that's implicit in the record here is whether or not CSX or the Commonwealth would be the better administrator of the overall public interest in these if you look at how both of those entities would possibly make decisions with respect to dispatching and accommodating each other's trains.
So one is the geographic location of the dispatching, and the other is sort of an intuitive assessment.
Well, I think part of it is more than intuitive. That is that the record also reflects, as it has and as we've pointed out, and as others have noted, that MBTA is the predominant user of most of these lines on a train count basis.
Are there other instances where dispatching in the general Northeast region is conducted by an entity that is not the predominant user?
I'm sorry, could you repeat the question, please?
Are there other instances, or to what extent is dispatching in the region for passenger rail in particular conducted by entities that say don't have the highest train counts? Thinking in particularly of Amtrak, right? Amtrak, is it correct to say, and maybe Dennis, you can weigh in, that Amtrak has dispatching responsibilities on some lines where it doesn't have the highest train count?
I do not know, Commissioner.
That is true. We do have, it's train lines that we own.
So I guess I'm sort of wondering whether or not it would have been appropriate for MBTA to submit some sort of hard evidence that train count share improves dispatching performance for all users. You know, you have the Amtrak example where Amtrak is not the predominant user and has dispatching responsibilities, and you could potentially compare that to commuter rail performance with dispatching. You could also, provide evidence of other freight railroads, CSX included, and their dispatching performances for all users versus dispatching of the predominant user. And I guess one of the things that I totally hear you on the intuitive or implicit nature of the claim, but none of the actual hard evidence about what's going on in the rail network was presented in the record, including on some lines that MBTA is using. Is that a fair assessment? So you didn't, for example, look at any other lines where you're the majority user and someone else dispatches and provide any evidence about what's going on those lines?
No, we did not. And our argument is largely predicated on the policy considerations that I think, again, are pretty well understood in this particular case, that you can compare the approach to CSX dispatching to the approach to MBTA dispatching. And one of the things that I suspect you know is that MBTA does dispatch operations on other lines, whether or not those contain freight operations on them. But one of the distinctions is, of course, if you have CSX dispatching those lines, and I don't mean that there's any nefarious considerations here, just in terms of the priority analysis on this one, while we've had good experiences with CSX is clearly, its mandate is to maintain a fluid freight transportation system, first and foremost. Doesn't have a specific mandate. It may have some obligations under contract to accommodate MBTA commuter rail service. By comparison, if you consider MBTA dispatching, MBTA would be looking at all of the stakeholders involved. That is the fluidity of freight transportation and passenger transportation on those lines. And so I think that there is a more kind of holistic take on what MBTA would be looking at and how it could best balance those competing interests here.
I appreciate the kind of the implicit point for sure, Robert, and I appreciate you making it. Would you, I asked Dennis this earlier, but you'd agree that board precedent sets out that parties requesting conditions have the burden to show they're necessary?
I do agree with that.
And in terms of the policy considerations, do you think that the board do you think that the implicit or intuitive argument is sufficient for the board to have confidence that you've met your burden, that dispatching under MBTA would be better than under CSX when you've provided no data about dispatching performance?
I do.
I can switch gears then to the standard. Robert, can you give your assessment of how the DM&E Metro precedent should factor into our decision making? The way I read that case is that the board denied the requested conditions by Metro Commuter Railroad for two reasons. One is the focus of D is competition, and the other being that the issues could potentially be worked out by contract. And CSX contends in the record that it's stepping into existing contractual relationships. So is it appropriate for the board to look to that precedent to guide its decision-making in this area?
I think it's appropriate for the board to look at all of its precedent, not just the CPD-M&E case. There's kind of a couple of elements to your question here, Commissioner Fuchs, and I want to take them both on separately. Let me start with the 11324D discussion, because I know it's been one that's been a recurring issue for you, and I understand and appreciate that. And I want to point out that that my perspective on 11324D is that while it is the standard for approval, it is not necessarily the only basis for the board's conditioning authority in Surface Transportation Board proceedings in minor or significant transactions. And in fact, there's other precedent I'll point out just briefly that supports that proposition. So let's start with D, and then we can talk about the precedent if you'd like with respect to CPD-M&E, what I think it stands for, because I think they kind of correlate to each other and of course have the connection. The first one is, and let's just take a look at it this way. If, as I think you may have generally posited, I don't want to put any words in your mouth, but if, as I understand it, you're suggesting that 11324D says the only thing that the Surface Transportation Board can look at in a minor or significant transaction are competitive impacts, and make a determination as to whether or not the board should approve a transaction based on that competitive impacts analysis. I'd submit to you that when you're looking at commuter rail or passenger rail impacts, which obviously are not central to or even directly involved in that competition analysis, excuse me, that if you do that, that the logical extension of that here would be, and I know these are not the facts, but I think you have to think about what the logical extension of that kind of a strict application of this is the only thing that matters. If, and I'm not saying you're suggesting that's the case either, but if you were, then it seems to me that under the circumstances here, if we were to change the hypothetical a bit, you'd be looking at a situation under a hypothetical, or perhaps, and thank goodness they're not doing this, CSX would say, here's our transaction, it's pro-competitive, it yields a bunch of public benefits, particularly in the transportation world, and it is highly pro-competitive. Now that said, this same transaction will have definitive and clear adverse impacts on passenger transportation throughout the Commonwealth. Again, I know this is the hypothetical. And by the way, there is nothing you can do about it, board. Nothing you can do about it, because 11324D is the only element of the standard, and it is your only conditioning authority here. So it seems to me there's a danger in that. Now that's just sort of the logical element of that. But the other part of it, it seems to me, is that the congressional mandate in 11324D is about focusing on the the competition issues in those transactions, not to the exclusion of other STB conditioning authority, because we know, and this is where I'll transition into your discussion of the CPD-M&E, and I had listened to you and I agree with you that that case, number one, was determined on its facts and circumstances, and I don't read that case as being a categorical determination that passenger train impacts are simply unavailable, cannot be mitigated under appropriate circumstances. It was a reluctance to get into those, and the fallback there, of course, was to resort to contracts where those contracts existed. And indeed, those contracts do exist in that particular case between Metra and the merger applicants there, particularly CP. So that's one of the things I point out. Finally, if you're going to point to the CPD-M&E case, it seems to me you also have to look at the CN-EJ&E case. And if you remember, in that particular case, one of the issues that was litigated was the board's imposition of conditions on overpasses. You're probably familiar with that. The argument in that case on appeal was whether or not the board had the authority, again, under the assertion that 11324D controlled, whether the board had authority to impose overpass conditions since they had nothing to do with mitigating any competitive impacts. And the court upheld the Surface Transportation Board's authority to impose those conditions in that particular case to address transportation issues that were not tied to freight competition. So I'm hoping that I'm just giving you my perspective for, number one, the dangers of focusing exclusively on 11.324D under hypotheticals where there would be clear and demonstrable adverse impact, and saying you can't do anything about it. And the notion that the STB's precedent, and for that matter, Court of Appeals precedent, supports the proposition that the board's reach of its mitigation conditions, or its conditioning power, goes beyond the limited scope 11.324D.
Robert, thank you very much for that discussion. I think for the efficiency of the hearing, it might make sense to revisit the standard issue after CP's testimony, if you'll hang on, and that way we can kind of, because I think some of the issues that we would discuss would apply to both of you, and so we can maybe have a discussion in that regard. I will observe that I think that you've described the countervailing precedent and the countervailing points accurately. I think that Metris said that the primary focus is competition. It did not make a clear categorical statement ruling out passenger rail conditions. I think it could be read to be a bit of a non sequitur if it doesn't suggest that, but
right.
It's not clear and explicit. And I do agree that the Village of Barrington, in the context of the DC Circuit, in the context of environmental conditions, suggested the board had public interest authority that wasn't constrained by the approval standard. So I want to continue this discussion, but I think you've accurately stated the precedent.
I appreciate that.
But so do I, Robert, for what it's worth. So I think it is very helpful. This is a subject of which is board considered in recent times very intensely, and it's an ongoing consideration. Any other questions for Mr. Wimbush?
I don't now.
Okay.
He satisfied them, and I appreciate his comments, and I actually join you, Marty, in agreeing with his assessment. So thank you.
All right. Why don't we move forward to CP and Mr. Clements and Mr. Meyer. And the other two panelists, as Patrick suggested, stay on board with us.
Good morning, Chairman Overman. Good morning, fellow commissioners. This is David Meyer. I don't see James Clements yet. I don't know if he's on. James, could you?
Yes, I've joined Mr. Meyer.
Thank you. Okay, excellent. Well, I'm going to attempt to share my screen for the PowerPoint presentation that we have to accompany our remarks. So bear with me for a moment. Can everyone see that? Is the Canadian Pacific presentation visible?
Yes.
Excellent. James, I'm going to turn it over to you to begin our presentation.
Yes, thank you, David. And thank you, Mr. Chair and fellow STB members, for giving us the opportunity to make a few brief remarks this morning. I'm James Clements, the Senior Vice President of Strategic Planning and Technology Transformation at CP. I've been with CP for about 27 years in a variety of roles, including car management, finance, marketing and sales, and corporate strategy type roles. If I go to the next page here, David, what I just want to mention to start the presentation is that we see the Pan Am Southern as an important link for CP to access the New England markets in the Boston area, the Pan Am Railway, and also other short line connections in New England, like the Providence and Worcester and the New England Central. In that corridor, we handle several thousand carloads a year in what I would describe as a normalized non-COVID year. We've certainly seen a little bit of decline as a result of changing traffic patterns in the last couple of years. And we use the Pan Am Southern as a critical connection, and we see it as a competitive alternative in the market versus the CSX route into many of those same markets. One comment I will make, we have, and this was in some of our evidence looked at alternatives in terms of we could go, as this map shows, over the top to Bangor and North Main Junction interchange with Pan Am Railway and have that traffic move south. That is a very circuitous route. There's also a couple of options involving the Vermont Railway or potentially even other G&W lines where we would connect in Sherbrooke, Quebec. And again, there's either weight limitations or route inefficiency concerns that we think would make those very limited viability in terms of competitive alternative into the market. So David, if you move to the next slide, this shows why we see this one as such a critical connection and is directly parallel to the CSX, what is called the southern route in our evidence. Before I go into too much more detail on Pan Am Southern, I just want to make the observation that the Pan Am Railway portion of this transaction, we have not sought any conditions, we haven't raised any concerns. We certainly expect, as Jamie Boychuk and others observed yesterday, that in Maine and into St. John and other areas, this end-to-end combination with the CSX route will certainly be a competitor for us up in that area. And we believe that the CSX is, when they invest and operate it, they're a good operator, and there'll be some benefits around the Pan Am Railway transaction. So we have no concerns, comments, or anything to put on the record relative to that. All of our comments here are going to be around the Pan Am Southern, and what we see as a potential to change the competitive dynamic east-west between our connection and New England and Boston markets. The Pan Am Southern today, as you've heard, is a route that goes across into Boston. It connects with CP and Norfolk Southern at Mechanicville, also the CSX at Rotterdam Junction. And it's been described as a good grades and efficient route. The CSX themselves certainly described that there are some operational advantages to that route for traffic into the New England area. It also today is a viable and productive intermodal and automotive route into Boston and via air, and has a service level associated with that meets the needs of all the shippers in the market. And certainly the owners today have the incentive to invest. We can see that with the effort that was made to repair the Hoosac Tunnel after the partial collapse that occurred a couple years ago. And so with all of this is what positions it effectively as a competitive alternative to the CSX in the market. Now, David, next slide. When we look at it, and I want to talk a little bit about history, the reason that the joint venture was formed and why NS engaged with Pan Am Railway to create the Pan Am Southern was specifically to create and strengthen the ability for the NS and other shippers to compete against the CSX into the Boston market. And in particular, and I think Mr. Mullins yesterday acknowledged this, one of the focuses was intermodal and automotive. As you can see in their statements, there's $87.5 million that was flowing to both enhancements to the corridor itself, as well as the creation of facilities at Mechanicville and air to handle automotive and intermodal traffic that was being made by the joint venture. And so, one of the concerns as you look forward is that this traffic, the very traffic that was designed to attract this capital investment, is being moved off of the line. I know that it's been alleged that it's low margin, but it is the traffic that had incented the recapitalization of the line. So that I just wanted to go through that. Now, when we start to talk about the change so that we've got this good competitive line, and you start to look at what the incentives are today and where the incentives are going, I think it's undeniable that the incentives that the new ownership structure has are different than the incentives that today Pan Am Railway and Norfolk Southern have. The first one is that, and most importantly, the CSX is becoming half owner. You almost have like a 2 to 1.5 kind of combination here, and CSX is going to have considerable power in the boardroom now as a result of that change. And I want to comment a little bit. The analogy was made around Conrail, and that the CSX and the NS have been able to compete effectively as a result of the Conrail shared asset areas that were created in that carve-up transaction. And I think it's important to note that transaction was almost the reverse of what we're contemplating here. Conrail was a single carrier that had, their operations in many of these areas with very limited competition. And by creating the shared asset areas, you are actually introducing a competitive alternative that never existed as prior to the transaction that was being proposed. In this one, what's happening is there are two competitors, and in fact, you're reducing the competition. And what's being said is that we can do it in Conrail, and by having the same structure here, it's going to help mitigate the impacts here. And I just don't see necessarily the parallel to Conrail when you're looking at the current situation that we have today on the left-hand side of this slide. The other piece I did note already is that Pan Am hosts premium intermodal and automotive service today. And when you're maintaining the line to have the speed and lack of slow orders and efficiency across the line for the intermodal service, you sort of by nature lift the quality of infrastructure so you can provide a better service on all of the manifest traffic. And undoubtedly the traffic that we interchange to Pan Am is entirely what I would call manifest carload, boxcar type traffic. But you're now removing that traffic. So the incentive to maintain it up to the highest standards to serve the most service sensitive traffic then is gone, which can have a longer term impact on the level of investment to maintain the manifest service in the area. Again, what we have here, we talk about the Pan Am subsidiary is competing with CSX, and now you're putting the CSX in, and they have come up with this solution with the Berkshire and Eastern. And you know what, I would agree with everybody's observation. Genesee and Wyoming is a quality operator, has done a great job across many of their properties. But I will observe that they are the, let's call it, dominant alternative operator in the New England area with the New England Central, Providence, and Worcester, and many of their holdings. And then today, Pan Am Railway interlines with both CSX and PAS. We agree that the new single line route will attract traffic. And in fact, the CSX has made a commitment that some of that traffic they will route over Pan Am Railway or Pan Am Southern in the short term as one of their undertakings to compensate for the change in traffic flows with the removal of the intermodal. Again, that's a temporary flow. We think the incentive is to use the efficient single line route that CSX is creating for much of that PAR traffic, and that as your commitment expires, that may well change the traffic flows. We provided some analysis on what we think the change in gross ton miles are, both as a result of the intermodal and in the longer term with the expiry of the CSX commitment. So again, that is also another factor that changes incentives in terms of how the Pan Am Southern is operated. Slide 6, please, David. When we start talking about competition, this isn't just anecdotes from CP and not supported. The participants themselves, the CSX, filed directly an acknowledgement that in the absence of any conditions, that the impact of this transaction could have harm on the competitive environment, and that they created a series of agreements to try and mitigate that risk of harm. And really what is at issue, and we will get into our commitments at the end of my remarks, is whether those undertakings are sufficient to protect from the competitive harm. And I want to acknowledge that many of these undertakings are short-term. There's I think it's a redacted, I don't know the number of years in some of these commitments. And I think it was Jamie Boychuk in the discussion yesterday around the business case. And the acknowledgement was, this isn't about the first 5 years. This is a 50 or 100-year transaction, and that there's going to be a long-term view that is being taken by the acquirer. And so when we look at the commitments, one of the concerns is the term as it affects this the gateway that we interchange with in the context of a transaction structure being proposed is contemplated to be 50 or 100 years. In terms of the evidence, David, next page, I'll skim through this one fairly quickly. The Department of Justice has also said this arrangement is likely to diminish competition between CSX and Pan Am Southern on these parallel routes. So again, we're not the only ones, we're not making this up. On the DOJ, I just want to be very clear. We are not supportive of the idea of divestiture. We're not advocating for the idea of divestiture. When we look at the conditioning powers that the board has, we believe that there are appropriate conditions that can be put on this transaction in order to allow the public benefits on things like the double stack competitive service that the NS will get into Boston, or the single line CSX route into Maine and other parts of New England that are good for this as a result of this transaction. And the replacement from what we've heard of the parent Pan Am may also have some benefits. So what we're seeking is the board to use their conditioning powers to effectively protect the competitive alternatives in the market for carriers like CP and the shippers. David, I'm going to hand over the next few slides to you to continue the discussion on 11.324 and other aspects of the board's mandate. You're muted.
Can you hear me now? Okay, thank you, James. There's been a lot of discussion in the past 2 days about the legal standard applicable here to the board's review of this transaction. And I'll be brief. Perhaps we'll have a discussion of this in more detail. We think that under 11324D, which is the governing provision for the control transaction here, that the board does have authority to impose conditions designed to avoid significant competitive harm from the transaction. There are two parts, as Commissioner Fuchs observed yesterday. There are two parts to this. One is the question of whether there is a competitive harm to be avoided, and we can talk about that in more detail. James, I think, has addressed it well. The second part is whether, if there's competitive harm, can conditions be imposed, notwithstanding that if one tallied up the aggregate competitive benefits from the transaction and weighed them against the aggregate competitive harm of an unconditioned transaction, would the balance tip towards net harm? And we think the board has resolved that question in its interpretation of the statute in the Messina Line case. And we also think there's a reasonable interpretation of the statute from the Messina Line case that would allow for conditions under those circumstances. Here, there is clearly in 11.324D a focus on avoiding or on competitive consequences of the transaction, our request for conditions and our examination of the consequences of the transaction, if unconditioned, is very much in line with that focus on competition. So we're operating within the target zone of Section D. And if you look at the board's powers in a significant transaction, it's also clear from the statute, not in the D2 language, but in the first part of D, that the board does have authority, just as in any case, to condition a transaction. And it makes eminent sense in a case like this one to find that there's a harm and to eliminate that harm if the conditions that eliminate that harm do not also eliminate the pro-competitive benefits of the transaction. And here the conditions that we're proposing do no harm, do not diminish in any way the ability for applicants to carry out the parts of the transaction that they have pointed to that have public benefits, as James has outlined. Now, there was discussion about how the language in 11324D tracks the Clayton Act yesterday. And I think that's a very astute observation. I have an antitrust background in my career, including service at the antitrust division as the chief civil enforcement official. And so I have a lot of knowledge of how the Clayton Section 7 standard works and is intended to work in merger cases. And I think the approach to examination of competitive harm that I've just discussed is very much in line with how the Clayton Act would be applied in a merger outside of the railroad industry. In that kind of context, were there a transaction that was offered by the proponents to be net pro-competitive? An example is, say, two grocery store chains proposing to combine, where there are 100 stores being combined across some region of the country. There may be tremendous net benefits to that transaction, but in a couple of markets, 2, 3, 4, 5, it may be that the stores overlap very directly and there are very few other competitors in that local market. The way in which the Federal Trade Commission or the Department of Justice would approach that transaction would be to seek either divestitures or other relief with respect to those specific overlaps in specific markets, in other words, fix those harms and let the balance of the transaction go forward. That kind of approach happens every year in numerous transactions. It's how Section 7 would be applied. And I think that's the appropriate lens through which to examine a transaction such as this one, where there are harms, likely and substantial harms. And again, we can talk about that if you wish, that can be eliminated with conditions that do not prevent the benefits of the transaction from being implemented. There is, in addition, I think, in this transaction, an additional basis for conditions. It's an issue that hasn't been discussed in the papers or the briefing to date. So it occurred to me as I was reading the briefs of the applicants and thinking back to the Pan Am Southern Formation case. In that case, the applicants sought not just approval under 11324 or 11323, excuse me, but also approval of under the pooling statute. And the reason they sought that approval was because by putting Pan Am Railway and Norfolk Southern into this joint control relationship and then appointing Springfield Terminal to operate and earn the revenues and then split the revenues that were earned from the traffic on the line between Norfolk Southern and Pan Am, there was a question whether, or a belief by the applicants, that may be treated as a pooling of some part of their earnings to which the pooling statute applied. The pooling statute says that pooling cannot occur without board approval. And it says that the board shall consider whether there's an anti-competitive effect, and that the board may impose conditions on the pooling. Unlike 324D, that's a clearly unrestricted scope for potential conditions. Now, in the Pan Am Southern case, as the board may remember, it rejected the application for pooling authority because essentially the board found that it wasn't required, that there was not a relationship between Norfolk Southern and Pan Am that would otherwise have been a competitive relationship. They were essentially end-to-end partners, and under longstanding board precedent, an arrangement between end-to-end connecting carriers that allows them to cooperate is not treated as pooling because because competitive relationship is a necessary element. Well, that won't be the case anymore with CSX brought into Pan Am. And so with respect, it appears that in order to go forward with this transaction, it may be necessary for a pooling to be approved. CP has no objection to that approval, but we note that the statute makes clear that there's unrestricted authority to impose conditions and to address the competitive consequences. Now, I'm happy to answer additional questions now about the legal standard and the legal issues in the case, but I'm also happy to hand it over to James and we can come back to it at the board's discretion.
No, David, Patrick has some questions. This is an area he's focused on. So why don't we do that now? I think that would be more efficient. Patrick, if you want to go ahead.
Absolutely. Thanks, Marty, very much. David, would you agree with the proposition that the board's authority to condition is is constrained by at least part of the approval authority in subsection D?
Certainly its authority under 11324 is constrained by those statutory requirements. We completely agree with the idea that the board needs to comport its review of a transaction with the standards set forth in the statute and with its precedent. I think that's very important for the guidance of parties and adherence or reasonable expectations about how a transaction will be reviewed. So I think we agree with that proposition, yes.
So in other words, you believe that the board cannot impose a condition, at least on a competition related matter, unless it finds likelihood and substantiality.
That's right. That is, we think that finding, in order to impose a condition, and this is true whether it's a minor, significant, or major transaction, in order to pose a condition, the statute and the board precedent, I think, would say that you must find that there's actually a competitive harm that needs to be addressed, that's transaction related, that's not pre-existing, that's not a matter of complaint about a contractual arrangement. There's been discussion in prior panels about certain issues, certain kinds of issues that may not rise to the level of transaction related harm, and certainly or competitive harm that warrants a condition. So we completely agree with that.
But David, isn't it true that in subsection D transactions, the board specifically evaluates things for likely or substantial, but in subsection C transactions, the board doesn't use that language?
Well, the statute doesn't use that language, but I think if you look at the board precedent, essentially there is a similar, if not the same, concept and standard that is applied to examine whether there's actually a competitive harm. If the Clayton Act analogy may be apt again here. In Section 7 of the Clayton Act, the language is substantial lessening of competition, and the courts have interpreted that to mean essentially what 11324D means. But by the same token, in major transactions, when the board examines whether competition will be harmed, it adopts a very similar analysis to ask, is this really a competitive harm that's coming from the merger? Is it likely? And will it be significant enough for us to remedy?
It's your view that let's just say under the new rules for major mergers, it's your view that the new rules for the major merger adopted a Clayton Act standard to competition.
Well, so that's introducing I think there may be two layers to that question, Commissioner Fuchs. One is the question whether there's a competitive harm that warrants imposing conditions. Separately, there is a broader conditioning authority in a major merger case than just competitive issues, right? And so I think a way of looking at the new rules is that they are tapping into that broader authority of the board to ensure that the transaction will be in the public interest. And there are a host of issues that the board pointed to in its adoption of the new rules that are public interest concerns. And collectively, they led the board to conclude, for example, that there needs to be an enhancement of competition. I agree that is a different standard than what we're focused on here.
So if the board has a broader conditioning standard under C than D, as you described, what can't the board condition under D that it can under C? And why?
Well, we don't have a position on this issue in this case, but I think, for example, our position here in this case would not require the board to find that it has any authority under D to condition a transaction to protect passenger rail interests. Now, again, we don't have a dog in that hunt, so to speak, on this issue, but I think to find that the kinds of conditions addressed to competition that we're urging here are warranted under D, you would not need to conclude that you have any authority to impose.
No, I understand, but I just want to make sure I understand the point. Can you give David, can you give a concrete example of something we could condition under C, but we can't under D, and why?
Well, I think
just so I understand your claim that C is broader authority.
Well, I think you could under C impose conditions that are designed to guard against transaction-related harm to passenger rail service.
But we can't under D.
Well, I think what I'm saying is I understand the interpretation of D that would say you can't. We don't really have a position here that you can't, but I understand that there's a distinction between the issues that would allow you to go one way and not the other.
And so you kind of go into the fact that the Clayton Act standard is apt and that the board should basically adopt something like a Clayton Act standard when it's both evaluating the transaction and when it's deciding on conditions. Is that right?
Yes.
Okay. So why do you think Congress added D2?
Patrick, can I just interject for a minute? Because I'm trying to follow this. Could one of the two of you, David, I suppose, state when Patrick said, should we apply something like the Clayton Act standard? Could you articulate that?
I think actually the language of D2 does a pretty good job of approximating a Clayton Act standard for a review of the transaction. The Clayton Act itself talks about substantial lessening in competition. And D2 talks about actual and substantial competitive harm. And under the Clayton Act as well as under D2, you do view that whether it's the board or a court would evaluate a transaction by balancing the harm to competition against potential pro-competitive benefits from the transaction. That's how the Clayton Act has been applied for a generation at least. So I think that's a way of thinking about what a Clayton Act standard is. Commissioner Fuchs, to your question of why
Thank you, David. And Patrick, I'm sorry to have interrupted, but I just.
Well, I think to directly answer, David, please correct me if I'm wrong, but the Clayton Act says that, maybe to substantially lessen competition or create a monopoly, right? And in any line of commerce in any area of the United States, is that right?
Yes.
All right, and so D1 also says, well, it says a little differently. It says there is likely to result in a substantial lessening of competition, creation of monopoly, or restraint of trade. So you can see how the language is very similar. I guess that's why I keep on, D1 is a Clayton Act-like standard. And this is, David, I'm really glad you're here with your background. I am, first of all, I'm not a lawyer. I'm certainly not an antitrust lawyer. So you'll have to, could you educate us on, I thought that under case law at the time, like Philadelphia National Bank and Procter & Gamble, that economies weren't a defeating defense for substantial lessening of competition.
Well, so Philadelphia National Bank goes back quite a ways, and it is, I would submit, it really is not the governing law on the question of how to apply Section 7 of the Clayton Act. I think the right line of authority to examine is a Supreme Court case called U.S. versus General Dynamics, and then a subsequent DC Circuit case, U.S. versus Baker Hughes. In both of those cases, the courts emphasized the importance of examining competition, not just in terms of the structural kind of impact on concentration statistics, but on the dynamics, the competitive dynamics of the market. And really,
let me ask you, so what problem do you think that Congress was trying to solve when it added D2?
Well, so I'm not sure that Congress was trying to solve a problem that wasn't a competitive problem that wasn't already addressed in the statute. In my view, adding D2, plainly places the focus of a minor or significant transaction on competition versus other public interest concerns. It says, if the transaction is net pro-competitive, then don't be concerned about other public interest factors that may be raised against the transaction. That Congress wants pro-competitive transactions to go forward, whether or not there are other public interest concerns that might, in the board's view, get in the way of that transaction. I think that's, at least that's a way of reading D2, and I think it's a reasonable way. If you look at when that was adopted in the statute, the way the antitrust laws and the deregulatory thrust of Congress in the rail area was very much on allowing for transactions that did not harm competition to not be burdened and impeded by concern about other claimed public interest issues. So again, we don't have a position on the other public interest considerations of the CSX Pan Am transaction, and as James said, even in the competitive focus, we think on, if you were to say, if we had no authority to condition the transaction, we would not suggest that the board block the transaction, but we think clearly the board it's not hamstrung to say, we have no power to fix specific concerns that we can fix without doing violence to the broader benefit.
So I want to posit a theory, but I just want to make sure I kind of concisely summarize that. It's your view that that what the Congress was intending for D was that if you don't find likely and substantial competitive effects, the board should move along.
Yes.
Okay. Regardless of whatever other public interest factors it could dream up.
I think that's a fair interpretation. Yes.
Okay. So let me get your reaction and let me posit a theory. I think that captures a good bit of what was going on at the time. But as you may be aware, in 76, the 4-hour, Congress put forward an expedited merger procedure that wasn't really implemented. And then, this is what I alluded to yesterday, the Carter administration, out of the Prospectus for Change, had a bill, the precursor to the Staggers Act, which is what added D, that thought to put everybody under the Clayton Act, all mergers under the Clayton Act. And then for non-mergers, other cooperative agreements, coordination agreements, it would be under like a standard that looks a lot like D today. And there was a series of congressional hearings at the time. Donald Flexner representing the DOJ, and Bob Gallimore for FRA, Sullivan at FRA, Chairman O'Neill for ICC, and the railroads. And there was an extensive discussion about whether or not merger should just be under the Clayton Act, as you're suggesting D is today. And what the railroads contended at the time was, because of the language of in any line of commerce or in any market, the Clayton Act would essentially put an end to mergers. And there were a lot of parallel lines where the shifting of routing would lead to economies that would not be possible if you adopted a Clayton Act standard, because you would find a likely substantial lessening of competition in that area or for that line of commerce. And you would lose all those economies or economies that could exist elsewhere. And there was active discussion and questioning by the what I understand to be one of the chief drafters, Florio, Representative Florio at the time, to the railroads, to DOJ, to DOT, about whether or not if you apply the Clayton standard, you lose a focus on the economies. And he actively suggests whether or not you need D2 in order to consider the broader public benefits, because Clayton would be too cramped for the unique characteristics of the rail industry. I also agree. So I put that out there to say that I don't think it's hard to look at that and say the intent was just to apply something very similar to Clayton, when Clayton was explicitly contemplated and not adopted. And so I would also, so that's on the Clayton point. So I think that I'd like you to maybe disabuse me of that. And then the other is on the factors point. I completely agree with you. The conference report suggests that D stands for limiting factors. If you look at what was going on at the time, in 1978, the ICC issued a policy statement that had all of these factors. And the prospectus for change, the court measure said, there's so many conflicting factors, public interest factors, we need to focus on competition here. And it's very clear across government and other agencies that that was a concerted effort to focus mergers on competition and not other public interest factors, some of which include fixed charges, some of which include actually environmental impacts and other things that were in that policy statement in 1978. And so the Congress also wanted to limit the factors, but it didn't only want to limit the factors because they had this other concern that Clayton would be too cramped, in addition to the expert agency claims and other things. So I guess I certainly appreciate that the Congress wanted to limit factors, is I guess what I'm saying. And I think the way you read the statute and to not get involved in all these other public interest matters is a very reasonable and defensible one. And it's hard to imagine what D stands for anything if it doesn't stand for that. But I only put forward that there's a lot of discussion and sort of, when you look at the case law at the time, there's a lot of reason to suggest that if Congress just wanted the board, or I should say the ICC, or the DOJ to apply Clayton, as you're suggesting is our role today, it would have just done that. But it didn't. And I'm wondering whether or not there's significance to that.
So Commissioner Fuchs, a couple of reactions to that, and I'll try to focus on responding to your points or questions, and perhaps I'll go a bit afield. But I think my first observation is, I don't know that I have a unified field theory of how the board considered or Congress considered potential alterations to the statutory framework, over the last half century. I did litigate side by side with Don Flexner in an antitrust case. So, I kind of can envision him as the Department of Justice representative speaking to the competitive issues. I'll offer some observations about those issues. But I want to say, I think some of the academic, question that you're raising is sort of interesting and maybe very important in certain contexts, but I don't think it actually is a necessary path to decide that the particular conditions that we're proposing and the consequences that we're seeking to address through our conditions are within the board's authority and discretion to address. So I think I have not, perhaps because of that.
Well,
I
I hear you, except, the first, we have Amtrak and MBTA, right? And they're asking us to impose passenger rail conditions, something that we've basically never done, and rejected, at least by pointing to D, right? For among other reasons. So I think resolving how D limits factors is extremely important for adjudicating that issue, right?
And I'm certainly delighted to do my best to be helpful to you.
I totally agree, and that's not, you don't have a dog in that fight. I hear you. And then the other thing, though, is, and this is why I think it's a little bit more than academic, is because you all have the burden to justify your conditions.
Mm-hmm.
Extensive board precedent on that. I think everybody's agreed with that.
Agreed.
And so it's the burden to what standard?
Mm-hmm.
And if it is true that you needed to look at the effect on benefits of the transaction,
mm-hmm.
say, for example, factoring in the benefits of NS trackage rights,
mm-hmm.
you haven't made any showing on that. You haven't.
Yeah, I disagree. You
haven't. You made a showing on the relative merits of NS trackage rights and the potential ways the conditions could jeopardize those.
The conditions in no way affect the NS trackage rights. We are fully supportive of NS exercising their trackage rights.
Well, if CSX granted NS trackage rights under certain conditions on the northern route, the board would be unjustified in considering whether or not, if those circumstances changes, the circumstances change, the trackage rights would no longer be granted, because that is a voluntary measure.
Well, we're not. I don't believe that any of the conditions that we are seeking would require the applicants to go back and renegotiate any aspect of their arrangements among the three participants here. And James will address the specifics of what we're asking in a few moments, but we're not saying that they have to relinquish or alter their plans to move the double stack trains to the southern route. We're not saying that they need to avoid taking advantage of the single line route that CSX will have established with its Pan Am Railway acquisition and force traffic over the Pan Am Southern, even if it were inefficient to do so. We are not saying that. Well, all we're saying is that to the extent that those steps and or really the fundamental aspect of this transaction where the evidence, right, I would submit, of substantial effect is unavoidable, is that where the board found in the Pan Am Southern formation case that it was in the public interest to enhance competition, Pan Am Southern against CSX in these markets, to then have CSX invited into the boardroom with a half interest in that railroad, I would submit that is proof enough of an anti-competitive harm. If we were in a Clayton Act case.
Right, but I think we're established we're not in a Clayton Act case, right? Because Clayton Act, it referred, is similar to D1. D2 was, if my contention is right, that D2 was meant to contemplate maybe something broader than Clayton Act. But I think, stepping back, I just want to circle. I mean, you all have, it's fair to say, though, that you have not weighed the overall public benefits of the transaction. And your contention is that your conditions have no effect on the benefits of the transaction.
That's correct. So what I would say is whether the overall competitive benefits are, $1 million or $1 billion, right? I think we would be inclined to say that they likely do exceed, and they may exceed. It doesn't matter to the outcome, the net harm, or you just to not condition the transaction at all.
So the board should intervene when transactions add to competition, but have one aspect of them that don't add to it enough, or that take away from it.
Where they have an aspect that will cause harm that can be remedied without reducing the net benefits of the transaction.
Okay, and I'll wrap up by saying,
it has the effect of increasing the net benefits, but the goal isn't to increase the net benefits, it's to remove the harm. And that's how the Clayton Act would be applied. And to your point, there's probably a very great degree to which I agree with your perspective on D versus the Clayton Act. And, going back to, Don Flexner and the history of this, there certainly has been over the years in the Clayton Act context, debate in the antitrust community about whether, if the antitrust division goes to litigate in a merger case, whether a court is allowed to consider efficiencies of the transaction as a counterweight to the competitive harm. The thrust of current law, I would submit, is very strongly in favor of allowing defendants in a merger case to bring forward efficiencies to show that, in fact, when the efficiencies change the incentives of the parties and they mean the transaction's not anti-competitive, that's sort of neither here nor there. I think being clear in the context of the Interstate Commerce Act that efficiencies are important goes back to the Transportation Act of 1920 and the whole thrust of why the board has a role in allowing transactions that are in the public interest to go forward. I think I would take your point a step farther. If you're looking at in a major merger transaction, one of the reasons why, when the board was created by ICTA, that it retained the authority over mergers was to allow for a transaction that some might regard as anti-competitive to go forward because it had substantial public benefits associated with improving the strength of the transportation network, providing significant benefits, for example, encouraging investment in what would otherwise have been a less effective competitor. And a good example of that is the UPSP merger. If you look at the way the board reviewed that merger transaction and saw benefits associated with UP taking over the SP network and remedying competitive concerns with extensive trackage rights, the Antitrust Division and the Clayton Act probably would have come to a different outcome and required either a block of that transaction or some other kind of relief. The board had more authority to tailor the relief to the public interest in that case. So I think there is this discontinuity between the approaches. I'm not suggesting it's exactly the same. However, I would submit that whether it's a minor transaction, a significant transaction, or a major transaction, when you're asking, is there a harm that ought to be considered as a harm for a potential remedy, the basic approach is to examine it like you would in an antitrust case and ask, is competition going to be reduced? Likely, and is it substantial? And here, circling back to that question, unless you're prepared to say that the competition that Springfield Terminal provides against CSX is not substantial, allowing CSX to be on the board of Pan Am Southern is clearly a substantial competitive harm.
I want to quick wrap up, and I want to thank you for the robust discussion, as well as my colleagues for allowing me to explore this issue. It's of importance to me, and we've discussed it at length in many other cases, and one in particular. So I really do appreciate it. I want to extend my appreciation to my colleagues. I kind of wrap it up by saying, and get your reaction. Do you agree with the proposition that the board should only impose a condition if it could withhold approval? Of the transaction. So the Seventh Circuit. So immediately after D, there was a case that the ICC had that said we should only impose conditions in a transaction if we could withhold approval, and that decision was upheld by the Seventh Circuit. And then there's another case in a major merger where the DC Circuit said we reject the notion that the board has broader authority to impose conditions than it has to deny approval, basically is what it said. So I guess I'm asking you, does the board have broader authority to impose conditions than it does to deny a transaction?
Well, so two points. So if we're focused just on 11324, So not looking at the pooling statute, which, you know, is a separate point that may apply here. I think, I'm not sure that there is a discontinuity between the point about withholding approval and imposing imposing conditions, in the sense that, it begs the question: could the board withhold approval if there were a competitive harm that was not necessary to go along with the benefits that are included in the calculus of whether there are net benefits? I mean, you could end up with this circular debate about
Right.
do the benefits, do you have to take the harm with the benefits to get the benefits? And if, I think the way, this goes back to the way in which an antitrust agency would evaluate competitive harm. If you can calve off the harm without doing harm to the transaction, without doing harm to the benefits from the transaction, then you would do so. If you would blow up the transaction as part of doing that.
So I mean, but David, I mean, to summarize though, you basically say, yes, the board can impose conditions even if it could not deny the transaction on that basis.
What I'm resisting is the hard conclusion that the board could not deny approval under a circumstance where there were harms that weren't connected to the benefits.
I guess I'm missing the distinction. I guess so. We look at D1 and D2 to decide whether or not we can deny the transaction. If we conclude that just based on the transaction as presented, non-conditioned, we can't deny it. We can still impose conditions, and that is true under both C and D. So if we look at a subsection C transaction, it's the same situation where if we conclude we can't disapprove it as it presented, we can, in both instances, we can go beyond our authority to deny in order to impose conditions.
So I think if where I think we may agree is that, if you assume that the board has reached the conclusion that it cannot deny the transaction, then I think there is a good argument that you cannot condition it. However, where I think we may be not 100% aligned is to conclude that the board cannot deny a transaction because you may look at the way in which the parties have chosen to structure the transaction, and because of the way they've packaged certain assets together into a transaction, they may have a very pro-competitive, 5 elements of the transaction, but they've chosen to add in something that's blatantly anti-competitive in order to force the board to approve that under D. I think that the board probably has more latitude than your question may be suggesting, to reach out and say, no, you can't include this blatantly anti-competitive aspect just because you've chosen to do those 5 elements of the transaction. Now, if it were the case that the only way to get the 5 elements.
So when the Congress tells us that we shall approve the transaction, if it meets those criteria, it doesn't really mean we shall approve the transaction. It means we should approve the transaction as we design it.
I don't think I would necessarily ascribe to that characterization of Congress's statement in D2. I think, I would be inclined to go back to, where it appears that, to me, that Congress was coming from was the focus was to put the starting point with D2 is we want to make sure that you are not going off and denying transactions on the basis of issues that aren't competition issues. And now when you're examining a competition issue, we want to make sure that you're also considering potential benefits associated, competitive benefits associated with the transaction. That's completely consistent with a focus on competition. And it's also completely consistent with our focus here in this
I will
transaction.
only note that, and I'll wrap up. David. I only note that D2 doesn't include the word competitive benefits, right? It says public interest in meeting significant transportation needs. So it's,
Fair.
all right. But I'll leave it at that. There's also, I'll actually just leave it at that. But David, I really do appreciate the discussion very much. And again, thanks to my colleague.
Sure thing.
Thanks, Patrick and David, both. That was extraordinarily enlightening. And I have a few questions. We have been going for a little over 2 hours. I wonder if this would be an appropriate place to take a short break. And then I'd like to follow up, David, with to tying down a little bit of this discussion, which was far ranging as it might apply to this case. I will say, I don't have any sense of being able to discuss this on the same playing field as you and Patrick in terms of expertise in both legislative history and antitrust law. The last time I looked at antitrust law was when I borrowed a classmate's notes to take the exam in 1969 and did better than him. But other than that, I don't know anything about antitrust law other than looking at the board. So I have a few more questions. So let's break. It is 11:50. I think what might be good, if it's okay with the board, we come back in 10 minutes, finish this panel, and then break for lunch. That sound like a plan for everybody?
Sounds good. Thank you.
All right, we'll see you at noon sharp.
Is the
All right, everybody, I think we are back in session. And I had a little bit of a follow-up, David, to this extremely erudite discussion. Couple of points, as I was listening to this and staring at D2, which I have stared at off and on since I've been on the board, I thought it was interesting that whatever the intent of Congress was to focus on competition, as Patrick pointed out there at the end, D2 says that we're supposed to weigh anti-competitive against the public interest in meeting significant transportation needs. It doesn't say in meeting the public interest in pro-competitive impacts. It doesn't say significant freight transportation needs. It doesn't distinguish between freight and passenger. So that if a proposed transaction is not meeting significant transportation needs, including passenger, then we're supposed to take that into account when in the weighing part of D2. Is that a fair reading? And I know you're not here on the passenger side, David, but you are a resident expert, so I'm gonna take it.
Well, and Robert Wimbish is here, right?
Yeah, and he can weigh in on that too.
Well, I think that I'm not sure. I mean, I think when I look at the language of D2, and it speaks to whether there are anti-competitive effects that outweigh public interest benefits, it appears to be suggesting that the nature of the harms that may outweigh benefits is to be measured in terms of competitive harms. At least that's
the harms are supposed to be measured on the competitive side, but the benefits aren't limited to competitive. The benefits are talking about significant transportation needs, which could mean competition, could mean passenger service, could mean better freight service, could mean it's a broad term. They chose a broad term.
And I think apropos to my observations about the preservation of the board's authority over mergers at all in the mid 90s in ICTA, I do think Congress has long had the view that maybe uniquely in the railroad industry, of all industries in the country, there's a desire to make sure that antitrust law doesn't stand in the way, kind of narrow-minded application of antitrust law doesn't stand in the way of transactions that may be vital to improve the rail network. And whether you view the Union Pacific Southern Pacific merger as an example or not, I mean, I worked on that case. I thought that was a very pro-competitive transaction. It was certainly the case that the Department of Justice strongly disagreed with that conclusion. But the board, by reserving to, the Congress, by reserving to the STB the authority to say, you can approve that transaction if it's in the public interest, notwithstanding, some anti-competitive effects that may or may not be found, I think, allowed for the board to have latitude to serve the interest of the public in transportation needs without being hamstrung by the potential for anti-competitive effects. But I think none of that debate, whether you can or can't weigh certain types of effects against other types of effects, in my view, limits the board's authority to excise anti-competitive harm that's not inextricable to the beneficial aspects of the transaction.
Marty, you're suggesting you only reach that though if you first find maybe you first make an anti-competitive effect finding, right?
I think you have to make an anti-competitive effect finding relating to that which you will excise. Yes.
Yeah.
But I don't think you don't need to take unnecessary anti-competitive harms along with the benefits just because they've been latched onto the transaction before you.
You're saying, as I take it, that since competition is the focus of this whole discussion, if a transaction has anti-competitive effects that can be excised by conditioning without harming the transaction, we're supposed to do it.
That's our view.
Yeah, well, so that's what I want to get to. I want to see if I understand this, and I don't know if maybe this is for James as well, if he was going to get to it, but let me ask you, David, and then if we should await further exploration of this until James makes his further comments, I'm happy to do that. As I understand it, right now, CP, with no transaction, as of today, CP is comfortable with the current situation. It's access to PAS, it's access to New England and so forth. And that you don't want that diminished. Is that a fair summary of where CP is in this deal?
I'll let James speak to that.
Sorry, yes, that's correct.
Okay. So your concerns are that without some conditions or promises by CSX, and I want to go into that, your current situation could be diminished and your ability to compete in New England could be diminished, and therefore it comes in under this whole discussion of anti-competitive effects of the transaction. Is that a fair understanding of why we're talking about this?
Yes, that's exactly correct.
All right. So yesterday, I had a robust discussion with the CSX team, which I assume you listened to, about their promises to keep all gateways open, to keep them open on non-discriminatory pricing or equalized pricing. I cited as an example a current PAS tariff that relates to Mechanicville, Hoosick Junction, and Rotterdam. And I thought we had a very clear promise by Mr. Foote that he was going to close no gateways physically or financially. Did you, first of all, were you both on listening to that interchange?
Yes, I heard that interchange.
All right. So, and you know, CSX has said any promise they've made to us, they agree can be a condition of this transaction. So let's take it to there. Was that discussion, if it was properly written out to cover PAR and PAS, does that satisfy that, at least one of the conditions you're asking for?
Yeah, so there's two components. I would say that condition, the way I understood the conversation, addresses what we would call the commercial access over PAS and to PAR, and also, as you discussed, the reverse flows that are coming out. So that is
that part of it. And I realize you have some other concerns, but just on the access part and your ability to get in there and compete by having access.
Commercial access, yes, sir.
Yeah, because, you know, I didn't ask Mr. Foote about this, but I thought, and I remember this, I just hadn't remembered it yesterday, the page that you put up on the screen, I thought covered this as broadly as possible, because the statement made by CSX that you had up there said, through a series of agreements with NSR GWI, CSXT has structured the proposed transaction, which is everything, to eliminate any risk of competitive harm relating to these two parallel routes. So he and I talked yesterday about competitive access up and down the Maine, which, you know, the line as it runs up through Bangor and so forth. This language specifically covers any risk of competitive harm to the two roughly parallel routes. And that's where your focus is, your access to PAS, right? So if we put into a condition with specificity, keeping those gateways open at Mechanicville, Rotterdam, and Hoosick Junction, that part would eliminate, quote, any risk of competitive harm. Is that we're all on the same page there?
We're on the commercial side. We think that being competitive is also a function of the service that you get into the market. We
All right, so,
are not satisfied that service is adequately addressed at this point in time.
all right, so that, I know you, that's the, and I agree, I was just focusing for the moment on access. And so that is what I wanted to deal with. I want to hear, you are also concerned, I know you are concerned about the condition of the PAS line, whether there's enough incentive to keep it up. From an investment point of view, you talk about service, and I gather you want to deal with that directly in a further presentation. So I think I'll hold my questions on those aspects of what you're asking for until you've been able to, I think you want to explain it in more detail, right?
Yeah, I'll maybe go through it very quickly at this moment.
Okay, well, I don't want to cut you off. I didn't want to do it piecemeal. I'd rather let you make your presentation, then we can come back. Before we do that, do any other board members want to weigh in on the Patrick, David intellectual exchange? And I don't mean to say it's not practical, but practical as well as intellectual. Do any of the board members want to weigh in on that, or shall we let the comments go forward?
I just wonder, Marty, if they could run through just the 11-322, in terms of why they believe that to be applicable here, and how it relates to their assertion that the harm it would cause, well, the remedy it would cause, it would produce, over the CSX taking over 50% of pass. So if David, if you could just go over that just a little bit, I'd appreciate that.
I think that's a good point, Robert. And in fact, I'm glad you raised it, because I'm not sure what pooling means in this context, and maybe David can put some flesh on that.
Sure. And again, this observation in our presentation today builds primarily on the original formation of the Pan Am Southern and the applicant's view, Norfolk Southern and Pan Am's view at the time, that approval under the pooling statute was in fact required to allow for the two of them as joint owners of becoming joint owners of Pan Am Southern, therefore sharing in the profits from the rail operations on Pan Am Southern, through, to be operated by Springfield Terminal, generating revenues that would be allocated back to the owners. They assessed the situation and thought, we need pooling authority. And the board disagreed because they weren't otherwise competitors. But perhaps let's go back to the beginning of the analysis and understand why they thought that they may need pooling authority. And you'll understand, I think, why pooling authority or the pooling statute arguably does apply here. In fact, I would suggest this may be a textbook case of pooling in the railroad industry. It's a relatively little used authority in recent times because major railroads avoid sharing revenues with folks that they compete with. And the board's very clear that pooling doesn't apply when there are end-to-end divisional arrangements, for example, or trackage rights arrangements. But if you're actually sharing, and I'll read from the statute, if you are a rail carrier within the jurisdiction of the board, you may not, quote, pool or divide traffic or services or any part of their earnings without the approval of the board. And the board may approve pooling if it will be in the interest of better service, if it will not unreasonably restrain competition. So the board has the authority to approve the kind of arrangement here between CSX and Norfolk Southern if the arrangement will improve service to the public or the economy of operation and not unreasonably restrain competition.
So let me translate that to make sure. So I think I understand what you're saying. I just hadn't focused on the word pooling before. So if the deal goes through, Norfolk Southern and CSX will each own 50% of PAS and get 50% of the profits. That's pooling. Is that what you're saying?
I have not analyzed with, in depth exactly how funds flow from what sources to the owners, but it certainly appears to me that as 50% owners in an enterprise in the LLC that's generating a certain amount of revenues from the rail operations of the LLC, whether they're conducted by B&E or some other operator, that seems, if that's two competitors with parallel lines coming together to share in the revenues from the competing line, I think that is a textbook case of what the pooling statute was designed to address.
All right, and you're saying that under that statute, there is a even broader conditioning authority. So if we just take this situation, we have been told that one of the pluses of Pan Am is that at least the way, or PAS, the way PAS has functioned is that it's neutral to all comers. So it has these tariffs that allow CSX, NS, CP, anybody else to access the PAS line on exactly the same terms, so that the shipper can then, or receiver, has several competitive options. And that's the way it's been run now. It sounds to me like you're saying if we allow CSX to come in and replace, to come in as the 50% holder, replacing Pan Am, now there's pooling there between CSX and NS. We can condition that by saying you can't reduce all those competitive options that have been in place prior to your coming in as a 50% owner. That's one kind of condition we could impose by keeping these gateways open on new equalized pricing. That's your point about the conditioning authority under 322?
The board, so two points to there I would suggest, and James may want to chime in on the merits, but point one is, I think, if the board concludes that there is pooling here, I think the statute is pretty clear that the board's ability to impose conditions is not limited in whatever way 11324D2 is limited.
Yeah.
And
that's under B.
Yeah, this is 11322B, correct?
There's no limitation. It just says may impose conditions governing the pooling or division.
Correct.
Okay.
The second, and maybe I have three observations, one of which goes back to Commissioner Primus's question. My second observation is to the way in which you've described the condition is probably different and broader than what we suggest is warranted. We're not looking for a condition that freezes rates or necessarily requires that Pan Am Southern treat every condition in an equalized way. That we're not trying to rigidify the way in which Pan Am Southern operates in the market and approaches the market. We're just trying to preserve the incentives that exist today for Pan Am Southern to cooperate in an effective and interested way in building traffic in interchange with Canadian Pacific. And we think, as James has said, that the way in which we heard the commitments being expressed yesterday, and there are various points in the papers that the applicants have submitted about the gateway condition, keeping gateways open on commercially reasonable terms, and specifically now being clear that that doesn't apply only to the Pan Am Railway gateways, such as the connection with Pan Am Southern and Air, but also applies to the transaction participants as a whole and to the Mechanicville gateway with Pan Am Southern for traffic to Pan Am Southern and then across Pan Am Southern to Pan Am Railway. We think that's now clear in the record. To the extent it is clear in the record, we think that commitment keeping the gateway open on commercially reasonable terms is an adequate reflection of what we were seeking, without
So,
going so far as to say there's necessarily needs to be equalization or other specific, freezes of how Pan Am Southern approaches the marketplace.
yeah. Well, I'm sorry, Robert, go ahead.
Sorry, Mike, just staying on that, David. So were you suggesting or saying that the potential there for, a joint venture between CSXT and Norfolk Southern, at Pan Am Southern would harm you in a sense that it would tend to direct more traffic? The gateways would remain all open, but in terms of the direction of the traffic would be more towards geared towards NS and CSXT because they, of course, stand to benefit from that.
No, I don't think that's the thrust of the argument we're making. I think the thrust is not that there's an incentive to divert traffic away from us. It's not. I think that the concern that we have is that because of, and I'll try and connect this to the pooling statute, but the same analysis applies under 11324. That what as James indicated in his chart about changing incentives, to us the centerpiece of what causes the harm here has nothing to do with the Pan Am Railway part of the transaction. It has to do with CSX acquiring the Pan Am Southern interest that used to be owned by Pan Am. So it's bringing CSX into the ownership of the LLC and the boardroom. Now, I think under the analysis that the applicants presented to the board at the stage when Pan Am Southern was formed about pooling, I think that is simultaneously a control issue under 11324 and a pooling issue under 11322. So then the question is, what about that causes competitive harm? We're not saying it causes harm to us. What we're saying is Pan Am Southern's incentive and ability and the investments and service levels that go along with the incentive to compete against CSX are reduced by the fact that CSX is there as a 50% owner in the boardroom with no incentive to compete against itself. Now, we've heard CSX point out that, well, we have a great interest in interchanging traffic with Pan Am Southern. We're the number 2 interchange partner. I would submit, of course they are. They're one of the 2 Eastern railroads. Of course they're going to have interchange traffic with Pan Am Southern. We understand that. But they don't have an incentive. They have an incentive to terminate and originate traffic that's local and bring it to the CSX system, for sure. And we're not suggesting that that goes away. But when you look at Pan Am Southern's role as a part of a through line that competes against CSXT long haul routes, that incentive goes away. And that's where, I think we heard a number of colloquies with the applicants about scenarios that, it wouldn't be hard to come up with scenarios where there were particular investments, needed at Pan Am Southern, and there would be a very different view that CSX would have about whether to invest to maintain service levels or adjust the service design on the railroad or some other decision where, the motivation for the investment or the change would be to either compete better against CSX or to maintain the ability to compete effectively against CSX. And, Norfolk Southern may have a view that it would want to make the investment. CSX would not have incentive to make that investment. We just want to make sure that the situation is protected by enforceable conditions in perpetuity. Again, this is a generational transaction or a multi-generational transaction, as the applicants have pointed out, and so that the service levels, the investments aren't as a result of introducing CSX as an owner and an influencer is not going to be to diminish what would otherwise have been the competitive service route that competes against CSX's service route. It's really as simple as that.
Okay, I appreciate that. And I'm going to have to untangle it because it almost sounds similar to how I'm saying. I know you're saying it's not exactly, but if they're making improvements and doing things that are going to advantage CSX on that, and like you said, the long haul traffic as a result on your side is not benefiting from that. It sounds not necessarily that they're drawing away, but again, what you're saying is you're not going to gain from those improvements and enhancements.
So I think maybe what I'm trying to suggest is the differentiating feature between the way you framed it and the way I framed it is to think of it this way. It's today, if you're a shipper moving traffic from the Midwest to Boston, there are 2 through routes. There may be a number of ways to get to the west end of New England,
right,
either Albany or Mechanicville. You might choose NS, you might choose CSX, you might choose CP. Today, in order to get to Boston, there are 2 routes. There's the Pan Am Southern and there's the CSX. The competition between Pan Am Southern and CSX disciplines the competitive outcomes for the overall line haul competition. So shippers, not CP, but shippers benefit from more competition for service levels, more competition on rate levels, terms, everything else. And that's why we like competition. Competition is good. After the transaction, CSX is in the not necessarily in the driver's seat, but can influence how good an option that Pan Am Southern route is. And the less good the Pan Am Southern route is, the less competition there is between the two, and the less discipline there is for rates and service levels, the traffic moving to Boston. We and our shippers benefit from there being competition between those 2 routes, so that there are 2 competitive routes. We understand that we're not going to win all the traffic west of Mechanicville, and we in fact interchange traffic with CSX as well on these routes. But overall, the marketplace is benefited along, and we get carried along with that by there being these 2 competitive alternatives. And we're concerned that the transaction diminishes the quality of one of those 2, or could diminish it, or likely would, if unconditioned, diminish the quality of one of those 2 routes, making competition not function as it does today.
Thank you.
David, I wanted to follow up. Thank you, Robert. I think that discussion was also helpful in enlightening us here. I want to get back to this question of the access points, because that's been really is a concern of mine. I wasn't asking, and I don't think anybody was suggesting, that the absolute amount of an interchange fee be frozen in perpetuity. Nobody suggests that. The commitment that I understood they were making is that whatever levels those were, they would be equalized for all. So they wouldn't charge you a different interchange fee than they'd charge NS coming in, or somebody else at the same onto the PAS route, so that the competitive options would have remained what they are today, as I understand it, under PAS's operation. Now, you referred to their commitment to charge commercially reasonable access rates. Is that a term of art in your view? How is that defined, commercial? How do we know what's commercially reasonable?
Well, I'll speak briefly on the use of that phrase in board precedent, and then maybe James can address what it means to him from a commercial perspective. In merger transactions for some decades now, the board has imposed conditions, or maybe another way to put it is required that applicants honor representations or commitments relating to keeping gateways open on commercially reasonable terms. And what I think, there's been not very much debate about what precisely those terms mean, but there has been a great deal of debate, which I think led several decades ago to a very strong conclusion and I think really binding precedent in the board that in the context of end-to-end transactions, so we're not in an end-to-end transaction here. This Pan Am Southern issue that we're talking about is a horizontal competitive issue, so it's a different kettle of fish. But in end-to-end transactions, where the issue has been preserving gateway access, preserving the viability of existing interline routes between merging partners, or between a merging partner and a non-merging partner, where there's a new single line route that may be available. It's been very, I think, clearly established that what it means to keep a gateway open is, first of all, that you not, and we heard Mr. Foote say this yesterday, you not close it physically. So you still continue to go to the gateway, you continue to interchange traffic there. And in order to keep it open physically, I think, you don't degrade the service levels so much that it becomes not a viable point of interchange for whatever was the pre-existing connection. Of course, that has to be dependent on traffic levels, whether there's a demand for it, nothing should be frozen. But then on the rates side, the economic terms, also, as Mr. Foote said yesterday, and I think he said he was the inventor of this approach in the CNWC case, and he may be, just thinking back, I can't think of a case that used this terminology before then. So I take him at his word there. The aspect that involves commercially reasonable terms is, that you can keep a gateway open physically, but if you raise the rate factor between the interchange point and the destination or the origin and the interchange point so much that it becomes economically non-viable for someone to construct a through route using that interchange, well, then you've made it, you've effectively closed it. That's the idea. They're defining where that, what it means to have a rate level that's too high, i.e. commercially unreasonable, is impossible to do in the abstract, in my opinion. The board has considered and talked at great length about how important it is not to impose conditions of the kind that once upon a time were mandatory in merger cases. You may have heard of the DT&I conditions, which imposed rate equalization and other rigid protections on protections of connecting carriers that prevented merging parties from taking advantage of single line efficiencies and pricing to the market, eliminated the possibility of differential pricing and so forth. Those were in the 1980s found by the board or the ICC to be anti-competitive and counterproductive to allowing for a transportation network that was characterized by market-based pricing and flexible competition by railroads against trucks, against their rail competitors, against other modes, considering market factors across the board. So I think the board has clearly said that commercially reasonable terms does not mean freezing rates, does not mean equalizing rates across gateways or across all destinations. It preserves the ability to price to the market. It says that there is an outer limit on what can be done that would prevent a connecting carrier from providing an economically viable offer using the interline route that previously had handled traffic over that gateway.
So let me see if I can understand it in this situation. As you understand it, if we look at other parts of PAR, we were looking at those charts of bringing propane in from Sarnia. up through Bangor. After this transaction, CSX will be able to offer a single line rate that it couldn't offer before. And single line rates tend to be more advantageous to the shipper than an interchange rate, right?
Yes.
And you're saying that neither you nor prior boards are suggesting that somehow we don't allow CSX to get the benefit of its acquisition by offering a lower single line rate where it can.
Absolutely correct.
Right, right, okay. So I understand that. And I don't know that anybody was asking for that. It may have sounded like it in my questioning, but that is not what I was focused on. I was focused on exactly what you're talking about here, and I'm still focused on it. On PAS, is it your understanding that if CSX wants to ship traffic on PAS, it's not a single line rate because PAS is a separate entity? So they still be interchanging with it as they do now?
Well, I think that that's right. I think, there may be ways in which the parties could structure their relationship such that, they may conceivably grant CSX haulage rights, in which case it may be more equivalent to a single line rate. And I'm not close enough to the specifics of this transaction, as to that aspect of the commercial relationship to be able to say one way or the other, whether perhaps there may even be an aspect of that already present in their intentions. I don't know.
Well, aren't they telling us, and maybe we can clear this up when we talk to them again today, I thought it was clear, that B&E is going to operate this railroad independently. It's going to be in charge of pricing. So when either CP or CSX approach B&E and they want to interchange someplace, as they do now, Rotterdam and Mechanicville, they're like dealing with an independent railroad. It's not going to be CSX dealing with itself. Isn't that what they're trying to tell us?
Well, I think they've told us that as to CP, that is correct. As to CSX, I think what I heard yesterday was that the B&E pricing authority has exceptions for arrangements that already exist between NS and Pan Am Southern for haulage rights. And I believe they were also referring to arrangements, part of this transaction involving CSX's temporary commitment to route certain traffic over Pan Am Southern. But I'm not sure, I don't have a recollection as to precisely what the financial arrangements were for that CSX traffic over PAS. As a general proposition, I think our view would be, in the long run, after this short-term arrangement, we have, if you look at the traffic data and you also look at the investments CSX has made in its own line, the Southern route, how it connects to its yard at Selkirk near Albany, I think, and James can speak to this, our expectation would be that CSX wouldn't be interlining traffic over Pan Am Southern. It would be running traffic on its service route, the Southern corridor, and so there probably won't be a long-term sort of CSX Pan Am Southern interline rate to think about as a benchmark for what is a commercially reasonable rate, if that was your thrust.
Well, I understand two things, David, from what we heard yesterday. One is there is some local traffic on Pan Am Southern that CSX serves now, which will go on indefinitely as long as those local customers are there. It's the only way to get there.
That's right. I was thinking of traffic. I was thinking of the traffic that was kind of the overhead traffic.
Right. So you have that traffic that's going to stay, and that is traffic. Let's just take one at a time, because I think now, if we're going to get into this and we're going to talk about conditioning, we better be very specific. That's what, so we don't run into a situation that we don't know what we all have a different view of what we meant. So as I understand it, if we start with the local traffic that is there now, which CSX says will always be there as long as those local customers are there, it's the only way they can get there. today, that traffic is interchanged, I think at Rotterdam, if it's coming from the west, by CSX, and they pay a tariff, interchange tariff. And based on the tariffs I looked at, the charge to CSX is the same as the charge would be if CP were bringing that same traffic in at Mechanicville. Tariff rates are the same, even though they're.
Maybe, Mr. Chair,
Yes.
one comment. My understanding is the vast majority of the traffic that we interchange today is not interchanged onto the tariff rate. It's on the basis of a negotiated division of revenue that we would put together in conjunction with the PAS. So I don't know how much traffic moves on that tariff. And then I agree, the local traffic will always be there. The question is, in the longer term, will they optimize the operation to serve the local traffic rather than potentially maintain the through option all the way over to the PAR in terms of how you organize it? And so I'm not saying that people are going to do that tomorrow morning after the approval, but as you think about the incentives and look at it over time, the question is, will the nature of that operation, the quality of that infrastructure be much more oriented towards providing adequate service for the local rather than the right service for the longer.
Yeah, I appreciate that, and the service is obviously important. But let's just stick with the access costs for the moment, just so we can fully understand that. Would it be accurate, yes, to either of you, on these so-called equalized tariffs, that they at least set the terms for sort of a base for you then to negotiate your own contract rate for your access? So you have some bargaining power that you either can go with the tariff or you get a better deal on a contract rate. Either way, you have equal chance to get on the PAS with the other carriers coming into the system like CSX and NS.
Yeah, that and again, what we've heard from, as you described, the tariffs and the other commitments, we do think that the representations, if they're made as conditions of the transaction, all of them, both what was represented yesterday as well as their written submission, does put us on a commercial footing that would allow the PAS to provide a competitive alternative.
Well, I guess one question, getting back to this definition of commercially reasonable, they could raise everybody's rates other than their own to a level that's not commercially reasonable and foreclose anybody from using PAS other than themselves, in theory, if it weren't restrained in some way, other than regular rate case restraint, right?
Correct.
So would it be accurate, I guess it's more a case question for David or either of you, when you say commercially reasonable rates that could be imposed as a condition of a merger, is that a different rate measurement than how you might measure a rate in a rate case challenge?
Yes, I think it is. It's not, I think I can state pretty categorically that I've never thought of what a commercially reasonable rate ceiling might be as determined by what would the application of the board's unreasonableness standards dictate. I mean, among other things, you wouldn't ask the question, as a predicate to examining a rate level whether there was market power. You wouldn't ask the question whether, what would a SAC rate constraint be, or what is 180 RVC as a threshold? And none of those questions really are germane to the question of what is a commercially reasonable rate. The commercially reasonable rate, that standard may be higher or lower. It's a different inquiry as to whether it allows for that route to remain competitively viable. The one thing I'd say, though, is important in this case to think that, when we say that the commitment to a commercially reasonable rate is one that is valuable and important in this case. We have to remember in this case, this is not an end-to-end case. This is a horizontal case. And so what we're trying to protect against is the different incentive that exists at Pan Am Southern with respect to maintaining Pan Am Southern as a competitively viable long-term alternative for all shipper and all connecting railroads. And so
could I just ask a quick question?
Certainly.
Sorry to interrupt you. And I'm sorry to interrupt the line of questioning, but I believe that CSX has actually characterized the transaction as end-to-end, although I'm not 100% sure on that right now. And you're describing it as horizontal. And I wondered if you could perhaps just go over with a little bit of specificity as to why you believe it's horizontal.
Sure. So maybe I'll use this map, which is built on a map that the applicants have used to describe their transaction. And I think the way I would answer it is to say the overall transaction that's being proposed here has both end-to-end features and horizontal features. The part that involves combining the blue route, which is CSX's system that ends near Worcester, Mass, with the red, which is the Pan Am Railway that starts near Worcester, Mass, and heads up through air, across trackage rights into New Hampshire and into Maine. That's an end-to-end transaction. That will create new single line routes for traffic from Maine onto the CSX network. CSX has described the benefits of doing that. We agree with them. That's the end-to-end part of this transaction. The part of this transaction that's not end-to-end is combining the green, which is Pan Am Southern, with the blue. Now it's not being combined outright. There's not a merger between the two, but that's where CSX which is today, CSX has no relationship to the Pan Am Southern other than as a competitor. And the second map, we've shown the blue again and the green again. The green is the Pan Am Southern, what we call the Hoosac Tunnel route between the Albany area. So Rotterdam Junction is near where Mechanicville is shown on the map. The route goes across northern Massachusetts to Ayer, Mass, near Boston, and connects with the Pan Am Railway, but also serves the Boston metropolitan area and eastern Massachusetts, southern New England. CSX's southern route does exactly the same thing in direct competition with that route. And that is a horizontal competitive issue. So those two are competitors today, and with no ownership relationship or overlapping directors or any entanglement of that sort. With the transaction, that will no longer be the case. CSX will be the half owner, be the 100% owner of the blue line and the 50% owner of the green line. And that's what reduces horizontal competition. Competition that's head to head today will be diminished.
Thank you.
Patrick, you want
Following
to
up on Michelle's very good question. David, is it fair to say that CP is focused very much on a specific definition of intramodal competition and does not provide evidence on product competition, geographic competition, or intermodal competition?
Well, we're certainly focused on preserving the rail to rail competition that exists. I think to your question, there's no doubt that for any given carload or container load of traffic that runs on one of these two rail routes, if you were doing an analysis in a rate case, for example, of whether there were other competitive influences on that particular flow of traffic, you would need to consider things like, are there?
I appreciate that, but you mentioned horizontal merger, and isn't the case under horizontal mergers that you have to define a product market and the geographic market, and consider, and also under our DMIR precedent, you look at the broader transportation market. So that includes intermodal. And I guess I'm wondering whether or not it's CP's view that parties can carry their burden in requesting a condition without addressing product competition, geographic competition, or truck competition.
Well, I think the answer is, again, the question is, are there circumstances where you can carry your burden without a thorough investigation of all of those potential forms of competition? I think yes, there are, and this may be one of those cases. Now, there are also, I'm sure, there would be hypothetical.
Real quick on that point, though, under a traditional horizontal merger guideline type analysis, you'd have to address product and geographic competition.
Well, but this may be somewhat metaphysical, but I think that yes, in merger analysis under the Clayton Act, for example, you would typically, although there is a trend in the antitrust world away from this towards direct examination of competitive effects, but typically, yes, you define a market, and you ask the question, in a case of a multi-product firm, so both of these rail lines carry a lot of different traffic. Some of that traffic may be highly truck competitive, where if you shut down the rail line tomorrow, there'd be no effect on competition because trucks are a perfect substitute. And so there's no competitive effect from either getting rid of the rail lines altogether or combining them. None of that matters to competition for maybe some of the traffic on those lines. For other traffic on the lines, rail may clearly be a better transportation solution than trucks or barge or, geographic competition and so forth.
But CP hasn't provided any information or data to help the board identify that.
I think that that's correct in this case. We have not done a movement by movement competitive analysis or provided economic expert testimony. However, I would submit that in a case where we're examining, significantly parallel rail routes that are recognized by the applicants as effectively the only two rail routes serving flows of traffic in a corridor and diverse flows of traffic in a corridor, the board can take notice of the fact that there's going to be traffic, significant volumes of traffic in those kinds of corridors where having rail to rail competition is in fact improving the competitive equilibrium relative to a world where there's no rail to rail competition. It just isn't. We know enough to know. I think the board certainly knows enough to know that getting rid of rail competition serving New England would deteriorate the competitive options, but also the results of it would result in higher rates, worse economic terms, and reduced incentives to provide good service for a lot of that traffic. Not all of it. In a lot of cases, the driver will be truck competition. Absolutely.
Yeah, but you haven't told us how much of it has truck competition. It could, we based on the record you presented, you couldn't say whether or not it's 100%, 90%, 80%.
I think that James may have an informed view based on his knowledge of the types of traffic that CP participates in. So I'll suggest perhaps that he answer that question.
Unfortunately, David, I don't have a deeply informed view of the competitive dynamics.
Let me jump in here for a minute, if I could, Patrick, if you don't mind. In this case, and I realize that these are important policy considerations as a general proposition, I think, David, what you're saying, I'm going to say it differently. In this case, where the applicant has come in and told us at the very outset in their own application, see the competitive problems of our buying in half of PAS. And we're going to tell you before anybody has even asked us for relief, we're going to twist ourselves into a pretzel to avoid anti-competitive impacts. We're going to have B&E come in, we're going to have them control pricing. We're going to subject ourselves to arbitration on capital investments. We're even willing to put a fiduciary in there who controls the decisions rather than us. They came in and told us that this whole thing is anti-competitive if something isn't done to restrain it. And they made all these promises about open access and so forth. So I'm not sure on the state of this record, we're powerless to act unless CP or somebody comes in with an economic analysis of how much of this is truck competitive and so forth. It could be if you had an applicant coming in saying there's no anti-competitive effect and somebody like CP wants to say, oh, yes, there is, they have some obligation to make a factual record. But here you have a concession from the applicant that there's an anti-competitive effect. And the only thing we're trying to figure out is how to make sure their promises are carried out. I don't see the need in this case, unless I'm missing something, to have more of a factual record as a basis for us to figure out how to make sure that if we're going to approve this transaction, there are competitive protections here. Is that, David, I am not trying to argue your case for you, but I am trying to articulate this so we can move ahead. Is that a fair way to think about it?
I think that is a fair way to think about it in this case. And I also think, in addition to the applicant's own recognition of the competition between these two lines, and you could also look back to one of the transaction participants, or excuse me, 2 out of 3 of them pointing out exactly the same competitive relationship when Pan Am Southern was formed. I also, beyond that, I think it is, absolutely within the board's authority here, on the record that we have about the competitive relationship between these lines, and knowing what the applicants have said, which is the truth, that this is a transaction forever. Where, the ownership of these lines, the competitive relationship between these lines is multi-generational. And so if there's, regardless of whether, 10% of the carloads or 50% of the carloads or 80% of the carloads on these 2 routes, or benefit from rail to rail competition rather than other potential constraints like geographic competition and truck competition, over the next 100 years, if there isn't going to be competition between these 2 routes, we know, I think with a certainty, that the transportation environment will be less competitive. And that is harm to competition that the board has authority to remedy.
Aren't you also saying, David, and I was thinking about this when Patrick was focused on the current state of competition, which is not, and I don't mean to suggest unimportant, but just for the reason you said, I was thinking that neither CP, NS, or anybody else can tell us today how you might use these lines if you have access to them over the next 100 years. The nature of freight may change. Traffic, which doesn't exist today, may come into tomorrow that there are customers there that want to use your service. And so we're trying to talk about preserving a rail line for the long term and not just talk about a current antitrust case, I guess. So I think that's what you were saying, that this is could be a permanent diminution in competition if it isn't protected. But,
absolutely, and it's, again, in this case where these are horizontal competitive alternatives that have been active, have been invested in for exactly that purpose. The board has approved transactions for exactly that reason, where the applicants recognize the need to preserve competition. In this case, we don't need to overgeneralize. In this case, I think there's just no doubt that preserving the competitive role of this route is well within the board's authority on this record to preserve.
Patrick, were you finished? Okay.
Thanks, Mark.
All right. I wanted to go back to the commercially reasonable question, David, and if this isn't fair to challenge you at this setting, if you're not prepared, tell me so. But I have been trying to think through in the future. Let's assume we do this transaction and we say what Mr. Foote and I were talking about yesterday are conditions here, which they seem to agree to, that access will remain open at every access point. And as we were talking about equalized rates, which have to, and I guess to me, they're part of the same thing, commercially, which have to be commercially reasonable. And the day comes when you get a rate to interchange at Mechanicsville, which you think is not commercially reasonable. What happens? You come into the board and asked us, tell us that it could be 10 years from now, they're violating a condition. And the violation is that here's a rate and it's not commercially reasonable. How would you prove that to us?
Well, I think I would echo what others have said at this hearing, which is I think the first thing that would happen is if a condition were imposed requiring that rates be such to preserve the commercial reasonableness and keep the gateway open, the first conversation would be with the transaction participants and to try to understand how they thought that a particular rate or approach to rate making was consistent with this obligation that they have. And there'd be a negotiation. And that negotiation may not involve us. It may involve our shippers directly with the applicants, with the transaction participants. And I would actually expect that would be an important part, maybe the dominant part of implementing a condition, and that disputes might avoid the board altogether.
Well, I don't disagree. And, I've said repeatedly, I said yesterday, I've said it since I've been on the board, we much prefer people to resolve these things themselves. And hopefully if we set the right terms, the incentives will be to do that. I guess I was implicit in my question. I'm assuming private negotiations have failed, then what?
Right. Well, then I think, it's probably quite impossible to be too specific in a hypothetical future scenario, but I think the basic idea would be, here are the commercial terms being offered by the transaction participants that, in our judgment, are not commercially reasonable. Why? Because they don't allow for an interchange between CP at Mechanicsville for traffic going across the Pan Am Southern to be a competitive in the market. And in this particular case, probably there would be an examination of what are the factors that bear on whether that rate, is justified by, market conditions, marketplace changes, rather than being explained by a diminution in the incentives to preserve the competitiveness of that route arising from CSX's role in this transaction and INS's, diminished or changed incentives because of its new access to the southern route. We have no illusions about that kind of inquiry being a simple one or a mechanical one. There isn't a way, in our view, there is not a way to impose a condition that is a simple formula. But we do think that having the condition imposed that allows for the kind of inquiry that we're talking about, into whether the competitive viability of this route has been affected by the transaction in a negative way, will create the counterweight to the kinds of steps that might otherwise cause the harm of diminishing its effectiveness. And I don't think I can be complete in saying that without saying, obviously, there needs to be protection on the actual physical capabilities of the route not being degraded in the transaction, and that James was beginning to allude to that.
I know we're going to get to that. So just to finish this point, then maybe we should let James move on, or we'll never get done. It sounds to me, David, like you are saying whether commercially reasonable is an actual fine term of art. It is a concept that is well understood in the railroad industry that can be proved by custom and practice by railroad economists one way or the other on a very case-specific basis. Is that a fair way to think about it?
I think so, yes.
I think if we move in this direction, I would hope we never have to decide such a case, but we have to have some idea of what the case would look like if we're going to take up CSX on its offer to say it will agree to commercially reasonable rates, which they've offered. So they must have an idea what they're offering as well. It'd be hard for them to say they can't understand what it means, since they're the ones who introduced the term into this proceeding. But they'll have a chance to talk to us about it later today. So why don't we, unless our board members want to jump in, why don't we let James get to where he's been trying to get for the last hour? And then we'll finish this presentation.
I think we're here.
Okay.
No problem, and I think it's been a good discussion. I'm not going to belabor the first bullet on here. I think that's been the focus of the discussion. But given that we feel that there is competitive harm, what do we need to see protected? And at a high level, it's maintaining the competitive viability of the route. This is, as we discussed, both a competitive rate basis and then also the physical infrastructure and the service that runs on that infrastructure. We think that you can preserve this environment and do so without having any impact on the benefits of this transaction and what the applicants are trying to achieve. As we discussed, the single line haul, the other benefits that NS gets. We're not asking for any changes to any of that. It is just a set of conditions that allow the competitiveness of the Pan Am Southern route in parallel to the CSX route to be maintained as we go forward. So David, I'll move to the next page to specifically talk to our asks. And, the very first one, you've observed that there's been a number of representations, Mr. Chair, and there's been a number of commitments made both verbally and in the submissions around maintaining that. We would ask that those conditions or those representations are upheld through conditioning on the transaction.
James, let me just say that I believe it's clear on CSX's papers that they have volunteered before we asked them one question that they consent to every representation being made a condition.
Yep.
One of the things we're engaged in here is making sure we know what those representations are, but that's a very important. So I think there's no disagreement on the concept in your bullet point 1.
Yeah, and in bullet point 2, we would agree that based on everything that we've heard, that these commercially reasonable terms have been agreed to with CSX in the public record. So number 2, I think, is well talked about. The next 2, one is around the maintaining the physical condition of the route at a standard that's consistent with what it is maintained at today. We think that the pre-transaction railroad is maintained the way it is so that it's a competitive tool, as we've described, by removing things like the premium intermodal traffic or the highly service sensitive intermodal traffic. You do change the incentives even for the other half owner, and that we want, because of that change, the physical condition maintained. And then finally, you could have a very nice railroad. If you don't run any traffic over, it's pretty easy to maintain it or don't provide any service on it. And so we're looking for through traffic service levels that are consistent with what we're seeing today. And I look at this one and we see, the B&E made representations that they're there to compete and they have every incentive to look after service. We heard the Norfolk Southern talk about them having every incentive to move traffic on this line. And so we look at this and partly why you say it's not that onerous is if they have those incentives, then I would call this sleeves out of their vest. If they're incented to do it, then it's easy enough and it's not onerous and not a burden on the transaction to let us have the understanding that over the long term, we're going to have the service we need. I'd also acknowledge, and we understand, the rail business, that if traffic changes, that this isn't an absolute commitment. You've got to look at what's commercially reasonable around the service levels. And if there's a change in the overall service volumes, that they need to be able to maintain an efficient operation, but they also need to do it in a way that addresses the needs of the shippers on the line in a way that they would have under those same volume levels if the CSX and the NS relationship in this merger hadn't happened, if they continued to be Pan Am independent of CSX. And so that's the last condition we're looking for is.
All right, James, let me ask you a couple of questions because maybe it's a Canadian phrase. This is the first time in this case I've ever heard the phrase sleeves out of the vest. Not entirely sure what it means. It sounds like it means no problem, but here's what I'd like to get at here. In terms of ensuring the maintenance of a condition of the track, that's of the infrastructure, that's what you're talking about. Let's leave the tunnel itself aside. We heard yesterday that was $300 million. But how would you, maybe this is a question for David as well, how would you phrase it? As I understand it, and I'm not on top of these, I'm sure Karen is an expert in this, there are different classes of track that the FRA sets forth and that this PAS line meets certain standards as to freight speeds and so forth. And I don't know what those are, but you're talking about the present condition is at least minimally acceptable if that were to stay that way forever. Is that a way to write? I'm trying to figure out how you would write a condition. It strikes me as problematic to say you've got to spend enough money. Who knows what enough money is? Would it be more suitable to, and would it accomplish what you're trying to accomplish? I'm not saying we would do it, but just to understand what you're asking. If we wrote a condition that said you must maintain the entire route to at least the standards, the FRA standards it satisfies today, would that solve bullet point 3 for you?
Yeah, we're not seeking a prescription on a capital program. Capital can be lumpy. The description of a FRA class of track, and all track has some slow orders. I would have said the slow order condition that we have today, so that however many minutes of delay or are experienced due to a slow order. A slow order is where, due to an emergent maintenance situation, let's say you have a couple of ties or some problem with the ballast that you need to go in and run the tamper, and then you can speed up again. That happens on every railroad all the time. So we acknowledge that that they're going to have a few delays out there, and what we just don't want is if you have 20 minutes of delay today, it degrades and you have an hour of delay 5 years from now.
All right, well, let me go to bullet point 4. How do we make that concrete? I'm not 100% sure how you would define what you're asking. I understand the concept, but I don't know.
I would define it in 2 specific ways. That if current traffic levels are maintained, the level of the frequency of service is the same, and the transit time is the same, consistency. If you have the quality of infrastructure would then come from that. The then second part I would look at is if you have a change in traffic level, there's then maybe you're going to consolidate, and where you're running 4 days a week, you run 3 days a week. I would look at a test on something like the average transit time in those lower volumes are consistent with the average transit time that was experienced, let's say pre-COVID, 2018, 2019, and that on average, you're still delivering the service, even if you have, spikes because you have less frequent train service.
Well, I'm going to reduce this to its simplest form to make sure my simple brain can understand it. Right now, you interchange traffic at Mechanicville. So after the transaction, you're going to drop off cars at Mechanicville, and a B&LE locomotive is going to take those cars over to air, right?
Yep.
And what you want to make sure is that B&LE has enough locomotives and crews to take them there on at least the same frequency that they do now.
Yeah, so if it takes,
Is that what we're talking about here?
yes, that's exactly. So if it takes on average 36 hours to get to air, now it would take 36 hours in the future. We don't, that's how we would phrase it. We're not looking to say you have to run this train service, you have to run, this schedule or anything like that. It's, we get that there's some variability and some operational flexibility they need to run an efficient railroad. They can run an efficient railroad, just keep the transit consistent with where it is now.
Has anybody at CP been in touch with the CSX or B&LE folks, G&W folks, to try to negotiate these conditions? Or have you talked about it? Do they find them acceptable? They made a number of representations that they have every interest of running the line at least as well as it's being run now. So if that's what sleeves out of the vest means, that they shouldn't have any resistance to this. Have you asked them?
We have had discussions, and I would expect that we're going to continue to try and resolve this. We've heard your sort of urging on that front. The service side has been one that is more, let's say, complicated than the commercial side.
Well, one of the things I was going to ask, and it would be much better if it were done jointly than unilaterally, is that your very excellent counsel come up with more specific language of the kind that might be appropriate in a board conditioning order. Not to do our work for us, we have fabulous lawyers too, but so we know with more precision what you're asking for. Then we can judge it, whether we have the power to do it and whether we have the wisdom and whether it's wise. But the concepts you're stating here are quite clear, but as lawyers know, translating those into legally enforceable language can sometimes be a challenge. It'd be better if you did it by agreement. And I'm sure CSX would prefer to do it by agreement rather than have us ultimately order them to do something that they don't find practical. So I would encourage that effort to be done, and to be done quickly, so we can move ahead. We have a statutory schedule, as you know.
We will both, work to reach agreement with the applicants, and we will draft some proposed kind of structure for your consideration.
Yeah, I have. Let me ask this. I know Patrick wanted to make some remarks before we get to that.
Question.
Yeah, before we even get to that, I just wanted to find out from a timing point of view, other than questions or remarks that we may have. David, are you and James finished, or were there other things you were going to direct your attention to?
I think we're finished.
Okay, so let's try. We were going to try to break for lunch, so see if we can finish up with this panel and then break for lunch. Michelle, you had you wanted to have some questions.
I do, thank you. You mentioned earlier that you're requesting conditions to help both CP and the shippers. Have any shippers stated in this record that they want such conditions, or have otherwise opposed this transaction?
I think there has been the comments from ACC that were referenced yesterday that have expressed concerns about this aspect, the aspect of the transaction that we've been describing, the Pan Am Southern CSX relationship. So I think the answer is yes, there have been concerns.
Michelle, did you have more?
Yeah, I think that ACC just asked for adherence to the representations, though. Is that correct?
I'd have to go back and look at their specific submission, which is not front of mind. But I think, as I recall, the thrust of what they were worried about was that essentially the CSX role with respect to Pan Am Southern.
Thank you.
Were you done, Michelle?
I am. I think Patrick. has a couple
Yeah,
questions.
okay. I didn't want to cut you first, that was all. Go ahead. I have some more questions, Patrick. Did you want to go last? Or?
I just only have concluding remarks, but Robert, please.
I just had a
I have
follow-up
one quick
to
question.
I just had a follow-up to Michelle, if you don't mind. So, and just on the line. So, with these bullet points that you have up now, talking about preserving the competition conditions, you didn't mention what we were talking about earlier. We spent a long time talking about the pooling and PAS and CSXT owning 50% of PAS going forward should this transaction be consummated. I mean, do you have a recommendation or any sort of language pertaining to that particular portion of the transaction, a recommendation?
We're not recommending any change to that proposed ownership. We're saying that these competition preserving conditions are required because of it. And I guess I'm not the lawyer, but David, I'll do this anyways, is why we pointed at pooling was more to say that given that there is a potential that there's a pooling relationship here, it allows you to be able to impose these conditions, even if you felt under 11.324 D1 and 2 that may have restricted your ability. The pooling provision would still continue to preserve your ability to put these competition preserving conditions on the transaction.
Okay, I was a little confused. I thought the fact that you were also bringing up pooling, which suggests that the idea itself of CSXT taking over Pan Am Southern warranted that condition to sort of be tripped and for us to act in that manner too. But you're saying that's not the case.
I'm trying to be clear. Two things. On pooling itself, we would not have any objections to an approval of a pooling arrangement in the event that the transactions proposed are approved. But then where we were going with pooling is that even if you felt you were limited in terms of your powers under the 11.324 conditions, that the pooling provision 11.322 would give you the authority to impose these conditions on the transaction. So again, we do want these conditions as part of the transaction, whichever way you feel is appropriate to come to the determination and application of them. But there's two different routes that you can still get to the same place.
Okay, thank you.
I do have another area that I wanted to get into.
I was Karen.
Yeah, I just have a quick
Oh,
question.
I'm sorry, Karen, I didn't see.
That's all right. With respect to the physical condition of the track and other infrastructure, are you aware of any places where the track may be out of compliance with FRA standards?
No, we're not aware of the current specific condition at any location on the track. Overall, this route has been maintained at a level that it has been effective in providing competition into the New England market.
Okay, we would just want to, when you negotiate, the wording of that provision about maintenance, that you're not freezing the maintenance at some level that does not meet FRA standards.
Appreciate it. Thank you.
Were you done, Karen?
I'm finished.
Yeah, okay. There's another area, at the risk of prolonging this for a little bit before we break for lunch, but I feel constrained to at least inquire about it, and that has to do with the divestiture argument or the conditions in lieu of divestiture. First, I'm wondering, I guess this is really probably for David, maybe it's for James. The proposals that have been made for how PAS will function with BNLE as the operator and this management committee and so forth and so on. Do you have any comments, pro or con, or any at all, about the idea that if they can't agree on capital investments, they'll submit it to an arbitrator, and if we don't like that, they will agree to hire a fiduciary to come in and make all the capital investment decisions? Do you have any comments on the wisdom of those ideas?
James, you want to comment? My perspective is that dialogue of yesterday and the potential role of CSX in that decision making, we don't think much of the fiduciary arguments, I think it's fair to say, but it illustrates exactly what we're concerned about, that there could be situations where Pan Am Southern just ends up in a different place in terms of the kinds of investments that get made, the kinds of service that get structured, the delays in addressing market opportunities, what have you, than it would have been had there not been this transaction. And if we recognize that the transaction is a whole, and that it's not. We agree with the applicants that it probably is not in the world of possibility to divest CSX from Pan Am Southern while having the good aspects of the transaction go forward. And so that's why.
Say that again, David. You're not.
We agree with CSX and the other transaction participants that ordering a fundamental change in the transaction risks all of the good aspects of the transaction along with the bad aspects of the transaction. That's why we're focused on trying to solve for the bad aspects only.
So are you saying that if we could craft conditions in accordance with the bullet points that James has here, and particularly if everybody agreed on them, which I actually think everybody is, at least concept, that would offset the need to have this fiduciary come in and decide whether to spend money on the track?
I think we think yes, because it would mean that decision making at Pan Am Southern would have to be adhering to these principles that effectively preserve the incentive structure that exists today.
And what about the $300 million to improve the depth of the height, or whatever you want to call it, of the Hoosick Tunnel? Do you have any thoughts about whether that'll ever get done, and whether it is less likely to get done if this transaction goes through?
Well, we're not seeking that the applicants be held to have to do that, based on the competitiveness that this provides in the market today. We think the line does its job. Do I have an opinion? I think two things: the movement of a intermodal train pair, or the intermodal business, the one train pair to the CSX, certainly suggests that there's no immediate reason why anybody would want to spend that money. You then speculate, as you outgrow the capacity of the 9,000 foot train, whenever that may be, that there would then return the incentive. Obviously, if you had more traffic, it would be more likely to happen. So I think this transaction does extend further into the future the possibility of the tunnel seeing a double stack investment.
But I take it CP is not proposing that we try to deal with that capital investment in an order on this decision.
We are not proposing that at all.
Yeah. The
We're
only
not
other,
looking for anything new or anything that increases competitiveness. We want to be left in the position we are currently in the absence of this transaction.
you don't want competition diminished.
Correct.
Just the final, I'm just curious about it. If you may not want to comment on it because you're not arguing for divestiture, but we were told about the history that 15 years ago or 12 years ago, you were invited in by NS and chose not to join. You had different management at the time, so that may have something to do with it. And you have this a very intriguing footnote, which many of us at the board have read more than once. I assume you wrote it, David. Footnote 6 in your last brief saying, well, you're not arguing for divestiture, you'd be interested in buying the line. If it was ordered, is that what we're supposed to? So you want to sort of comment on the overall interest or lack thereof in CP buying 50% of this line?
Yeah, so I can comment on that. And, you know, as the CSX mentioned, there's a difference between the interest in preserving the route versus the interest in owning the route on that basis. Our concern today, from what we understand of the structure, is that the NS, and I think it was referenced in discussions yesterday, the Norfolk Southern, as part of the joint venture, does have certain rights. The parties have indicated that they agreed that the NS wouldn't exercise those rights in relation to the CSX acquisition of 50%. You know, certainly the NS rights would be a concern, and you know, we'd have to understand where we stood relative to those in engaging the interest as to whether there was a, you know, business case that would justify. We're also, as you are well aware, very busy and involved in making significant investments elsewhere on the network.
I noticed that, James.
So as a priority and as a focus at this point in time, you know, we're probably busy elsewhere.
Can you comment on the dynamic of 12 years ago, or is it not worth taking up time since it's ancient history? Because several of us have puzzled about what this line is worth or what 50% of it's worth. We can't figure out why you didn't join in initially with NS.
You know, I have no specific knowledge of the situation 12 or 15 years ago, so unfortunately I can't comment.
Yeah, and it's probably not worth our waste of time on it. I will, I know Patrick wants to make some final remarks here, but before he does, I just wanted to make one observation that in response to the question Michelle raised, which caused me to think about this. We are going to hear from shipper panels later today, so we can ask them directly. I think most of them are supporting the transaction. It does occur to me when you read everything that was filed by CSX and what it volunteered, it could well be that the shipping community looked at all the promises that CSX has made, the ones that we're talking about here today included, and concluded that overall, if the promises were kept, shippers would be fine, and there was no need for them to go out and spend their own money and hire counsel to join in because the CSX promises were protecting shippers. That may be why we haven't heard any negatives, because they think they're getting their competition protected, assuming these get translated into conditions. You know, it's always speculative about why a witness shows up or doesn't show up, but that might be an explanation. It just occurred to me. That was all I had. Patrick, you want to take us to the lunch hour?
Thank you, and I'll try and be quick. I really do appreciate the questions of my colleagues. I think it was a really useful discussion. I have to say I'm troubled by a few things I've heard today, and I just want to run through them. The first is, you know, I think this notion that the applicants conceded likely and substantial is not quite in the record. They conceded that they were doing things to address the possibility of competitive concerns. And Mr. Chairman, as you rightly pointed out, we are going to consider the transaction including settlements and voluntary mitigation. So I think to evaluate that D1 standard, likely and substantial, should be after those agreements. And so I don't think the mere fact that they came to the table should be held against them as conceding D1. And I think that has the potential to have a chilling effect on the overall thrust that we've been emphasizing, or the thrust of the board to encourage parties to come together. If parties felt that coming to the table meant they conceded important legal standards, we should perhaps think about what the ramifications of that would be. The second is that Norfolk Southern is the beneficiary of the trackage rights, and they seem to evince concern that their trackage rights are in jeopardy if CSX is meant to do additional things on the northern route. In fact, I'm sure that Norfolk Southern in some ways would like CSX to do things on the northern route. And so, CP claims that there will be no effect on NS trackage rights or any effect whatsoever from CSX if we impose these conditions that might compromise the benefits of the transaction. I just wanted to point out that we've heard testimony yesterday from Hub Group and others about the benefits of those NS trackage rights, and the beneficiary of those trackage rights is concerned. So in some ways, in order to buy CP's claim about NS trackage rights, you have to not believe NS itself, the beneficiary. Third is Mr. Myers seemed to suggest that under D, the board could impose conditions even if it couldn't withhold approval. And, I think that, the Seventh Circuit has confirmed, has upheld a decision which the board said they shouldn't do that. The DC Circuit in a major merger said that withholding approval and conditioning is basically equivalent. And I think it's worthwhile to look at the text of D, which says the board shall approve the application unless the two criteria of D are met. Not only likely substantial, but also that those anti-competitive effects outweigh the benefits. It doesn't say the transaction with conditions, for example. So I think you can look to precedent and the text, the command is shall approve, if not for those two conditions. And lastly, looking across the panel, we heard testimony from Mr. Newman and Mr. Wimbish about how the board's conditioning authority is totally unconstrained. It's public interest just like in major mergers. That's what Barrington suggested. That is what the cases, the oftentimes major merger cases that are cited in those briefs put forward that D conditioning authority and C conditioning authority are equivalent. CP's contention is that they are not equivalent. Mr. Myers said that the C authority is broader than the conditioning authority under D, and suggested that the focus should be competitive effects, limiting the focus on other things, which suggests that perhaps we shouldn't wade into areas such as passenger rail. And I think endorse that as a reasonable reading of the statute. And I think there's a tension there. I don't think those views sit side by side, and the board has not yet resolved that tension. And I don't think, because I think we're at risk of basically applying a double standard. A conditioning authority that is the public interest because we need not be limited by the approval authority, and a conditioning standard that borrows part of the approval authority. And I don't think we can have it both ways, or at least we need to think about doing a better job resolving that tension explicitly. And I think the differences in opinion on the board's conditioning authority presented today call on the board to resolve that tension. So I just wanted to make those concluding observations because I think that there are some real concerns raised in the testimony.
Well, let me, Patrick, I'm going to take my prerogative to just respond to a little bit before we break for lunch. I have not meant to suggest by anything I've said, nor do I hear it from any of the participants on either side or any coming from any direction, whether it's the applicant or others, that CSX has conceded a D1 or a D2 standard. I think it's quite clear that as a factual matter, all you have to do with their papers, they have conceded competitive concerns if they don't make the promises they've made, whether they got to the point of getting to a D1 standard or not, that they haven't said. My view is that if all of this is done by agreement, we don't have to resolve that tension in this case. And my penchant in deciding cases, which I learned in law school, is that we should only decide what we have to decide and save the tough decisions for the case where people are at odds and force us to decide, because that's a better factual way to do it. So the tension you point to is astute, and still may be there among board members if we ever get to a case where we have to decide it. But this whole proceeding has struck me as one that is heading towards working these things out by agreement. And we've made quite a bit of progress. There's some remaining parts that we may have to resolve. But if the parties can keep us from resolving it, I think we'll all be better off and move ahead with a transaction, which would appear to have many, many benefits, and the negatives either eliminated or minimized, and that seems to be the goal. So, but I wanted to comment specifically on your observation. We don't want to disincentivize applicants coming in and trying to ameliorate the problems. I don't think we're doing that, because we haven't yet. We may have to, but we haven't said or even observed that CSX has conceded some statutory standard has been breached. So I just think I wanted to make that point on the record.
I appreciate that very much.
Yeah, if we are, I would like to break for lunch, and I would like to finish this panel. Has everybody on the panel said everything that they need to say? And have all the board members done everything they need to do with this panel so we can finish with it? Okay, good. It's been a really robust discussion from all fronts. I think we've learned a lot yesterday. We've learned even more this morning. It is 1:42. Let's break for 30 minutes, which brings us back at 2:12. And we're going to finish this today, I hope. So we may be, well, hopefully we'll go through this afternoon's panels pretty quickly and then get back to the applicants. So we will see you at 2:12. Thank you all.
Thank you.
My thanks to the panel.
Thank you.
Good afternoon, everybody. We are back. We are 1 minute late, which I don't like to be because we have a lot to do. I'm going to immediately call on our next panel. The Maine Department of Transportation, Nathan Moulton, the New Hampshire Department of Transportation, Patrick Herlihy, and Islington Creek Neighborhood in Portsmouth, Thomas Heine. Are they here?
Yes, sir, Mr. Chairman.
All right. So, I called on Mr. Moulton first because that's the order they're listed for me, but if he's not present.
I am, sir.
There you are. All right, you're first. Go for it.
Very good. Good afternoon, Chairman Oberman, members of the board. My name is Nate Moulton. I'm the Director of the Office of Freight and Passenger Services, the State of Maine Department of Transportation. In my role here, I oversee transportation policy and operations across multiple modes, including rail, to the benefit of Maine citizens and Maine businesses. Additionally, I am the department's liaison to the Northern New England Passenger Rail Authority, who is on a later panel, who provides oversight of the Amtrak Downeaster passenger rail service between Brunswick, Maine, and Boston, Massachusetts, and runs over some of the PAR lines in question. The NEPRA's Executive Director, Patricia Quinn, again, will be speaking a little later this afternoon. And let me start by thanking the board to have this brief opportunity, and I will be brief, to help move this along. I do want to note, so State of Maine has a long history of working closely with our railroad partners and operators within the state. We also, by default, sometimes become railroad owners of lines that are up for abandonment that we feel are key to Maine businesses. And working through and with the Surface Transportation Board, have been able to purchase and then lease back to private sector entities that operate them on our behalf. Generally, after putting some capital in them to put them in a state of good repair and back in a fairly good operating condition. Additionally, we work closely with the railroads and customers of the railroads on our Industrial Rail Access Program, which provides funding up to 50% to provide access to the railroad for a customer or someone abutting the railroad who might not have current access or has access, but it needs to be expanded or improved. So we work in that way, both with the railroads and shippers within the state. We have also participated with both state and federal discretionary funds with railroad partners in regards to improvements in yards and interchanges, as well as mainline improvements. We believe that the dollars invested in partnering with the private railroads, even on private infrastructure, is good for the state and good for our transportation system. So I'm here today to once again reiterate the strong support the state of Maine has for this proposed transaction. Following on the letter from Maine Governor Janet Mills back in July of 2021, which the board has on file, we are fully behind this. We think on par. The benefits, especially for the state of Maine, outweigh any of the smaller issues that have been brought up, and I understand why for certain states or certain entities, they may have issues that they want to see looked after as part of this. But again, overall on par for the state of Maine. We are in significant support for this transaction. We think it'll bring substantial benefits to the state and to Maine businesses who rely on rail currently to deliver and receive freight, will also attract new rail freight users within Maine. I think it's extremely important to once again highlight, and a lot of people have talked about it, but particularly here in Maine, we are not aware of any shippers within the state who oppose this transaction, and most have expressed a great deal of optimism and excitement around this transaction. This is foundational to the state's support for this transaction, is listening to those shippers and noting their strong support for this. And I see several of them have submitted letters of support as part of the record. Additionally, I think at least one, Poland Spring, testified yesterday, and a couple more who do business in Maine I think are testifying on an upcoming panel. So I think that's very important. When we talk to businesses in Maine, transportation generally is one of the top two concerns as far as doing business and challenges of doing business in Maine. In particular, rail and rail freight are brought up as challenges. And we get a lot of feedback that the rail system needs to be more competitive. And it's been talked about a great deal by all parties here. And it's nice to see everybody kind of agrees. Here in Maine, this transaction is going to provide more competition, a stronger lane. The current PAR lane will be improved. It'll be safer. We'll have better technology. We'll have better service, more efficient locomotives, all those types of things that folks have talked about. And we think that has great potential to help the state of Maine and Maine shippers. Additionally, the improvements that's been talked about in relation to the Downeaster passenger rail service are very important as well. Again, I won't dive too deep into that at this point. We want to know when the proposed transaction was announced. DOT was very quick to reach out to CSX, and as well as our shippers and other railroad partners, and begin a dialogue on initial questions, concerns that we had or others had around the transaction. For the state of Maine, we found CSX to be very responsive, a willing partner, and started conversations early and often with us, with ongoing cooperation between the parties. And we were able to negotiate a settlement agreement that, again, the board has. I believe it's dated June 16th of 2021. That's been filed. And with the agreement between both CSX and Maine DOT, that be made part of a condition of approval of this transaction, along with, as CSX has stated, some of the other guarantees and things that they've negotiated as they brought to the table in regard to the existing gateways and other things along those lines. I don't want to overlook those. Those are important. But again, we think with what's been negotiated and what's been asked for to be made part of the record, we are comfortable from our perspective that, again, the positives far outweigh any negatives in this transaction. The power lines are very important to the state of Maine. It is our biggest gateway for rail freight. It is the one that is closest to the East Coast, and a great deal of freight from Maine already goes down this corridor, along with a lot of freight is trucked out of Maine and reloaded at locations like Air and Barbers and things like that, and put on trains of the Class 1s. We believe strongly, as you, Mr. Chairman, have pointed out during this transaction, along with the other board members, we echo your comments, the importance of competition. We believe the strong competition between our railroad operators, as well as creating more competition for trucking, is good for Maine business, good for the environment. And we look forward to the CSX keeping their commitments on existing gateways and keeping them open on reasonable terms, along with the infrastructure and service improvements that have been promised. These, if and when they're followed through on, will have a significant impact on Maine for the long term. I want to just, again, talk a little bit, having watched some of the discussion yesterday, the propane discussion. Something like that is very important to us. And we do have a lot of inbound propane here to Maine, and its competition is great on that, because we have several good lanes, both from the Canadian railways as well as across the PAR lines. And so having another stronger lane of that only helps when it gets cold, like It's going to the next few days up here in Maine, and where parts of Maine won't get above zero. Things get tight, and then we got a big snowstorm coming right behind it. So it's important to have multiple lanes and multiple sources of that in case one of the lanes becomes jammed, or there's a strike, or there is something else that may happen. So that redundancy and that competition is very important. Likewise, outbound forest products, which is king for the state of Maine as far as outbound products, is very important to have multiple lanes, the ability to move that product on rail long distances to keep our Maine producers competitive. We can do it on trucks. We're truck dominant. And if we're going to grow business and continue to have starting to have a little bit of renaissance in some of our paper making in regard to box board and some of those other types of products as the companies pivot, as well as some of our sawmills and wood forest products. So we look forward to this transaction helping to continue to grow those and encouraging those companies to continue to invest in Maine. And with that, I'll close. And again, thank you for the opportunity and happy to take any questions.
Mr. Moulton, thank you much for taking the time to talk to us. At the risk of handing you a softball, it's fair to say that from the state of Maine's point of view, and by the way, you should know, I'm sure you do, that the phrase state of Maine gets thrown around inside the STB on a regular basis because of the famous precedent. You see CSX's acquisition of Pan Am with CSX's resources as a plus for your state. But it seems to me that as good as it may be for CSX to be operating up there, it is in the state's public interest to make sure that all the other carriers that currently have access to the gateways continue to have that access. That's equally important to you, would you say?
Yes, absolutely.
And it would be a loss to the state, its economy, if those access points were somehow limited or closed off.
If that was not there, we would very we'd be less supportive or not nearly supportive or against this. I'll use a quick example, and I know we're short on time, and it goes back to the STB. The state was involved in purchasing some lines in the northern part of Maine, which became, in around 2010, became the Maine Northern Railway. We leased it back to the New Brunswick and Maine Railways. It had 23 shippers, very low volumes at the time. It's grown 4 times since that period of time, mainly due to good service by that short line. That time we had no class 1s in the state. We had poor connections, poor relations with the class 1s. Today, we have a very good connection with the CN at the border in northern Maine. We now have the CP operating through the state and a very good connection with the CP off the Maine Northern. And if this transaction is completed, we will have a direct connection through the same short line who acts as a haulage carrier to CSX. So what a turn of event for those lines that had no class 1 connections around their last legs. Now have turned around. We're seeing significant growth, and we'll have access to 3 class 1s through their short line. We would not want to see that changed.
Good. Thank you. Much appreciated. Any questions by any board members? Okay, we'll move ahead. Patrick Hurley from New Hampshire DOT.
Thank you, Mr. Chairman and members of the board. For the record, my name is Patrick Hurley, and I'm the Director of Aeronautics, Rail, and Transit for the New Hampshire Department of Transportation. I'd like to thank you for the opportunity to come before you today in support of the acquisition of Pan Am Railways by CSX. The state of New Hampshire, similar to Maine, we own 6 active rail lines hosting 4 freight lines and 2 tourist excursion lines. And we are very excited by the opportunity to have a class 1 railroad operating in the state. And not just the department, but the governor and key members of our legislature are also excited by this opportunity. This transaction would be beneficial to New Hampshire because it would provide a continuous single line rail service, as we've heard on numerous occasions over the last 2 days, and provide additional resources to improve and market the line, with the potential to bring additional freight service to New England markets. The ability to create more opportunity for freight service in New Hampshire would take additional trucks off the road, which would be beneficial for both the economy and the environment. The department has had numerous discussions with representatives from CSX during this process, and we anticipate that as a result of the acquisition, CSX will bring the necessary financial resources to the table for much needed infrastructure improvements throughout Pan Am's rail network operating in New Hampshire. You saw an example of that yesterday with the Hillsborough branch, the picture that CSX put up of the Hillsborough branch line and the condition that that was in. And we are looking forward to having some improvements done on that line in the future. We are also encouraged by CSX's commitment to honor all agreements currently in place with various shippers and interchange partners, as well as the trackage rights agreement already in place between the MBTA and Pan Am for passenger rail service on the Northern Main Line in New Hampshire. One of those interchange partners, New Hampshire North Coast Railroad, has submitted a letter of support for this acquisition. And the Milford Bennington Railroad, who partially operates on the host railroad, has also submitted a letter of support. And as Mr. Moulton said, in Maine, there have been no shippers in New Hampshire that have come out in opposition of this acquisition. The department also looks forward to working with CSX on our road, bridge, and railroad crossing projects where we need that timely railroad coordination, and they have committed to working with us on those projects in a timely manner. And with that, that's the end of my testimony. Thank you. You're muted, sir.
Thank you, Mr. Hurley. Short and sweet. Appreciate it. Any questions by board members? All righty. Finally, Thomas Heine, Islington Creek neighborhood.
Thank you. Can you hear me all right?
Yes.
Excellent. Okay. Just want to thank you, Chairman Oberman, Vice Chairman Primus, and the distinguished board members for taking the time to allow us to speak today. Before I get going, a couple of things that I just wanted to go back from yesterday that I thought were pertinent to what we're doing. We're going to shift gears a little bit here in all discussions, but coming at you from a local community group and some of the impacts that we see as being neighbors to the railroad. But what I thought was interesting, and I think you need to keep in mind as we go through this process, is some of the comments made by Mass State Rep John Barrett yesterday afternoon, and his comments in trying to deal with the current operator, and obviously the passion and the frustration that he expressed during his comments. We could echo that. We're not going to get into our issues that we're having. We're more interested in talking to you about the process, but that is the playbook that we have seen here when dealing with the operator, the current operator, which would be Pan Am, and as we're looking to possible solutions as neighbors. We get that kind of throwback and it really goes to preemption. We have preemption, therefore we can do what we need to do to move forward and move our interests forwards without taking into effect concerns from the neighborhood. I also want to point out the comments from CSX Chairman Foote in his opening statement, where he recognized the Islington Creek. We appreciate that, and just want to let you know that, and can confirm, they have reached out to us as a group, and we look forward to speaking to them further. And really, this is why we're here today, is to make sure that we're able to move forward in these areas. Okay, so Islington Creek, just to give you a little bit of background who we are. We're a neighborhood in Portsmouth, New Hampshire. Portsmouth, New Hampshire is a port city. We're very proud of the port, the work that's done, and certainly the manufacturers and such that are in this area, and certainly some of those being serviced by the railroad. We're a quiet neighborhood. We're attached right to downtown. So highly residential and high density. We recognize that, hey, the train activities go back here into the mid 1800s, and certainly this switching yard that we have here. We feel that's very important, that anything we ask of the railroad that we take into consideration, that we have customers that need to be serviced, we have interstate commerce that needs to take place, and we've spent a lot of time from our perspective as we move forward and try to have discussions with the railroad about these issues. We recognize the strategic importance of the railroads and the freight system and how important that is to the economy, not just nationally, but certainly here locally on the seacoast, and certainly to their customer base up on the Piscataqua River. Again, our concern is, how do we talk? And this is where I think it's important for the board, as a community group, how do we have discussions on a consistent basis with a railroad in issues that are impacting us when we're dealing with preemption, and how do we balance that scale? And so that's why we're really here today. As you know, preemption removes the jurisdiction from local control for state municipalities. Our concern here is, how do we build up, what do we have within the organization of the STB to level that field, to give us an outlet to be able to voice our concerns and work in a proactive way with our neighbors, the railroad. Typical tools aren't relevant in regards to us as a neighborhood group, where we can go to our city managers and work through the process. So we lose that touch point. And what fills that void? And so what happens to us as a group is we lose confidence, lack of confidence in being heard and understood as to why certain disruptions are taking place. And we can see this consistently, across different communities where issues come up and discussions. How can these discussions consistently be had? Okay. When we look at your website, for instance, we look at your charge, and the agency has jurisdiction over rail rate, practice, service issues, rail reconstruction transaction, including mergers, line sales, construction, line abandonment, period. Now, community is not mentioned in this charge at all. Perhaps it's tied in under practice. But again, as we look through and try to find a department to work with, we get into the Public Assistance, Office of the Public Assistance, and then a group that has informal advisory, where we finally get some community, touch points, some focus on community effort or dealing with concerns. So, we talk about competition, we talk about interstate, the importance of interstate commerce. This is all to drive business, to drive the economy for the citizens. Our concern is, hey, the citizens and the municipalities need a place at the table when we have issues. We don't want to see ourselves or others go through the process we have had to in this particular case to get to this point where we're having discussions or having input into what could be done to work together to try to mitigate some of the issues, okay? And that's what we're really concerned about. In our case, and just let me go through the process of what we had issues. We contacted the operator for possible relief, had some possible solutions that we pushed forward, that we felt, knowing the operation, knowing the customer base, knowing what they had for assets on the ground, that we felt could help the situation. We were never able to get to the next step of having a discussion with the operator. In fact, when we laid this information out to them, they responded basically with preemption and a case saying, hey, this is what, we don't need to go further down this road. This is not a jurisdiction. We're not going to have this discussion with you. And I think it's important that we go ahead and have some robust procedures in place so that other communities don't have to go through the work that we've had to do just to get to this point. And the key here too, and it's very important from our standpoint, we're not looking for litigation. We are looking for solutions, working outside in a non-litigious manner with an operator to go ahead and talk about issues that are occurring as the business grows. Hopefully, I know there's been a lot of talk about that, and what we can do to work together to perhaps mitigate some of the impacts. Okay. What we're asking today is to the STB is a number of things. And to be totally honest with you, I'm not even sure that this is an area that can be considered based on your jurisdiction, but a condition of the merger to protect us, to make sure that we can have, we're not looking for decisions to be made. What all this we want to make sure happens is that we can have a good faith discussion with the operator, regardless of who it is, whether it's Pan Am or CSX in this particular case. And that's really what we're looking for, is how do we go ahead and do that, and how do we protect it? And that's why we asked you as a condition, because we don't feel that the current structure supports continued discussion here, that we put this into the merger as a condition to protect us as we move forward. And as we do that it works through the RCPA as a arbiter or what have you, to help us if we do need to get to that point, to go ahead and do that. In closing, just this has been a journey for us. We started with specific complaints, I guess you would call them, or areas that we were looking to have some mitigation. That never took place. Those discussions didn't get very far because we came up against the preemption and the toolbox that the particular operator uses in these cases to push us aside. So the effort's been significant to get to this point. And I think it's critical as we move forward that not only for the Islington Creek, but for future municipalities, municipality groups, that there is a place or some structure in place where we can quickly voice these opinions and or have these discussions. And that's really where I wanted to close. If you questions, more than happy to take them.
Well, Mr. Heine, thank you. And I think we all appreciate your taking time to talk to us, and what appears to be a fair amount of frustration on the part of your neighborhood association, organizations with which I am intimately familiar, at least in my bailiwick in Chicago. I'm going to make a few observations. One, I would hope that our OPGAC office is responsive and able to help. It sounds like they have been, they always are. and provide whatever assistance they can. It'd be difficult for me to comment on the substance of whatever claims of preemption have been thrown at you, because I don't know precisely what issues you were raising. And I wouldn't comment on the substance of them anyway, because it might be a matter that comes in front of us. I will make a couple of observations, and this is not to cast any negative comment towards CSX, but all of the railroads rely on the preemption doctrine when they can. I'm not sure that will change much here, although I don't know what the issues are. And I can tell you that while there are some very strong preemption statutes that govern us and govern the railroad industry, which we have to follow, questions of preemption are often extraordinarily complex and subtle. The board has a number of preemption cases had since I've been on the board. We have some pending now, which generate a great deal of debate. So it is not obvious at the beginning of any discussion that something is subject to preemption, even though the local railroad person may throw the term around to try to make you go away, or at least spend money you don't have to hire a lawyer to fight it. That's frustrating, and I hope you will bring those issues to our attention. The doctrine of preemption should not be used as a heavy hand on a neighborhood organization's legitimate concerns to at least talk to the railroad. And all I would say on this, at this hearing, not knowing precisely what your issues are, is that I always encourage discussion, and I would very much encourage CSX folks to sit down with you. Our experience with CSX when problems do come up, mostly from the shippers, not from neighborhood groups, is that they do try to respond and sit down and work things out. I think they have a good attitude in that respect. I am sure they're listening. So I'm going to invite somebody from CSX to send you a proper contact information so that the two of you can sit down. It does not sound like it's the kind of thing that would be a condition in an order. I don't want to prejudge it, but I sure want to encourage the two of you to meet and get together and work out your problems. I'm a strong believer in that. If I were an alderman and the alderman in your neighborhood, I'd make sure it happened, but I'm past that part. But I've done it many, many times, including with railroads, by the way. In my own, we had a railroad that ran through my ward 40 years ago, so I had some experience with that. So I don't know if that gives you any comfort, but I can hear the frustration in your voice of trying to deal with a large organization.
Yeah, and just to be fair to CSX, they have reached out. I wanted to make sure that that was clear. That's a little bit of a breath of fresh air. We want that to continue, and look forward to that. And again, we're just a local neighborhood trying to work our way through this process. Your group, the RCPA, once I realized that they were there, have been very responsive in regards to phone calls, those types of things. Not most people know that it exists outside of the industry. I can tell you that based on discussions we've had with the municipality, keeping them up to speed.
Listen, our whole agency is little known to hear some people say it. The Railroad magazines called us that sleepy little agency last summer, and I have yet to find anybody at the board who's gotten a decent night's sleep since I became chairman. So we're not a sleepy agency, but we aren't well known. I just did hear, by the way, from Janie Shang, who is the director of OPAGAC, and she said she well remembers your contacting the office, and that Pan Am didn't accept the invitation to try to sit down, but I am sure Jim Foote will accept that invitation because he's listening right now, and I know Jim well. Let's.
They've already proactively got into that. So thank you very much, Mr. Chairman.
Well, that's great, and we stand ready, hopefully, to help make sure that conversation continues. Any questions by board members for Mr. Heine? Okay, thank you.
Thank you.
Much appreciate your taking the time to be here with us.
Thank you much.
All righty. So let us move on to panel number 7. These are shippers. So let me call out the names in order. I think everybody is here, or hopefully if they're not, they'll be here soon. Bob Lefevre of Eastern Propane Gas, Hillel Weissel from Fabian Oil, Marjorie Shansky on behalf of Frost Bridge Associates, Charles Giroux, Mid-States Packaging, and 2 people who I hope are here today who were not able to stick around yesterday, Seth Hankowski from All States Asphalt and Sarah Cohn from Blue Triton Brands, Poland Springs. So if those folks are with us, let us start with Bob Lefevre.
Good afternoon. Thank you, Mr. Chairman. Thank you, board members, for allowing me to speak today in favor of the CSX purchase of Pan Am. Quick bio. My name is Bob Lefevre, Vice President here at Eastern Propane and Oil, located in Rochester, New Hampshire. I've been employed with Eastern for 35 years. Eastern is family owned and operated and has been since 1932. Currently, we serve 93,000 customers within 5 New England states. As part of Eastern's supply infrastructure, it owns and operates one of New England's biggest rail facilities, which services 24 locations scattered throughout New England to service those customers. We work closely with our short line, NHN, and also with Pan Am, and have done so well over 35 years. In my opinion, and again, this is in my opinion, if things don't change, we will continue to see diminished service and ability to utilize rail as a viable transportation source. If service by rail diminishes, that would leave Eastern and companies like Eastern with less options to fulfill their supply hubs. If we understand the infrastructure of how energy is brought into New England, there are 3 possible areas in which that can happen. We can do it in New York by the pipeline. We can import it through 2 import terminals, one located in Providence, Rhode Island, another one's located in Newington, New Hampshire. Again, let me reiterate that, import terminal. And the last but least is domestic rail product. It is imperative, in my opinion, again, that we allow this to go through. This has to happen. Again, my history with Pan Am goes back to B&M days, if people can remember those days. We were excited then when Pan Am took over that line. They increased service. And we expect the same will happen with the CSX purchase of Pan Am. We will see the increased service, consistent, rateable delivery that we need on a continuous basis, daily, in order to keep the trucks filled, in order to make the deliveries to the consumers, to the hospitals, to the manufacturers, and everybody in between. Propane, as you know, is a green product. It's only going to continue to grow in its volume. And we need a strong infrastructure here in New England to be able to handle that additional growth. I'm sitting here today in front of you, throwing my support 100%, and so is the company's position, that we need this to move forward. There was a question posed yesterday by one of the members to a member of the CSX team that said, what keeps you up at night? Well, as a shipper and a consumer, I'll tell you what keeps me up at night, wondering if I'm going to receive my rail the next day. And it is viable that we do receive that steady service. If not, we can't fill the trucks. Those trucks need to roll every day to make those deliveries. We do not have the capacity to wait on the rail. We need those cars. So what happens? So we govern our supply needs based on what we project the rail can handle. And in this case, we are being hamstrung. We are not utilizing our facility to its 100% potential. We feel CSX will allow us to continue to bring in domestic product, which will only benefit our consumers with cheaper product. Again, let me reiterate, we operate in Rochester, New Hampshire. It's about 100 miles from Selkirk, give or take. The import terminals, we pay a premium for that. We're bringing that from overseas. Again, the best option for consumers is a strong rail system to bring this product into the New England market. And with that being said, Eastern Propane, myself, wholeheartedly behind CSX purchasing Pan Am. And with that, I'll answer any questions you may have. Thank you.
Yes. I take it you were listening in. Is it? I think I mispronounced your name, Bob. How do you pronounce it?
Lefebvre.
Lefebvre.
Yep.
Okay.
Very French. Quebec.
Yeah, I read all the letters that were there, so I apologize.
Yes.
You heard the discussion yesterday that I was having with the representatives of CSX as we talked about the propane supply coming in from various rail sources.
That's correct.
Yeah. So does your company rely on those competitive options today about various ways you can obtain your propane, either up through Bangor or through Selkirk or Mechanicville or however it gets to you?
So we try our best to utilize other lines to come in, but I will be upfront and honest with you. A lot of our product is coming in from the shale area, Pennsylvania, Ohio. We also get it in from Sarnia. We bring product in from Calgary. Calgary, we use CP down through New York and Selkirk. So yes, to answer your question, Mr. Chairman, yes, we do use other avenues. But I will say this, that we use CSX for 3/4 of what we bring into ours. Why? It's a direct route. It's the quickest shipping route for us to use CSX. CSX has provided outstanding service. We track our cars every day. From origin to every switching yard, we know exactly where they are every day, and we watch these cars move, and they move consistently across the CSX line. I will be missed if I said to you it's perfect service. It is not. There are times when there are holdups, and we understand that, but they're not consistent on a basis where we would object. But once they come into New England, the transit times double. This is what we're up against. And again, because of the turns of those cars, the suppliers or the midstream companies that we deal with have to charge a greater amount to turn those cars. And let me just give you, for instance, if we can turn a car in 2 weeks, the cost is this. If it takes us 30 days, the cost is this. And that's what's happening to us right now. It's happening that it's taken 30 days to turn a car, which typically should turn, they should arrive to us within 7 to 10 days. We unload it and it should go back to them in 7 to 10 days. We know that's achievable. And with CSX help, it will be achievable.
Well, and is the reason for the slow turns now the service you're getting from Pan Am?
It's the congestion, and I know I've heard a lot of discussions with passenger trains. Like I've been at this a long time. Pan Am, they provide outstanding service to us. I mean, to the point in the early days that they would actually take a train and a crew and go get some cars for us if we so needed it. They would do that. They can't do that any longer. I feel like our service started to diminish when the Downeaster came on board in the corridor in which we're located. Why? That Downeaster needs to run up and down that track a couple times a day. So that doesn't leave Pan Am the ability to run up and down that track during the course of the day. So what do? They run trains. They run full trains from Massachusetts, Barber Station, Deerfield, up to Portland, to Rigby Yard. They stage them, they put them there. And sometimes our cars will sit there in Rigby and Portland for an additional 3, 4, 5 days. And if something happens from the Portland yard to where we make the handoff to NHN, it becomes congested. We ship cars ratably almost daily. 3, 4, 5, 6 cars a day. This time of year, it might be 10 to 12. There are times that there are 60 plus cars sitting in Rigby waiting to come to our facility. Do the math, 30,000 gallons for each one of those rail cars. That's a lot of gallons that are sitting that we need turned. Again, I'm not laying blame on Pan Am. They're doing what they can. Again, I felt like service started to diminish when that Downeaster started to use that main line.
Well, it sounds like I don't hear the Downeaster going away.
No, I don't either. But my hope is that some infrastructure money will be put in so they can put side tracks in so they can bypass each other. That's our hope. I mean, again, and I guess I can't say this enough. And if I get animated and excited, is because this opportunity that's presenting itself here today is going to allow a company like ourselves to utilize our facility in the manner in which we built it. It's going to allow our consumers to enjoy pricing that is favorable without us having to go to the overseas market and bring in that premium product. So yes, Mr. Chairman, you're absolutely right. The Downeaster is not going away. But our hope is that they can have at least a bypass rail that they can pull aside, let the train go by, and continue to service their customers during the course of the day, instead of having to do it at night, because that's what's happening now.
Well, is it your hope that CSX will invest in a siding that will allow this to happen? Or why do you, I'm trying to relate to why you think CSX will avoid this coming in, will avoid the problem if it's a structural infrastructure problem?
Based on conversations, they understand the challenges, that being a Class 1 railroad, I think they understand those challenges, and they probably have workarounds in the capital to create those workarounds. Maybe to increase the tonnage on the track so they can move when they're coming back south after they staged them in Rigby to come back south. Maybe they can pull more cars back. Instead of using just one engine and one crew, maybe they could put three engines and a few more crews to pull those cars down at a greater capacity than what's happening now. So there would be other options that we don't have now.
All right. Has CSX made any commitments along those lines to you?
They have not. They have not. No.
I want to get back to the competitive options aspect of this. You say that most of your purchases come through CSX, but do you see it as important to your ability to negotiate for the best prices to be able to have those other options as bargaining tools?
Oh, absolutely. Oh, it's imperative. It's imperative because, again, year to year, the infrastructure in the propane world changes, and I can go back many years. Sarnia was a main hub. Western Canada product was main hubs. Most of the product coming into New England in those days were coming from CN and CP. They would come down, and SLR would pick them up, and then Pan Am would pick them up from there. But yes, I do feel that we need that to keep New England open. Those other avenues open to allow that competitive advantage. Absolutely. You got to keep, it's got to be those checks and balances. So yes, I'm fully supportive.
So I'm going to summarize. You, as much as you love CSX, you love that competition too.
That's, I think that's in all of us, isn't it?
Well, you know what? After I've been at the board for 3 years, I don't know.
Yeah. Understand.
Yeah, no, but no, I much appreciate it. I don't want to dominate it. Do any other board members have any questions? All right. Well, thank you very much for
thank
your
you.
observations. It, you
Thank
know,
you so
it's
much.
really helpful always to put these broad concepts and the statutes we've been talking about, so forth, into the hands of a real world person who needs to function under those statutes. So thank you.
And so is the consumer. I mean, so we need to think of that aspect as well. So the stronger that we can build the infrastructure, the better off everyone. So, so thank you again to all of you, and you have a wonderful weekend.
All right.
Thank you so much.
Thank you so much. All right, Mr. Weisel, I'm not sure.
Weisel, good afternoon.
Weisel. Thank you, sir.
Mr. Chairman, members of the board, thank you very much for letting me speak. I don't know if I could say much more than Bob. He really, he wrapped up the best possible picture for support of this transaction that the propane industry could put forth. You know, as far as Mr. Moulton from Maine DOT is concerned, you know, Fabian Oil is working closely with DOT on our current project here in Waterville, and we do mirror his support for this transaction. I might probably just say that my comments are going to seem trivial to the last couple of days of a testimony, you know, the antitrust and competitive or anti-competitive nature of this transaction, but I think they're no less important. I want to speak to just briefly, you know, the boots on the ground and what we feel the benefits of this transaction to the people of Maine, both consumers, the suppliers, and the jobs created and maintained in Maine. Fabian has made a commitment to bring propane to central Maine. You know, we support trucking. We operate a large fleet, but we really can't depend on trucking to meet the growing demands here in Maine. It's a growing population, and you know, the prior testimony spoke to trucking as an alternative, but it's no longer a viable alternative, and I think rail is the absolute necessity to keep up with what we need. If you look at the current landscape in trucking, there is quite a bit of a crisis in trucking, depending, you know, all over the country. We'd be in trouble without rail. Without investment in improving and increasing rail in Maine, we won't meet the demand inclusive of trucking. The equipment and the drivers to operate them are just getting harder and harder to find. With that said, the rail is a far safer means of transporting the volume of product we're looking to transport over the distances we're trying to transport it. It's more economical and efficient, and we need to increase and improve our rail system. Fabian has a decades-long commitment and investment to improve Central Maine's rail infrastructure. What we're doing is not something we could decide one day to roll up and move down the road. What we're building will remain for future generations as long as rail operations continue. And here in Maine, I'd like to just add that, you know, propane is it's not a discretionary product. It is cold up here. It's a necessity of life, so to speak, up in Maine to keep people warm. We don't see currently a commercially viable alternative to propane and fuel oil at this time. And what we want to accomplish and with this project and what this transaction will help us do is improve security of supply, ability to meet growing demands, protect the residents of Maine and those who work here. What CSX, we feel, and maybe the optimism in me is getting the best of it, but you know, the capital investment that we think and feel that CSX will put into the system, they'll add stability streamlined logistics, more direct and efficient communications, and most importantly, safety. Our product has, you know, people look at it in one way, and it is a very safe product, but we want to improve the rail system and add greater safety. And we think CSX is gonna do that for us. And I don't really have a lot more to say. I think that Bob summed up the industry opinion of this in the Northeast. But I think it's critical that we support this transaction for improving the rail system up in the Northeast, especially up here in Maine. Thank you for your time. I appreciate it. If there's any questions, I'm more than happy to help you.
Just a couple, Mr. Weisel. You're located where in Maine?
So our company is located in central Maine, in Oakland, Maine. The rail terminal that we are currently constructing is in Waterville.
All right, and the company's Fabian Oil, but it sounds like your product or one of your main products is propane.
So Fabian, it's a multi-product company, but our retail or energy division is propane and oil. That would be the main focus for our business. We do have a gasoline and C-store business as well.
What would you echo Mr. Lefebvre's opinion that keeping these options for getting propane through different carriers through the existing exchanges is imperative for you to be able to negotiate your best prices?
I think options are always important, you know, regardless of what products and means of transportation we're talking about. I would also add that stability and security of supply and logistics is critical, continued and improved means of transportation. So yeah, but it's important to have the competitive nature, but it's also important to have somebody you can rely on who's going to get the product to us to deliver to people in critical times of need. And I mean, you know, right now we're barely going to push 0 degrees tomorrow at the high, and the product needs to be there.
But do you rely on the fact that those gateways have been open to enable you to negotiate better with whoever is supplying you?
I think, you know, well, first of all, let me just add that we don't currently have an operating rail terminal here. This is the first. This will be the first one here in the Waterville or in the mid-Maine section or central Maine. So I can't really comment on it. In my experience in Connecticut, I've been dealing with Pan Am Southern for 8 or 10 years before I moved up to Maine. And it was always important to have channels, negotiate how you brought it into the short line, but I think it's also important to rely on service as well. They're equally important.
Yep. Okay. It's warmer in Connecticut. I went to school there.
I'm getting used to it up here in Maine. It's as they say up here in Maine, it's chilly.
Come to Chicago. All right. Thank you very much for your observations. Very helpful.
My pleasure. Thank you very much.
Do any of the other board members have any questions? Okay, moving along.
I do, Mr. Chairman.
Oh, I'm sorry, Karen.
Just one question.
Right
I've just read that there was a train that derailed in Biddeford, Maine, a couple of days ago, overturning 2 propane tanks, but it looks like it was quickly contained. How often do propane trains derail up there in Maine? Is that a frequent occurrence or?
So I will tell you, I've only been here since March, and those are the first, that is the first occurrence and the only 2 cars I know of that have derailed. In Connecticut, we did have some derailments from time to time. We never had, while I was there for the time that I was operating a terminal, overturned cars. Most of the time it was, you know, wheel skips track and they got to put it back on. This one, you know, and luckily these were 2 cars that overturned. There were minor leaks and it was contained. And I think it was an hour and a half that the incident was contained.
That's good to know. Thank you.
Thank you. Any other questions? Okay, we will move along to Marjorie Shansky.
Thank you. Good afternoon, Mr. Chairman and ladies and gentlemen of the board. I'm attorney Marjorie Shansky here in Connecticut, where it's warmer than Maine, but not this weekend. And we appreciate the opportunity to participate in this public hearing. I'm here on behalf of Todd Perry, who is facilities manager at Frostbridge. Frostbridge has a place of business in Watertown, Connecticut, and for a number of years, Frostbridge has operated pursuant to a permit issued by the state of Connecticut for a solid waste volume reduction facility. The facility is a critical resource and an important participant, in implementing the state's solid waste management plan. In its operation, the facility relies both on truck and rail service, with rail service accounting for approximately 2/3 of the material transported, which is in excess of 100,000 tons of solid waste annually. Currently, Frostbridge is serviced by the Naugatuck Railroad Company from the facility to Waterbury. Pan Am Southern continues the transport from Waterbury to Hartford and Springfield over Amtrak Rail, around the north of Albany, New York to Rotterdam Junction, New York, at which point CSX takes over for the remaining route to the final destination in Lordstown, Ohio. There are inefficiencies associated with this itinerary from an operational perspective. Frostbridge is supportive of the proposed merger, resulting in CSX having control of the routing and transport from Waterbury forward for the operation for a number of reasons. The upgrade of track to Class 1 will result in significant improvements in efficiency moving material, including a reduction in travel time between the facility and its Ohio destination. This efficiency will in turn result in Frostbridge's ability to sort and transfer additional material at the facility, which benefits not only Frostbridge, but the state of Connecticut in its significant efforts to manage solid waste. Millions of dollars of private money will be used to perform the system upgrades, and that represents a significant public benefit. Modernization, as others have said, of the rail system will enhance service consistency, reliability, and safety. And finally, on average, railroads are 3 to 4 times more fuel efficient than trucks. That means that moving material by rail instead of trucks lowers greenhouse gas emissions by up to 75% on average. With increased efficiency associated with CSX's operation of Frostbridge's rail transport from Waterbury forward, Frostbridge can increase its reliance on rail and eliminate an additional 1,000 to 1,500 truck trips to Ohio from the facility annually, with the resulting reduction in greenhouse gas emissions. In summary, Frostbridge recognizes and supports enthusiastically the proposed merger as a means of improving our local, state, and national response to management and control of solid waste and increased recycling. And we appreciate very much the opportunity to have participated this afternoon. Thank you.
Thank you very much for coming to talk to us. I'm just a little curious, what is it that's going to facilitate your moving more freight on rail once CSX takes over, if this transaction goes ahead? I'm not quite clear on, is it because you can ship more carloads because the track will be of a higher caliber? Or
correct.
Is that the reason?
That is a very significant reason.
Yeah, okay. And you're counting on that. And where is the track that you're talking about that needs to be upgraded? Is it on the north-south route?
It is, well, it happens to be in part from Waterbury to Hartford, but and more particular than that, I'm afraid I can't be. I am speaking to Mr. Perry, but I'm not Mr. Perry. But if you'd like, I can find that out. and add it to your record, which I know is remaining open.
Yeah, well, it might be helpful. I'm just I'm trying to picture the map. You go directly north-south up to the Pan Am Southern and then over to Rotterdam, right?
Correct.
So it's the north-south part which is problematic, as you understand it.
As I understand it, but again, I would be very happy to verify that.
All right, and I take it that for your purposes, the only way you can get to your destination in Ohio is on CSX. Once you get to PAS, you don't have any other options to get to Ohio.
As I understand it, that is correct.
Yeah, okay. All right, thank you. Thank you very much. Does anyone else have questions? All right, much appreciated.
Thank you.
Tell Mr. Perry you did an admirable job.
I appreciate it.
Okay. Next up, Charles Giroux. So I'm not sure Mr. Giroux was.
Hi.
Is he here?
Can you hear me?
Yes, I can.
I'm
hear you.
here.
There you are. Go for it.
Hi. Thank you, everybody, for listening. I own Mid-States Packaging and Distribution. We have locations in Portland, in Air, in Leominster, in Fitchburg, and on the G&W, we have locations in Worcester, Mass, as well as Auburn, Mass. We run distribution and transload services for the plastic and chemical industry, as well as paper in our distribution center in Air. We are in full support of the CSX taking over the operation. We think that the investment that they'll bring in will be significant and add to a reduction in the amount of inventory that needs to be kept on the rail due to the service. A lot of the materials that we handle are quite expensive, where cars can run upwards of $200,000 per rail car. So every day we can reduce that transit time, means that less inventory needs to be carried. As I said, we do the trucking and on the last mile, and we want to try to get the goods and materials that go to the manufacturing sector to them as efficiently as possible. And as I said, we're in support of this. And any questions?
Yes, so I'm, as you can tell, I am curious about the network aspects of each person who's speaking to us. So do you, what carriers are you using now in your business operation?
We use both NS and CSX, as well as G&W in Worcester and our Auburn locations. So we touch all of them.
And the G&W, do they then interconnect with what other class ones, or where do they go to?
They connect up in Gardner with the NS, and they connect in Worcester with CSX. So right now, today, our location in Auburn and Worcester can get serviced by both and avoid the entire Pan Am system. And then our locations in Maine, as well as Air and Fitchburg and Leominster, are serviced by Pan Am Southern and ST.
And so for your business, I take it you're going to, if this deal goes through, a meaningful amount of your business is going to continue to need Pan Am Southern.
Yes, I don't see any way that it really can't. I don't think that there's enough facilities to handle not using the Pan Am system, especially up in Maine.
Well, up in Maine, but what about, it sounds like you use Pan Am Southern, the Patriot route as well for some of your travel.
We use Pan Am Southern for our warehouse in Air, as well as our Leominster and Fitchburg locations. And then we use the G&W for our Auburn and Worcester locations.
All right. Where is that Pan Am Southern traffic going?
It's coming in from the Gulf Coast of Texas.
Oh,
primarily.
You use it mostly for incoming, is that what you're saying?
Yeah, we don't do any outbound shipments. We just deliver it to the local manufacturers in the nearby.
So the traffic that comes in from the Gulf Coast, is it coming from places that are sole served by CSX, or do you have options?
No, most of them are on the western part of the United States, so that they can go through either gateway, either an NS gateway or a CSX gateway. So they do have the option. The general, it's UP or BN is generally the origin railroad, so they can come through the gates.
So, because I was trying to understand if you receive materials both through the Rotterdam interchange and the Mechanicville interchange?
Yes, we do.
Yeah,
Selkirk and from Mechanicsville. So we do get them both. We get them from NS as well as we get them from CSX.
all right. So both of those interchanges are important to you.
Correct.
Yeah. Okay. All right. Thank you very much. Anybody else have any questions? Much appreciated. Thank you, sir.
Thank you. Thank you.
All right. Next up is Seth Hankowski, who I hope was able to join us. He wasn't able to stick around yesterday. Is he here? Oh, well, apparently he's not. If he comes in later, we'll try to get him in. And I had previously said that I thought Sarah Cohn, who couldn't stay yesterday, was also going to speak today, but I understand she is not here today. So if that is the case, that ends panel 7. Does anybody feel like we need a break, or should we try to go right into panel 8 and see if we can get through that before we break? It's a short panel. Hearing no objection, that's what we're going to do. The next panel is Northern New England Passenger Rail Authority, Patricia Quinn, New Hampshire Central Railroad, Edward Jeffrey, and Lewiston Auburn Railroad, Jonathan Labonte. Okay. Is Patricia Quinn here?
Yes, I am. Good afternoon.
Oh, there you are. Okay, go for it.
All right. Well, thank you very much for this opportunity, Chairman Oberman and members of the committee. My name is Patricia Quinn, and I am the Executive Director of the Northern New England Passenger Rail Authority, referred to as NEPRA. NEPRA was created by the Maine State Legislature in 1995 and is the state sponsor of the Amtrak Downeaster Intercity Passenger Rail Service. The Downeaster makes 5 round trips every day along a 143-mile corridor between Brunswick, Maine and Boston, Massachusetts, serving 12 station communities in 3 states. Since its launch in December of 2001, the Downeasters transported more than 8.2 million riders, the equivalent of 674 million passenger miles. In Maine and New Hampshire, the Downeaster operates over rail lines owned and operated by Pan Am Railways. And then the track we operate on in Massachusetts is owned by the MBTA. For more than 2 decades, NEPRA's negotiated and collaborated with Pan Am Railways to plan and manage over the investment of over $130 million of public and railroad infrastructure, safety, and maintenance projects in Maine and New Hampshire. And these have been funded by state and federal funding partners. The capital projects we've invested in have rehabilitated 106 miles of track and signals, including replacing stick rail with continuously welded rail. We've restored or replaced more than 10 miles of double track. We've replaced over 150,000 ties and refurbished more than 50 grade crossings. We have an annual maintenance program that supplements Pan Am's limited resources to address more routine repairs and deficiencies that impact the reliability of all trains, like degraded track components, surfacing and crossing panels, vegetation management, and drainage issues that, but for our involvement, would probably not be addressed. This public-private partnership has resulted in both public and private benefits. These projects have been necessary to initiate, sustain, and improve and grow Downeaster service. We've been able to reduce our travel time, increase frequency, expand the service reach of the service, and we reached, exceeded our ridership goals pre-pandemic. And this has all been accomplished while improving safety, supporting private development in and around our station communities. But further, these projects have not had any negative impact on freight, but have actually contributed positively to the efficient movement of freight. And in fact, because of these investments, much of the maximum authorized speed for freight has increased from 10 to 25 miles an hour up to 40 miles an hour on the segment on which we operate. Over the past year, CSX has worked collaboratively with us to learn more about the Downeaster service, about our business relationships and our goals and priorities. And they've committed to support the success and growth of the Downeaster service. They're going to do this by fulfilling their obligations to Amtrak to reliably accommodate and dispatch Downeaster trains, and collaborate on the installation of a positive control system on the corridor in Maine and New Hampshire, which will be funded by Amtrak, as well as the operation and maintenance of that system. CSX is committed to abide by our agreement with Pan Am to extend 6 more miles of double track at a frequency and build a second passenger platform in Wells, Maine. This project is funded primarily through a Chrissy grant that was just awarded to us not too long ago. And CSX is committed to cooperate with us on future Downeaster enhancement projects, including those to relocate of the Portland station, to add a new main station, increase frequency, and reduce travel time. The pledge that CSX has made to adequately maintain the railroad and invest in infrastructure improvements that improve the efficiency of freight operations really creates new and exciting opportunities for both freight and passenger customers. NEPR supports this proposed transaction, subject to the letter agreement that we have with CSX dated August 3rd, which I believe you have a copy, and looks forward to a robust and productive partnership with CSX that's focused on preserving and protecting the public interest and the public investments that have been made in this corridor to sustain and expand a thriving and quality passenger rail service. We also hope to leverage the resources to achieve strategic and mutually benefit objectives and partner to develop a strong and modern railroad network that supports the safe and efficient and reliable movement of people and goods throughout our region, protects our environment, and strengthens our economy. Thank you very much, and I'm happy to answer any questions.
Karen had a question.
Ms. Quinn, it's great to see you again. And I, first of all, just want to congratulate you on the terrific work that you have done with NEPR. I do recall from my time at FRA working on one of the early grants from the Recovery Act that we had some frustrations with your host railroad, and certainly you've done a great job since then, and I wish you the best in working with CSX.
Thank you very much. Appreciate that.
I'd like to briefly echo Karen and commending Patricia for her leadership.
Thank you. Robert, did you want to?
I'll jump on that bandwagon and commend Patricia as well. But I also have a question. One of your predecessors who spoke on a panel previously up from Maine and a shipper had voiced some concern by saying, I don't know if you heard that or not, that since the Downeaster started, there's been a slowdown in freight traffic. He seemed to attribute that to the Downeaster. And one of the things I'd like to hear is this transaction, a lot of it's talking about from the freight side. There's also that concern about, how it's going to impact the passenger rail. I know you've been talking to CSX about, working together. How do you see going forward, the Downeaster continue to play a vital role in passenger rail, while also partnering with CSX as they seek to grow on the freight side?
Well, again, I think that the investments that we've made because of passenger rail, it really have had a positive impact on the movement of freight. So I was a little bit, I was disappointed to hear those comments, but anyway, we have worked with CSX, and double track is something that we obviously support. I mean, this section of railroad, there's a lot of signal track out there, which is why we just finished a 4-mile siding extension. We have a 6-mile siding extension that we're doing to improve the reliability so we can all get around each other. And again, we've invested a lot of resources. A lot of it has been in kind of maintaining some of that status quo, which I've heard others talk about. And what I'm really hopeful for is that with CSX's resources, that we can really focus on our efforts on leveraging, the resources that are available to do some bigger things that really benefit the railroad in a bigger way, like more double track, like the installation of the positive train control that Amtrak has gotten funding for. So I think that there are really some important and key investments that are really on the horizon that can really be a game changer, help us grow and also support freight. We're an agency that was formed by the Maine state legislature. So the economy of our region and our state is as important to us, not just passenger rail. And so the movement of all of the freight and the passenger is something that we've supported all along. That's why we've been able to have such a robust relationship with Pan Am, because it was never, a benefit but for passenger rail or just for freight. These are benefits these are improvements that benefit the system. And, I know it's an old cliche, but all ships rise sometimes go up with a rising tide.
I agree. And one last question. Do you foresee continued growth on the down on your line in terms of potential of more trains, or are you sort of settling where you are right now in terms of the number of trains that you run up and down the line?
Well, right now we operate the 5, and then once this Wells project is done and positive train control is installed, we'll go to the 6, which will be an inbound commute line into Portland, or another run. We are, I think, looking forward. I mean, obviously, as we get through this pandemic, but the service really reaches such a wide variety of riders, and people travel for such a wide variety of reasons, and connecting the rural communities of Maine to the economic center of New England and beyond is critically important. So I think that our hope is to grow in the future. And that's why we've asked CSX through our agreement to leave that door open, and they've agreed to do so.
Thank you.
Any other questions? Thank you much, Patricia. I will say that it does sound to me like it's not really the downeaster, but it's the need for more infrastructure that may alleviate whatever Mr. Lefebvre's concerns were about getting the propane when he needs it. I have experienced over the last 8 years many complaints from passengers about freight delays, but I have never had a freight shipper complain to me about passenger delays. So that's a new one. But it sounds to me like between you and him and CSX, this is going to get improved, or at least that's the hope. Much appreciate your time.
Thank you.
Particularly since it's 1 degree up there and you need the propane. Mr. Jeffrey, Edward Jeffrey. Is he here? New Hampshire Central Railroad. Have we lost Mr. Jeffrey? Okay, apparently he was not able to join us today. If he does, we'll call on him when he gets here. Jonathan Labonte, Lewiston Auburn Railroad.
Good afternoon.
We can hear you.
All right. That long silence. Thank you very much. Members of the board, on behalf of the board of directors and shareholders of the Lewiston Auburn Railroad Company, I want to thank you for the opportunity to offer testimony today in support of the proposed acquisition of Pan Am and its associated companies by CSX. My name is Jonathan Labonte. I serve as the president of LARC and previously served for 6 years as the mayor of Auburn, Maine. For context, let me introduce you to LARC and the scope of our work in Maine. We were chartered by the Maine legislature in 1872 LARC is a private railroad company whose shares are owned entirely by the cities of Lewiston and Auburn. Our primary charge 150 years ago this year was to construct a 5.5-mile rail corridor from the Textile Mill District on the Androscoggin River in Lewiston to an interchange with the Grand Trunk Railway, which ran from Portland, Maine to Montreal, Quebec. Upon completion of construction, our line was leased to the Grand Trunk and later the Canadian National. At present, the lease is held by the St. Lawrence and Atlantic Railroad, the SLAR, a Genesee and Wyoming short line that's worked very well with us on business development, and we maintain a strong relationship with their management team. As industrial and distribution activity shifted over time, the sections of LARC saw a shift in their demand. Today, the active corridor is 3.5 miles of the original, with a termination at US Route 202 on the eastern end and Lewiston Junction on the SLAR to the west. While no direct connection exists between LARC and Pan Am's rail system in Maine, we've been active supporters of investments in Danville Junction in Auburn, which is an interchange between the SLAR and Pan Am. Even with those shifts in economic activity, we've remained focused on industrial and distribution growth strategies in our region. In 1994, in a partnership with SLAR, Maine DOT, and the Federal Highway Administration, one of the first investments of congestion mitigation air quality funds in rail infrastructure occurred and led to the construction of the intermodal facility, which currently exists in Auburn. That total investment at the time was a little over $5 million, and the location grew from no intermodal traffic before the early 1990s to a peak of about 15,000 containers a year. The goal, which was achieved, was to reduce long haul trucking and it did lead to growth in local trucking employment. 20 years later, in 2014, we completed a nearly 1 mile addition to our LARC-owned network with a total of investment of over $3 million. In a project known as the Rangeley Branch, we built a new line that connected to our main line and that of the SLAR. That project alone opened up hundreds of additional acres for industrial and commercial development to be served by rail. LARC and our shareholders, the cities of Lewiston and Auburn, have maintained a steadfast commitment to securing industrial, commercial, and distribution investment. For a state that is known by the moniker vacation land, and certainly Patricia, who just spoke, a number of her riders or those who are coming to vacation, enjoy time along the coast, a number of regions of Maine still retain strategic policies to support growth that relies on access to quality, efficient, and reliable freight rail service to be competitive in a global economy. Lewiston and Auburn is definitely one of those regions. In the city of Auburn, approximately 800 acres of land zoned to benefit from access to freight rail services exists along the LARC active rail corridor. Along the Pan Am corridor proposed for acquisition by CSX, another nearly 500 acres is zoned for industrial and commercial use that would directly benefit from improved freight rail access. Through a recent planning process concluded in 2019, a partnership between LARC and Maine DOT, we looked at freight business development opportunities that could be proactively pursued going forward. We're working with our city owners to look at strategies to advance that. With the proposed acquisition of Pan Am's assets by CSX, LARC sees a partner committed to growing freight rail opportunities for existing businesses and collaboratively cultivating emerging opportunities along with us. We recognize that our region is positioned to benefit significantly from having connections to two competing Class I railroads. In addition to the SLAR connecting to the Canadian National Railway, they of course would also connect to CSX, and that access to key markets throughout the eastern United States we see as creating a competitive advantage for our region to secure further private investment. LARC and our shareholders have sustained our commitment to the role our assets and communities can play in supporting the distribution of raw materials and finished products to serve our region, our state, and the northeastern US. As we collectively seek to reduce carbon emissions in the battle against climate change, rail and intermodal opportunities must be a priority. We urge the Surface Transportation Board to support our economic development's future through its approval of the acquisition pending here. And I thank you for your time.
Thank you very much. Does anybody have any questions? Okay. I take it that you, well, I think you've spoken very well. I'm not going to extend it further because we've got a lot more story to cover, but I much appreciate your coming in, Mr. Lalonde. Thank you much. All right, should we take a, it's 3:45. What's the feeling? Should we go to the next panel and then take a break? Sound good? Okay. That sounds like everybody agrees. Okay, the next panel are the following. Worcester Regional Chamber of Commerce, that's Timothy Murray. Western Massachusetts Economic Development, Richard Sullivan. Around Corner Capital, Dr. M.K. Dorsey. Capital Policy Analytics Group, Ike Brannon. And GFI Partners, Stephen Goodman. So if those folks are here, I'm not sure they're all present, but let's begin with Mr. Murray.
Mr. Chairman, I apologize. I just literally got out of my suit that I've been in the last couple of days in preparation for my testimony. So I'm in the car with my wife and kids, and we're heading north to hopefully get a little skiing in this weekend.
Let me say this, I'm very impressed, and I think it's awesome that you're able to do your job and head towards skiing at the same time. So that's great. Go for it.
Yeah, well, first, it was 25 years ago this month that I got sworn in as a Worcester City Councilor. And one of the main focuses of my campaign and my time as City Council, and then 5 years later as Mayor of Worcester, was focusing on the expansion of commuter rail between Worcester and Boston. You know, if you grow up in Worcester, part of our landscape and the sounds and the rhythms of the city are very much a part of the rail is very much a part of that, both freight rail and commuter rail. But you know, over the years, freight rail, commuter rail atrophied, and one of the focuses that I had, you know, was to try to expand the number of commuter rail trains between Worcester and Boston from what was then 6 to a more robust number. And you know, through that process and effort, both as city councilor, as mayor, and then later as lieutenant governor, to realize that goal, we had to create a level of communication and collaboration, you know, with CSX. And, you know, in my current role as president CEO of the Worcester Regional Chamber of Commerce, we represent about 2,000 businesses. It's the largest chamber in New England, 35 cities and towns. And in that geographic area, we've got a number of railroads of different sizes and scopes in terms of what their role is. So in terms of our regional economy, freight rail is extremely important. And so, you know, I mention that because I've had experience in a number of different roles working with CSX and with Pan Am and other railroads. In 2012, the Surface Transportation Board signed off on a historic acquisition here in the Commonwealth, and I would probably say in New England, when we acquired track from CSX in all different parts of Massachusetts. And one of the individuals who's going to testify, Rick Sullivan, was a member of the Patrick Murray administration, and I think he was a part of that process and understands the size and scope of that acquisition. It was a long negotiation, at times a hard negotiation. But the CSX team was always stayed at the table, always showed good faith, always were willing to engage in that back and forth that is so critical if you're going to move complicated, difficult issues forward. And that acquisition of track also involved some very detailed operational agreements and and financial commitments of significant amounts of money, both from the Commonwealth and from CSX, in terms of the modernization of infrastructure, as well as significantly upgrading operational functions on some of the issues that we've talked about: dispatching, signalization, et cetera. And so, working with CSX, you find a committed partner. And that has been my experience throughout my time in government and throughout at the chamber. And, I think the last figure I heard, and it's maybe a few years old, so I'm not sure exactly how accurate it is, but nearly 30% of all freight rail, in that passes in and out of New England, kind of goes through Worcester and or Central Mass. And when CSX, that historic agreement, and we acquired the tracks, one of the major things that took place as a result of that was a significant, I think, 25-acre expansion to the CSX intermodal hub in the city of Worcester. They spent over $125 million in modernizing, upgrading the intermodal hub, with a lot of interaction with neighbors, business groups, municipal and state officials. And, I'm not going to say everything went perfect, but it went extremely well, all things considered. And again, they were responsive to issues large and small. In Worcester right now, we've been able to, as a result of that acquisition, as a result of the operational agreements, we've gone from 6 commuter rail trains to 20 plus between Worcester and Boston. We have seen an expansion in freight rail activity in the region, and that has created jobs. And I don't, say this with hyperbole, but it's no coincidence that with the expansion of both commuter and freight rail in our region, the city of Worcester is one of the I think the fastest growing large size city in New England, and we are having an economic resurgence like we have not seen in a long time. And I would dare suggest that it's because of this. A major factor in this was the collaborative agreement that took place that allowed both the more efficient use of the rail in a way that complemented CSX and freight rail and commuter rail. And I can tell you from my experience with Pan Am, and I'm not going to necessarily expound upon it to the extent that Representative Barrett, former colleague of mine as a mayor, or the gentleman from Portsmouth. But CSX, I can tell you firsthand, their infrastructure in Worcester and throughout central Massachusetts is crumbling. Yeah, I would argue that parts of it are unsafe. I mean, when you talk about some of their track over the Wachusett Reservoir, which serves the MWRA and communities all in Eastern Mass as a water source. So I think it's extremely important that we see a company that's capitalized and has a record of collaboration with the Commonwealth and others to take ownership of that. I've had a chance to read the Commonwealth's brief, and hear the testimony from their counsel, Bob Wimbish. And I just say that, having reading that brief, I understand and respect a lot of the concerns that the Commonwealth has. But even since that brief was submitted on January 8th, we know that CSX has continued to try to work and has reached agreement on a number of the things that the MBTA and MassDOT expressed concerns about. So I, based upon a 25-year track record, really believe that almost every one of those items that they listed can and will be worked through in good faith by the CSX team. And I had a chance over the last couple of days to read the bios of the board, and appreciate your work, Chairman, as a member of the Alder board in Chicago. And I'm not an elective office, but I still get calls on issues large and small from former constituents, and sometimes on occasion relating to CSX, and they're every bit as responsive now as they were back then. And as I mentioned, I think all the members of the board can appreciate, policy is only as good as your personnel. And the personnel that CSX has on the ground in New England, whether it be Maurice O'Connell, their regional vice president, whether it be, their business development people, Kurt Miles, and others, that I always have found them to be extremely responsive, not only to the calls from us, but when you put them in touch with an end user or a neighborhood group or a business, they always are responsive and get back, and usually can find a way to satisfy those needs. And, no one bats a thousand, but they have a great track record. And so I just want to say, this has been a great, interesting couple of days for me. It's reminded me of a lot of the work that I've been involved with over 25 years on rail issues. Having gone to law school, I also, as you mentioned, Chairman Overman, reminded me elements of law school and some of the conversations and that have been taking place. But I think it was one of the board members mentioned, at the end of the day, what's the public interest? I would argue that, it's the relationship that we've seen, the track record that we've seen with CSX has been in the public interest, both from a transportation usage and efficiency point of view, certainly from an economic development point of view, and I would argue from an environmental point of view as well. And I have great confidence that the work that they can do in acquiring the Pan Am assets and rail is going to benefit the Commonwealth. And I'll just end on two pieces. The vice chair, mentioned that, in the first day or yesterday about some of the concerns in Eastern Mass. And Eastern Mass is the economic engine, but the growth and expansion of rail, both from a freight and commuter rail, has the opportunity to really be an economic engine for parts of Western Mass and Northern Worcester County. And Senator Hines talked about some of the population loss in Western Mass, and I know Rick Sullivan can speak with expertise on some of that. But by having more utilization of the rail from a freight and commuter rail passage along that, Route 2 Patriot Corridor, better utilization in Springfield, better use of Barbers Crossing north up to Air, is going to create economic opportunities that are going to be helpful to those communities and help them maintain and grow population. So it's happy to do this and look forward to hopefully positive outcome here, because we think it'll be good for not only central Massachusetts and the city of Worcester, but for the entire Commonwealth.
Hey, Timmy, Marty, just real quick.
Go ahead.
Timmy, I don't know if you remember or not, but I have that lean towards Eastern Mass, having spent 20 years with Mike Capuano. So I hope you won't hold that against me. But I recognize. I want to say that I was there working, with Mike, when you were working, in the lieutenant governor's, as lieutenant governor, working on these things. And we recognize, and I still recognize here now on the board, the importance of growth out to the west. My concern yesterday and even still today is just to make sure that there's that balance between the two, because I recognize the growth that's happening, not just Worcester, but beyond, the need for that growth and the importance for economic development to be strong. And to be strong, you got to have both strong as well, freight as well as passenger rail.
No, and thank you for that, and appreciate your work and your previous role with Congressman Capuano. I mean, really, the whole Mass delegation was part of that process in our negotiations with CSX. I joke with people that, former U.S. Senator John Kerry helped facilitate and mediate some of those negotiations between the Commonwealth and CSX. And I said it was probably his best training before he became Secretary of State. Some hard but good faith negotiations that have, I think, gotten us to a good place. So thank you. And I know the subcommittee that Congressman Capuano chaired at the time was also a leverage point as we had those negotiations.
Thanks, Tim. Enjoy the skiing. Marty, you're muted.
Thank you. Thank you, Tim. I think, Tim, at one point you mentioned something about crumbling rail. I assume you meant to refer to part of the Pan Am line.
Yeah, I mean, we saw the pictures, in the comparison of the Pan Am infrastructure with the CSX infrastructure. I can point to, if anyone's in Worcester at some point, happy to point out, drive, along from Barbers Crossing north, and the rail in Clinton, Mass. I mean, Pan Am's infrastructure, I think, is concerning, and it should be concerning in terms of where its current state is. And it's in desperate need of reinvestment. And I have seen and witnessed firsthand when CSX makes its investments in infrastructure, they're first rate and done well. We have the most efficient, we're one of the most efficient intermodal rail yards in the country here. And as I said, it was a 25-acre expansion in the middle of the city of Worcester, as well as a complete redo of the facility. And it is first class, efficient, quieter, but it was done in a way that really tried to address infrastructure issues of the city and the neighborhoods. And again, there are sometimes issues that come up from time to time, but it was done right. And to me, that is what communities and neighbors want. And they've got a track record of trying to do it the right way. And from a safety point of view, I know it was a previous question by one of the board members about the propane, turnover falling up in Maine, the rail car with a couple propane tanks. Again, I'm concerned about Pan Am's existing infrastructure right now.
All right. Thank you very much. Any other questions for Tim? Tim, be safe. Don't fall down.
Thank you for your time and thoroughness process.
Yeah, no, thank you. Much appreciate you're taking all this time out of the family. If you can say hello to the rest of the family and enjoy yourselves.
Will do.
Okay, take care. Is Richard Sullivan here from Western Mass Economic Development? Okay, we don't see him on the screen. Let's go to Dr. M.K. Dorsey from Around the Corner Capital.
Good afternoon, Chairman Oberman, Vice Chairman Primus, distinguished members of the board, ladies and gentlemen. Thank you for the opportunity this afternoon to offer testimony for today's proceedings regarding the proposed merger between CSXT and Pan Am Railways. This acquisition will have a significant impact on a multitude of interests and parties across the New England region. Accordingly, it's critical that the board carefully consider the testimony of the stakeholders partaking in this hearing, as you have been over the past day and a half now. Our firm invests in many ESG, environmental, social, good governance, commodities, and assets. I'm a 16-year New Hampshire resident and a former White River Junction resident, and thus all too familiar with some of the shortfalls and limits of regional rail, many that were just mentioned by Tim, from considerable personal use and too much engagement. I will say that many of my comments today can also be found in an op-ed that I wrote in the Vermont Biz paper that was published last November, titled Railroad Merger Charts, a Clear Track to the Environmental Gains and Carbon Neutrality. With that offered, I'll continue. Protecting our environment and reducing climate change-inducing emissions is a complex yet urgent issue. Like most complex problems, there will rarely be a silver bullet or a one-size-fits-all solution. We can seek incremental changes in the short run that produce major breakthroughs over longer periods. Sometimes incremental environmental victories are hiding from us in plain sight. Every year, trucks, ships, planes, and trains move over 1 billion tons of cargo around the world. While freight transportation keeps the global economy moving, it's essential and unavoidable. It's also a heavy driver of polluting emissions. According to several of my colleagues down at MIT, freight transportation accounts for about 8% of global carbon emissions. However, curtailing freight transportation isn't an option for our increasingly interconnected world. Nevertheless, we can do much more to ensure our transportation infrastructure is as modern, reliable, and ecologically efficient as possible. For example, we should encourage more goods to ship by rail instead of by truck. This will drastically help reduce emissions, and the data is in on this, as I think you all are aware. According to the EPA in particular, while freight railroads account for about 40% of U.S. freight being shipped across our country, U.S. freight railroads account for only about just under 2%, 1.9% of U.S. transport-related greenhouse gas emissions, and only account for less than 1%, 0.5% of the total U.S. greenhouse gas emissions because of their higher fuel economy. Today, as we consider the situation in New England, the proposed merger of CSXT and Pan Am is an important opportunity that can bring about big positive environmental and economic changes quickly without breaking the bank or disrupting supply chains. Trains are the most fuel efficient land-based mode of transportation, 3 to 4 more times efficient than trucks on average. Moving freight by rail instead of by trucks actually lowers greenhouse gas emissions by up to 75% on average, according to folks, some of my friends down at the Texas Transportation Institute, in a recent study they did on urban mobility. U.S. freight railroads on average move 1 ton of freight more than 400 miles per gallon of fuel. However, some publicly available CSXT data indicates that the firm is doing about 1 ton of freight more than 500 miles on a single gallon of fuel. That was discussed actually yesterday, if you all recall. Further on, it's remarkable and notable that CSXT invest in emissions reducing technologies, including idle mitigation, energy management software, some of which we saw yesterday. CSXT's trains are able to reduce emissions by using advanced software to shut down diesel engines when possible and automatically restart them when necessary. These ecological and corresponding social bona fides stand in stark contrast to the many of the locomotives in use by Pan Am today. Pan Am's locomotives' average age is more than 40 years old. Replacing Pan Am's aging fleet with newer, higher horsepower, more inefficient locomotives from CSXT will enable us to operate the fuel locomotives that are being currently used while simultaneously improving fuel economy. These are all compelling reasons that give me hope that the board will approve this merger as a way to improve and upgrade the rail network in the region, and more broadly help address the important issue of rising greenhouse gas emissions that imperil our climate and threaten the environment. Thank you for your consideration. Much appreciated.
Thank you, Dr. Dorsey. Are there any questions?
Question for Dr. Dorsey. From an environmental standpoint, you mentioned the benefits in terms of greenhouse gases. Would you also put forward that the environmental benefits extend to things like particulate matter and nitrogen oxide and other pollutants?
Absolutely. And I would say they not only extend abstractly to the environment, but there are a whole host of sort of co-benefits socially as well, beyond ecosystems per se. So checking greenhouse gas emissions or reducing greenhouse gas emissions also has upside implications for reducing other forms of pollution, air pollution, and other forms of pollution as well, water pollution and many others. So indeed.
Thank you.
Yeah.
Okay, thank you. Any other questions for Dr. Dorsey? All right. Thank you very much, Dr. Dorsey. Appreciate
you
making the effort and not only testifying, but writing your op-eds and being out there to affect public opinion. Much appreciated.
Thank you, Chairman. Thank you.
Ike Brannon. Mr. Brannon here? I don't hear from him. Stephen Goodman, namesake of the late great Chicago
musician, yes.
Musician. Are you going to
very appropriate song too, given the comments here? Yes.
Disappearing Railroad Blues, huh?
Yes, yeah.
Well, you're on.
Thank you, Mr. Chairman, members of the board. Good afternoon. My name is Steve Goodman. I am the manager of GFI Partners. We're a New England-based industrial developer. Since 2010, GFI has developed over 2 million square feet of rail serve facilities in the New England market. As the warehouse and distribution strategies are changing, rail served facilities are playing an increasingly important role in maximizing delivery efficiencies and minimizing impacts of over-the-road trucking. And currently we are seeing increased demand from freight users looking for modern warehouses, with access to well-served rail. So I'm here to strongly support the CSX acquisition of the Pan Am network. A couple of the many reasons are the creation of the single line service, which we've heard so much about, which is a big plus for our tenants. It'll allow better access to national markets, improve service, both consistency and reliability. And as Tim had talked about, there's a needed investment in infrastructure, which we think CSX will be well suited to do. We think this will provide, open up new parcels for development, which in turn can create significant tax revenues, job creation for local communities, and allow us to create additional, rail serve facilities, which where I started was are so needed in this market. Really, that's really all I had to say. I just, as a developer on these lines, we think that the investment by CSX into some of this older infrastructure will help us create, the modern distribution facilities that the market's craving right now.
Mr. Goodman, just a couple of questions. You are a developer of industrial parks, as I understand it.
That's correct, sir.
Yeah. So are your tenants now rail users in any of your parks?
Yes. Yeah. Yep.
But
yes.
where? I'm just sort of like to tell us where that is.
Oh, we have facilities on both the Pan Am. We're in Devens, in their Devens. We have land in Devens, Mass, on Pan Amtrak. We have land in Air, Mass, on the Pan Am Southern. We have facilities in Worcester, Mass, that are on the G&W. To name a few.
And what types of shippers or receivers? Types of commodities are we talking about?
Yeah, so we kind of have a little bit of a lot. For example, Chuck Giroux from Midstate is in one of our buildings, who spoke earlier. We have big paper product coming out of Maine, which is located in Devens. We have a rail serve facility in Worcester, which is on G&W track that brings wine from the Gallo wine from California. We have their warehouse. Hood McQuesson, which is a large lumber supplier. Their Northeast facility is in one of our buildings on Pan Am Southern track.
So let me ask this: to your knowledge, do these shippers and receivers rely on different carriers to interchange with Pan Am now?
Absolutely, yes. And so the ability to have both the tier one to negotiate rate, having access to both of the NS and the CSX is in our experience has been important to our tenants to make sure that their costs are competitively bid.
So keeping these interchange points and access points open that we've been talking about, as you see it, is important to your tenants being able to continue to get competitive rates.
From our point of view, yeah, very important. Yes.
Is it one of the selling points when you do industrial development to say, look, we have rail access to various carriers that interconnect with the national network?
Yeah, I mean, it's always been important, and now it's so hard to find good land that one of the things we see is really important here is the investment in infrastructure. There's a lot of land that we think is will be accessible if we could convince our tenants that, the service would be predictable.
All right. Any other, appreciate that. Any other questions for Mr. Goodman? All right. Well, we will do our best to keep the railroads from disappearing, Mr. Goodman. That's part of our assignment.
Thank you so much.
Yeah, and Patrick and I, by the way, on our first field trip, took the city of New Orleans for a ways. So
nice.
Yeah, and it almost did disappear on us. So, all right. Thank you very much. I much appreciate you taking the time. I understand Mr. Brannon has been able to join us. So if he's
that's right, I'm here.
Okay, good for you.
Great, thanks. Thanks for the opportunity to attend and participate. And Chairman Oberman is a fellow Central Illinois, and it's good to see one of our own running the STB. So way to go. My name's Ike Brandon. I'm a PhD economist who's published articles in academic and public policy publications related to logistics, freight rail, and various other transportation issues. I'm currently a senior fellow at the Jack Kemp Foundation in Washington, D.C., and I also serve as an officer of a nonprofit dedicated to reducing road congestion called Parking Reform. Before my current positions, I was an economist at the Office of Management and Budget, the U.S. Treasury, and the House Energy and Commerce Committee. I believe that the proposed merger between CSX and Pan Am Railways would bring benefits to both the U.S. economy and especially to the environment. Consolidation would serve to improve rail service in the Northeast and increase the quantity of goods shipped by rail, which will in turn reduce road congestion, particulate emissions, and greenhouse gases. There's no reason to think that this merger would result in materially higher market concentration or that prices would increase for Northeast shippers. The opposition to the merger appears to be motivated by parochial interest, and the costs of preserving them would vastly outweigh the public benefits from the merger. First, I want to point out the merger between the two rails would not change the competitive balance in the rail industry in the Northeast in any discernible way. CSX does not currently have tracks in places where Pan Am operates, so it's merely expanding its network, if not eliminating a competitor. By being a part of a larger network, Northeast shippers will be able to get better service. There will be more customers they can ship to directly, which tends to be quicker and less expensive and more efficient to do as well. The transaction will allow CSX to take advantage of economies of scale in operating a network, and by extending into the Northeast, it will acquire more customers who can benefit from their network and resources. The merger would increase the capacity of the current Pan Am rail network, which would have a positive effect for New England. Being integrated with the largest CSX rail network would allow it to expand how much trains can operate and carry in the region. And being part of a larger, better capitalized company will undoubtedly boost investment in maintaining tracks and expanding capacity. Besides benefiting shippers, New England residents will benefit from expanded train capacity because it will reduce the number of trucks operating in New England, as Dr. Dorsey pointed out in his testimony. Fewer trucks means that there should be less congestion on the area's roads, which would mean less smog, less particulate pollution, and fewer emissions of greenhouse gas. Reducing transportation costs is an unalloyed benefit for society and helps firms reach customers faster and less expensively, saving them and their customers money. That's why, to me, it's puzzling that several governmental bodies, but by no means all of them, oppose the merger. One objection I know has to deal with the Pan Am dispatch office that would likely see its functions folded into and integrated within CSX's broader dispatching operations. But holding up such a merger benefits an entire region over such parochial interests could effectively force New England shippers to pay more and accept inferior service for the sake of a relatively small number of jobs, when a more efficient and robust train transport system would almost surely create more jobs and boost wages in the region, while at the same time providing additional benefits to shippers and residents across New England. The objection of Amtrak and its supporters, who want guarantees that passenger rail access would be unaffected by the merger, are also misplaced. It's unclear how blocking the merger would help Amtrak, but doing so would result in more goods being transported by truck, as would their demands for passenger rail priority on the combined rail network. Shifting goods from rail to truck to accommodate little-used passenger rail routes makes no economic or environmental sense. Amtrak's opposition is even more puzzling when we see that other passenger rail-focused entities in the region have been publicly supportive of the transaction because of the expected upgrades to the rail network that will seemingly lead to improved passenger rail performance for everyone over the status quo. I just want to observe that the Biden administration has opposed or delayed a wide number of mergers in the last year for both for reasons of economics and I submit ideology, but I fail to see how either precept can explain its apparent opposition to this merger. The competitive landscape for Northeast Rail would remain unaffected. The benefits of the transaction, from the jobs created to its positive impact on the environment, and the benefits that would accrue to shippers in the region who stand to gain from an improved and expanded network, should be obvious. Rejecting this merger would amount to the government rejecting its explicit economic agenda of combating climate change, expanding economic opportunities for slower growing regions in the country for narrow short-term interest. Thank you.
Thank you, Mr. Brannon. I just have a couple of questions. Your what is your business? I can see the name of it. Are you in the,
so I'm a scholar. That's what I am. So I'm a research and at the Jack Kemp Foundation does research, and a lot of it has to do with economic development and pollution. Yeah.
Do you have any background in consulting in the railroad industry, or are you coming here as with the general economic expertise? I'm trying to.
Yeah, that's right. So I've written a bunch on rail as part of my job as a scholar, but I don't have any. I don't have any consultancies going on.
Yeah, but you've done work with on the rail industry before.
We've published, yeah. So I write with a former colleague of mine, Michael Gorman. We've written a lot on rail, and in general, we've written a lot about congestion issues in the country. And as you know, rail has a lot to do with road congestion.
Yes, no, I much appreciate that. I'm just wondering, you, in talking about the competitive landscape, you didn't comment on the issue that we've been talking about a lot today. And I wonder, from your point of view, if you put any importance on not diminishing the existing competitive options for various short lines and shippers in New England by virtue of this merger, in terms of keeping these gateways open and that whole discussion we've been having the last couple of days. Do you put any value on keeping those options from going away?
I realize there's a cost to some of these options going away, but I think they're more than outweighed by the ability of more firms in New England to be able to have easy access and be integrated as a part of a Class 1 railway.
Well, but you understand that CSX seems to be telling us they aren't going to have these open gateways go away. They want to maintain them. Do you think that's an important part of the overall transaction, because it does preserve existing competitive options from other carriers?
You know, I'm working. Mike Gorman and I are working on another paper looking at reciprocal shipping options. So I'm going to reserve my my comment on that until we finish that paper. We will submit that paper when we submit it to an academic journal. We'll share it with the STB.
Well, let me tell you this. You know, we have a hearing on reciprocal switching in 2 months, so we can use all the expertise and advice we can get.
We're actually hoping to have a draft of that ready for that one.
That'd be great. But I was focused more on just the existing gateway issue that we have now up and down the Pan Am system and the PAS system, and all of the discussion we've had about keeping those gateways that already exist open, so that other carriers can, so that shippers have competitive options.
I just think that comes at a very high cost. If it means that it makes it more difficult for CSX to do scheduling, and it reduces their capacity, it comes at a cost. And I think that that's something that has to be to be acknowledged.
Yeah, they don't seem to be suggesting that it's a cost. That's why I asked. So it doesn't seem to be a problem. But let me end it there. I know that Patrick has some questions too.
Very quick, you mentioned, I think you were referring to the DOJ when you referred to opposition to the transaction. Is it maybe more fair to characterize the DOJ as proposing remedies to competitive concerns rather than taking a stand on the overall merits of the transaction? In other words, do you read the DOJ filing as saying that the anti-competitive effects are greater than the benefits, or more just a particular view on anti-competitive effects?
So I was speaking more broadly, right? I think in the last 12 months, I just can't remember a time where it's been so difficult for any kind of merger to happen. And
But to be clear, the DOJ does not say in its filing that the board should deny this merger.
Right.
All right. I just want to get clarity on that point.
Right.
Okay. Thank you.
All right. Any other questions for Mr. Brannon? Okay. Thank you very much, Mr. Brannon.
Thank you so much.
I think we all look forward to your reciprocal switching paper.
Great, thanks.
Well, I do. I don't know if anybody else does, but I.
Scintillating. I'll make it scintillating for you.
Yeah. Everything I read here is scintillating. Thank you. So with that, it is 4:24. We are, I'm sorry, before we end this panel, just to be thorough, did Richard Sullivan, was he able to join us? Okay, so I think we are going to end this panel. It is now 4:25, and we have to get to the applicants. But because it's been a long day, we're going to take a 10-minute break sharp. We'll be back at 4:35, and we're going to try to finish this up as quickly as possible. But there are some, I'm sure, there are issues that need to be closed, and there are, I'm sure, further comments from the applicants. We will see you all in 10 minutes. Thank you. All right, folks. We're reconvening for the final lap. We're going to finish this today. And I understand there are some travel commitments, but the people are going to stay with us while they're in transit. Tim Murray led the way. It can be done. So let us reconvene and get our applicants back up here for rebuttal. And I think there undoubtedly will be some further questioning. Are the CSX, B&E, and NS teams on board?
Yes, sir, Mr. Chairman. CSX is ready to roll.
All right, Jim, you're on.
Okay, great. Well, thank you, Mr. Chairman and board members, for the opportunity to summarize why this proposed merger between CSX and Pan Am is good for rail shippers, passenger rail customers, the environment, the national transportation network, and the public at large. I hope that we have been able to show you our enthusiasm and optimism about this transaction and how it will transform the New England rail network for the better. You heard from our customers, our short line partners, local communities, elected representatives, and state agencies that are excited to see a modernized Pan Am. They recognize that an upgrade to the Pan Am network is sorely needed. Becoming a part of CSX and the Class 1 railroad network is going to bring them tremendous benefits, and they have told you they want this transaction to go forward. We explained that CSX will upgrade and modernize the Pan Am operations, elevating the network's potential and maximizing its efficiency. We have already identified a number of capital projects totaling more than $100 million. We provided you a map showing the numerous projects that have already been identified that will bring the Pan Am network up to Class 1 railroad standards. These upgrades will benefit all rail users, freight and passenger alike. We have broad experience working with passenger services and how to coordinate freight and passenger operations to ensure safe and consistent service. We are partners with several local and regional passenger agencies across our network. Nothing about this transaction will have a negative effect on existing passenger service, and the operating and safety improvements that we will make will only result in improvements to existing passenger rail service. We have also pledged to work with passenger agencies to explore future opportunities. Pan Am's shippers will benefit from CSX's customer service, greater schedule reliability, and greater transparency about their shipments. New seamless single line service will provide shippers with low cost, environmental friendly rail service with truck-like reliability. So they can reach a wider customer base over an expanded territory. You heard directly how excited shippers are to be part of a larger network that will give them access to new market opportunities. You heard from Genesee and Wyoming. After their presentation, I think the board knows why CSX and NS chose them as the operators of PASS. They have enormous operational expertise and will make PASS a better rail carrier and will ensure the continued viability of PASS as an independent rail route into New England. You heard from NS, the party that would be the most natural source of opposition, and they vigorously support this transaction as it is currently structured. You heard how we have negotiated with interested stakeholders, and these agreements, along with the transaction overall, will lead to a restructured rail network in New England to make it stronger, more resilient, and more reliable. This is the result of numerous negotiations and settlement agreements. And we know that the board values the ability of stakeholders to work things out through negotiations. So do we. We also heard some concerns by a handful of interests. And I'd like to respond to the few parties who continue to have concerns regarding the transaction. First, Canadian Pacific. We share the board's preference to have these concerns worked out between the parties so that the board doesn't need to impose conditions. And we've attempted to do that here. CSX and NS are in agreement on nearly all the conditions outlined by CP today, and CP knows that. Yet CP won't come to an agreement with us. It seems to me that there's something else that is driving their position in this case. Second, we appreciate the working relationships we've established with the Commonwealth of Massachusetts. And as they have acknowledged in their hearing testimony, we have made a number of commitments that include strengthening the reservoir and supporting the Berkshire Flyer. My letter on the Berkshire was clear. Amtrak can begin the special train in 2022 without the 1,000-foot station track, but we need a commitment on that track long-term. We're also committed to continuing meaningful discussions on additional proposals for commuter routes. Third, with respect to Amtrak, in addition to supporting the Berkshire Flyer, CSX has agreed to Amtrak's remaining conditions. Finally, the legal standard is focused on competitive effects, and we have demonstrated to the board that the structure of this transaction ensures there will be no adverse competitive effects. We've shown how competition actually will be enhanced by this transaction. And even if you found there to be anti-competitive effects, the legal standard requires approval if the public benefits outweigh those effects. This hearing showed you the extent and strength of the abundant public benefits. I hope that this two-day hearing has served to inform you about why this transaction, as structured, which clearly meets the legal standard for approval, will revitalize rail service in New England. Thank you, Mr. Chairman, Vice Chairman, and board members for your strong interest in this important transaction. Upon your approval, we can get to work revitalizing the New England rail network.
Jim, thank you very much. Let me say at the outset, I think this 2 days of hearings, beginning with you and your team's presentations, have been exceptionally productive and enlightening and have moved the ball forward towards our responsibly figuring out what to do with your application. So I really congratulate you and everyone who has participated in this hearing. I think there are a few matters that need some clarification from my point of view. Perhaps from other board members, they can weigh in. So I'd like to deal with those. I actually think that the record is already pretty solid on the issues that I have raised as a concern. But in going over the proceedings from yesterday, I think, and some of the things that have been said by Amtrak and CP, I think there's some things that need to be clarified, which I'd like to do. So first of all, you indicated that in your comments just now that it was your goal to try to reach agreements with as many people as possible, or many interests, to avoid the board imposing conditions. As a general matter, you know, that is my view, to encourage private agreement. But just so the record is clear, it's my understanding that it's CSX's position from the papers you first filed that once you work out agreements, then you expect and actually want the board to impose those as conditions, but based on the agreements. That's really what you're talking about, right? So we're on the same page.
Yes.
Yeah, okay. Because you said instead of conditions, but the conditions we've been working
the
for.
negotiated conditions.
Yes, right. That's I think we all agree that's better, but they're still going to end up being conditions because you may not be there someday when these, and neither will I, when the conditions may need to be enforced. So with that in mind, I wanted to cover, I don't think we need to spend as much time on it as we did yesterday, but you and I had a very vigorous discussion, a very productive one, in which you were very affirmative about maintaining all existing avenues of competition. in terms of open gateways and equalized rates and so forth. And I realized that it may have been my own phraseology that I am not clear. I think the intent was clear, but I'd like to put it on the record that the commitment to keep all gateways open, to have commercially reasonable interchange rates, to have equalized rates for all carriers, so one isn't disadvantaged versus the other, applies to all of the interchange places on the Pan Am system, but also on the PAS system. I mean, I think sometimes that discussion got morphed together. Is that a fair way to state it?
Well, I think what we were talking about yesterday, and I think what you were talking about with CP today related to the PAR. Let's just call one PAR, one pass to keep it easy. And
I think yesterday we were talking about both, but that's what I wanted to be clear on.
Well, yeah, there was two things that kind of yesterday kind of got intermixed together. I think you pulled out a past tariff, and then we were talking about the past tariff that had equalized. They basically quote the same rate, whether it's going to the CP interchange or the CSX interchange. You know, they just have a blanket tariff.
So let's be clear. Let's clarify that today.
Yes, and then that kind of morphed into the conversation about propane moving from Sarnia into New England versus the Appalachian region into New England, and then we started talking about gateways. And yes, our commitment, which we said yesterday, our commitment is. To the extent that we can commit, I guess that's the best way to say it, to the extent that we can commit, because past you've got CSX, you've got NS, we've kind of ceded pricing responsibility to Genesee and Wyoming. So let's have to kind of deal with them separately. To the extent that we can commit, and that would obviously be the case on PAR. I think it's been kind of the standard for the last 20 years since the Wisconsin Central transaction. As a starter, you have to guarantee gateways open, which means physically open and economically open. And in that circumstance, and those guarantees really don't go to the railroads. Those are guarantees to the shippers. So when the shipper's out shopping around for rates and he wants to use different alternative carriers to find out what's going to be the most economic rate from what source, he has all of his options that he had available before. So if there was a rate existing today to a gateway that PAR has quoted to a customer, it's our commitment that we will continue to quote a competitive, reasonable rate that doesn't economically close that gateway.
All right, and that's I thought that was clear on the record and in your papers yesterday for PAR.
I think you had some very similar conversation today with the representative from the Canadian Pacific, where yes, I think you came out exactly in the same place with the crystal clarity on that. The question as it relates to the pass, and then we were talking yesterday about the tariff. And the fact that PASS had a tariff, and when they raised the tariff, they seem to raise it uniformly up and down. Doesn't make any difference to the railroad. Gateway. They have kind of parity between the east, the west, and whatever it is. I think in that circumstance, and council can correct me if I'm wrong. I think we have a relationship there where we and NS have ceded to, we have given the B&E the commercial responsibility for quoting rates in that area. And first of all, whether it's PAR or PASS, if there's a rate in effect today that's in a contract or whatever and moving freight, we're going to honor those rates. That's a binding commitment on our part. So we would honor those rates that are in existence, and then in the future would not do something unreasonable or detrimental to the customer that would economically close that rate. On the pass,
Jim, just to use the phraseology we've been using, that would not be commercially unreasonable, right?
That's correct.
Yeah.
That's what
Okay.
okay, sorry.
That's okay. Go ahead.
And then on the pass, because we have given the B&E, because we have stepped back out of the commercial arrangements, the pricing for the service, B&E would set that rate, and they would set that rate. They're incentivized to make sure they don't do something stupid that would close the gateway to pass, and so they would grow the business. So I guess there's a slight nuance with pass, only because I can't make that same level of commitment.
But maybe we can solve that problem right now because B&E and NS are there.
Well, and Mr. Chairman, let me point out one other aspect of pass. One of the very important elements of the settlement agreement and the term sheet was to ensure that pricing would be done on a non-discriminatory basis. That is one of the fundamental, that is, I should say, the foundation of the pricing responsibility and requirement that B&E is obligated by contract to follow. Non-discrimination is very similar to what you're talking about here. That means that if a product is coming in to pass from one carrier, a non-discrimination rate setting requirement means that other carriers bringing that in to use pass for the same movement cannot be discriminated against. They cannot. So they can't, so there would be no way under the contract for pass to favor either of its owners or any other individual carrier. They've got to be non-discriminatory.
Well, I understand that, but the settlement agreement's between NS and CSX. So there are other carriers that come in there, primarily CP. And I think what we wanted to make sure, and I thought it was in your papers, and I guess I wouldn't say very similar, I would say identical to a open gateways on commercially reasonable rates in perpetuity for all carriers, and that would include CP.
Yeah, absolutely, absolutely.
So now, but I think for our record, because I think Jim is right, they're dealing with different corporate entities. Can we hear an amen from B&E and NS? They're sitting right there, that they are committed that pass is going to operate in perpetuity. Of course, B&E may not be there in perpetuity. They have a term limited contract to this non-discriminatory policy. Just
absolutely. On behalf of B&E, it is embedded in our contract that we cannot favor any carrier over or another. So that means that we can treat CP no different than CSX nor NS. Any different from there are existing agreements in place, but from
going forward, that's a permanent commitment going forward.
That is embedded in our agreement as operator, yes.
All right.
And if we do not adhere to that, we can be terminated.
Yeah, but it could also end up being in a condition by agreement that could be enforced by us. That's what we're.
Absolutely. Sorry, right. And I would just ask to make sure with outside counsel that I stated that correctly, Eric. Right.
Yeah. Sounds good to me. Bill Mullins, are you on board?
Yes, sir. Yes.
Pardon?
On behalf of Norfolk Southern, I would say that we don't believe that an actual board imposed condition is necessary because of all the reasons that have been expressed, especially the fact that B&E already has a contractual obligation to be neutral. That in effect is an open gateway commitment. So you don't need to impose that. And it does require three parties to agree to that commitment: B&E, Norfolk Southern, and CSX. And actually there's a fourth party, CP. And I think what concerns us, and Norfolk Southern is always willing to sit down and discuss these issues with CP. We couldn't agree with you more, Mr. Chairman, that it's best to resolve these things in negotiations and not have them be board imposed conditions. And in that sense, we've actually made a proposal to CP. We being NS and PAS, we've not heard back on that. And we would like to sit down with CP, want to have fruitful negotiations with CP. But, you know, talking about your issue with it's great to have negotiations. Well, if one side feels like what they're going to get is being imposed by the board and they don't have to give anything because they're going to get it for free from the board, they have no incentive to negotiate. So like, for example, in the CP interest, they're not offering to give any rate commitments of their own. They're not offering to keep their gateway and interchange open. They're not offering to give us Pan Am Southern service standards. They're not offering to give us volume commitments. They're not offering to give us maintain their lines in a shape. And yet we depend on that traffic just as much as they depend on theirs. So it's a two-way street. And if one side feels like they get all the leverage because they're going to get it from the board, they have no incentive to negotiate.
Well, Bill, let me just say a couple of things. Number one, I was going off of the promise that the principal applicant here, CSX, made that whatever representations it made or whatever it worked out, it asked the board to pose those as conditions of any approval we might give. And I'm not here to mediate between you and CP, at least in this public hearing. But there is a difference. You and B&E and CSX are all asking us to approve something. CP is not asking us for anything other than to be protected. So they're in somewhat of a different position. But as a matter of philosophy, you know, I have been saying, at least since I've showed up in this business, that everything that promotes more openness and more competition is good for the public and good for the industry. So you won't get any fundamental disagreement with me. But on this specific point, it is important going forward to articulate for pass what Jim has just articulated for the rest of the PAR system, what Tony LaRocca has reiterated, and what B&E has reiterated. NX, NS, can I just get you to say yes from NS's point of view? You want PAS to do that?
Well, I will commit to you, Mr. Chairman, on behalf of NS, that we will sit down with CP and discuss this in good faith negotiations.
Well, are you going to stand in, you know, that really leaves it open. We're trying to close the record here. Is NS going to object to the board imposing a condition that all the gateways on PAS remain open and at equalized rates and so forth, commercially reasonable terms going forward?
At this stage, I couldn't say that. You know, I haven't spoken to the client about that, but I would say that is a subject that we should negotiate with. That is a subject that you know, hopefully we can reach agreement. As you said, we support your goal to reach agreement. As you said, you're not here to mediate or negotiate in the context of this record. So, and I would also add that CP is asking for something that to be imposed on Norfolk Southern. They're asking it to be imposed on Norfolk Southern, and they're asking for something that is more than what they have now. Let's remember that they're asking.
I don't know that that's true. With what as I understand, at least in terms of the open gateways, as I understand it, PAS has been operated that way from the beginning. It has tariffs that are open that have equalized rates. So the one thing I hear CP asking for, more importantly, I think you hear me asking for it, is that the current level of competitive options available not be diminished. And that, if it isn't done by agreement, goes right to 11.324D.
And I think, Mr. Chairman, that we exactly shared that goal, which is why, and again, remember, we're the party that actually shares your entire goal of keeping the Pan Am Southern system competitive to the CSX system. You know, your comments to all the shippers, your question to the shipper about the importance of choice. It is important to have that choice. And the railroad that wants that choice the most is Norfolk Southern. And it's because of that we negotiated very careful agreements, very complex agreements. And as part of that agreement, to go precisely to your point, as part of that agreement, we made B&E commit to neutral, non-discriminatory pricing. That is contractually put in there. The board can put that in as a condition, because they're adopting that agreement. So I don't know what more is needed because B&E is already agreeing to be a neutral, non-discriminatory price maker.
The only thing that's needed is that Jim Foote just said he can only speak for CSX and you're 50% owner. So I just wanted to hear you say what you just said. So I think we're on the same page.
Yes, and let me reiterate that we're all on the same page. We have asked you to impose as a condition of approval the NS settlement agreement. We specifically ask that that be established as a condition. An element of the NS settlement agreement is the non-discriminatory pricing requirement for B&E as the operator. So by imposing that settlement, you are in fact establishing that as a requirement.
And Tony, Mr. Chairman, I might add here, the tradition of these open gateways, the tradition of these open gateways commitments are related to mergers, right, of rail networks, and eliminating any potential vertical competition issues, as maybe Dr. Reiches can talk about. But they're really about railroad mergers. And in the PAS context, this is not a merger. CSX is not merging with PAS. There aren't any gateways that could even potentially be closed as a result of the transaction. And what we've done, as Tony and others have mentioned, is enshrine these non-discriminatory principles in the settlement agreement, which we're asking you to impose as a condition. I just think that the open gateways concept is not necessarily apropos to the PAS network, whereas it absolutely is to the PAR network.
Well, I think it appears to be that it is apropos because there are at least 3 gateways that are used right now on PAS at Mechanicville, Hoosick Junction, and Rotterdam. And I thought one of the bases of this transaction is that those gateways would remain as open and going forward as they have been in the past.
And I think the essence of our agreement with B&E was to ensure that was the case.
Well, I understand.
So,
I just hear Bill having some kind of a reservation here, and then
all he said was we ensured that there would be equal treatment at the gateways. And forget about this is designed to protect the shippers, so that the shippers get equal treatment when they want to use different carriers, so that a shipper going to any gateway using a different railroad will be treated equally.
Yeah.
And B&E is contractually bound by the agreement to do that. And we're asking you to impose the agreement.
In perpetuity, right?
Well, unless
the NS settlement agreement, yes.
The agreement, yes.
From which the G&W operating agreement and the whole issue derives from. So yes, that's absolutely right.
Yeah, but G&W may not be there in perpetuity, but the commitment has to be there in perpetuity.
The commitment is with respect to how PAS will be operated.
Yes, whether it's G&W or somebody else in the future.
Well, a change in operator would have to be approved, Mr. Chairman, so you don't really have to worry about that. If there's an issue down the road, and you'll have another shot at it.
No, well, I may, but I'd like to get solid now so we can, if we're doing is replacing G&W someday, we don't have to re-litigate this issue. I want to know where we stand. So I think, as I understand it, the commitment is, I think, as Peter just said, is to how PAS will be operated regardless of who the operator is. Is that a fair statement, Tony?
Well, that certainly is the intention of the NS settlement agreement. This was not linked to B&E necessarily. It was linked to the purpose of establishing a neutral operator for PAS. So yes, this was intended to be part of the restructuring arrangement that we put together.
Since I've gotten to the board, and Patrick and I joined in talking to the rail law transportation group, It's been our observation that over the 140 years, there have been times when orders of the board have been drafted with some ambiguity. And it's a mission that Patrick and I started, and I'm pretty sure our other 3 members will join with us, of having as much clarity in our orders as possible. And if I seem to be pushing the specifics of this, it's because I want to have an order, assuming we're going to approve this, and that's still up in the air, that leaves nothing, as little to doubt as the human language, the English language will allow us in terms of precision. So that is the reason I'm pushing this. It's a penchant of mine, and I'm pretty sure I speak for Patrick. But I think we have resolved this issue in terms of the openness that Jim and I had a very productive discussion on yesterday, really applying not only to PAR, but to PAS. And if anybody thinks that those aren't going to be open in the same way, I want them to tell me right now. And if not, I'd like to move on to a couple of other matters that need clarification. Hearing none. I want to go to other matters that were raised by CP this morning. And this goes beyond the pricing and the open access part. You heard them talk about having some assurance that the level of maintenance of the PAS infrastructure and the service availability not be diminished as a result of the acquisition. What I heard consistently yesterday from everybody on this team that's here now, CSX, NS, and B&E, is a very strong statement to the board that that's the plan, to keep PAS as at least as viable as it is today, if not, in fact, planning to have improvements on it, and to make sure, and as B&E has emphasized, they want to grow the business. So it's hard to see B&E saying we're going to reduce the frequency of our service. That would not be consistent with growing business. So I'd like to explore whether the reaction to the idea of writing into conditions some agreement that PAS will be maintained at least at its current level or better, and that service frequency will not be diminished. Does somebody want to respond to that, what CP was talking about this morning?
Well, I'm not sure what CP is talking about. So, maybe you can help me on occasion. As NS just articulated, we've tried to have a conversation with them about exactly what they want. And it's been a difficult thing to do. So you heard the hub group, you heard the hub group talk about the service on the line. So I guess that's what they want.
Let's take it apart a little bit, Jim. One of the in response to one of my questions, I asked, are they talking about some commitment by your team? I'm just going to say your team because it's a 3-part group here, to at least keep the PAS line up to its current FRA standards or better. I hear you saying that's your plan anyway. So if a condition were made that specific, would you have any objection to it?
Well, again, it's not to me. It's not for me, CSX, unilaterally to commit to 3 parties.
Well, let's take it one at a. I've got to get a vote of 3 people here. That's why we're here. From CSX's point of view, is there any reason from your point? You're 50% of the cost of maintaining that line. Ultimately, is that a condition that you would find acceptable?
Well, Mr. Chairman, let me point out that Mr. Clemens provided quite a bit of clarity and qualification as to what he was interested in. I wrote down the words, not looking for rigid or inflexible requirements. And I think that's critical. That is critical. Our intention is to provide better service. That's what we intend. A inflexible requirement, all that does is it imposes costs. It imposes costs on pass that are going to have to be borne by pass shippers. That's not something that's going to improve the viability of pass. It might improve other competitive scenarios, but it does not improve the competitiveness of pass if it's done without flexibility. And I heard Mr. Clements talk about flexibility.
What's inflexible about maintaining the quality of the track bed up to whatever the current what its current standards are? What's inflexible about that? You would be hard pressed to say you have a plan to come in here and let the PAS right away deteriorate.
2 years ago, Mr. Oberman, I did not see anything. I did not expect to be in my house for 2 full years behind this computer screen. I did not expect that, but things happen, and the network is very fluid, and there needs to be flexibility. You cannot establish absolute rules. You have to approach them with flexibility. And indeed, the whole history of the rail network and common carriage is a principle of reasonableness. There has to be some flexibility.
Well, Tony,
Mr. Chairman,
I'm just
go ahead. One at a time. Robert.
No, I mean, I don't understand, where you're coming from, Tony, in that respect. I mean, they're not asking to be rigid at all. They're just saying that the request is that you maintain what's already there. I mean, I take that same thing with Marty. No one's asking that it need be better or improvements or that thereof. I mean, my question to you guys yesterday was, do you look to in the future to continue to utilize the entire network? Now, I question that north, south, east, west thing. You said, well, we're going to continue doing that. And to do that, at the very least, in my estimation, you have to maintain, what you already have. No one's saying you do anything better. No one said to fix the tunnel. No one said to do those things. We're saying to FRA standards, continue to operate, past the way you've been operating. I don't think that's inflexible. Not at all. I don't think there's anything to that to suggest that we're telling you to do something any different than you're already doing.
Well, again, I go back to this. Norfolk Southern very strongly yesterday talked about the importance of that line, the need for their main line into Boston to be viable, how important it was to them. We have talked about how, as the second largest user of that line, how important it was to us and the critical nature of that line. You heard the customers telling you how important that line was, that there's no way that CSX can run around and whatever conspiracy theory seems to be in vogue on how we're going to do this. They're on the line. They need the service. They get the traffic from the West Coast. They want optionality. Do you think that it's, CP gets treated differently? Does CP run their own? Is CP thinking when they run their own train over to their customers? There are few cars that they move on this line go on the same train with the CSX freight and the Norfolk Southern freight intermixed into the same train. They get the same level of service. They get the same transit times. They get the same everything. There are few cars.
Jim, I think you're making Marty Mai's point is that you're saying that, hey, I don't know why you even bring this up because you're running on the same track and doing the exact same thing. I guess what I'm saying is it sounds like almost like this condition is a throwaway for them because it's like you are going to it is maintained. And
we are going to we the largest users of the track will, is all we're saying is, yes, we'll maintain the track and we'll make sure that the service is there, but it shouldn't be artificially imposed at some arbitrary standard because for the 1 or 2 cars that CP wants to move on the track. Where did that come from?
Jim, there's more than CP involved here. I think we forget this. If CP never showed up, we have an obligation to the public interest to preserve competitive options in the rail network. And the only reason that we are here talking about conditions is because the acquirer of half of the railroad has a competing line. And so that has presented issues, some raised by DOJ, some raised by others, some urging what you have described as somebody has a radical remedy of requiring divestiture. And I think what we've been engaged in for the last 2 days is a very detailed effort to see if we can't accomplish everything that would need to be accomplished in terms of competitive options without going to divestiture. So that's why we're talking about it. But I sort of share what Robert just said. It's like, it's like people say the only reason I'm not getting the vaccine is that you made me do it. Otherwise, I would have gotten it. It's kind of a strange approach to not be willing to commit legally to what you say is you're totally committed to doing anyway. But let me go to Karen because she wanted to speak up here a minute ago before we,
Yeah, it goes to this point that the concern is that, and you may call this a conspiracy theory, but at some point in the future, CSX decides it doesn't need the pass route, and maybe Norfolk Southern doesn't need it either, and you can close down the route and the availability of it just by withdrawing funds for maintenance. So I think that both CP and various members of the board are concerned that that does not happen, that this alternative route isn't made unavailable basically by agreement between CSX and Norfolk Southern to simply withdraw funds because it's not in their individual interest to keep it open.
Member Headland, can I address that, please? I think as I testified to yesterday, we've invested $400 million into this line and into this area. I cannot imagine a scenario where NS would say, we're walking away from that because we're happy we have 2 trains over on the CSX line. It's just not going to happen. This is why we have carefully negotiated a complex set of agreements that protect our interests. We are not the party that's coming in to ask for approval. It's CSX coming in to ask for 50% approval to buy Pan Am Southern. For us, there's no change except for who our partner is going to be. We shared the concern as to who that partner was going to be. So we negotiated these exact protections that you have articulated and that the chairman has articulated and others have articulated, that you don't want to see that Pan Am Southern line go away. In contrast to this negotiation where we put skin in the game, we've had $400 million. CP's done nothing, no commitments. They're not saying how important that line is. They have their own lines up into the Northeast market. It is not to CP's interest. It's to CP's interest to impose costs on us so that their own lines could be benefited. That's number one. Number two, CP hasn't made a case. They haven't made a case that the conditions that they wanted are backed by the record. They haven't put in any statements, no verified statements, no rate studies, no diversion studies, no economist study. There is no record on which the board would legally be able to impose these conditions because they have not shown that this transaction as presented to you is likely and substantially going to lessen competition.
I'm sorry, Karen.
Go ahead.
So
go ahead, Patrick.
I do want to make an observation, which is, in my view, the board does not have a responsibility, it does not have the obligation to maintain all rail lines open, all options open at all times. I think the whole reason why we are under the Staggers Act structure is because the ICC prevented railroads from adjusting to economic circumstances, including when lines become uneconomical. And what I'm hearing from applicants is you cannot predict in perpetuity every possible twist and turn of the economy, some of which can be quite severe. We've seen commodities come and go. We've seen a spike in frac sand in Wisconsin only to come back down. You know, we see secular trends in coal. All of these things change the economic propositions of lines. And I think to obligate applicants to maintain a line with forever, with all of the economic changes that could happen over time, is something that is exactly the type of thing that the Staggers Act was designed to avoid. And so I just want to make the point that it is important that the board keep open competitive options. It is not the board's job to keep open uneconomical competitive options, and we don't know whether or not this could become uneconomical. I would also add that for unforeseen scenarios in the distant future, unlike the DOJ, well, in a different way than the DOJ, the board has tools at its disposal to protect shippers. Parties will have a common carrier obligation. Parties will have a statutory obligation for reasonable rates and reasonable practices. It is not as though if unforeseen scenarios happen in the distant future, or if future agreements are not as strong as we might hope today, it is not as though the board, under current law, is powerless to address those circumstances. So I think it is important to note that what we may be discussing here is a perpetual obligation to commit railroads to potentially money-losing lines.
So
Go ahead, Karen.
we should look at this on the assumption that at some time in the future, the PAS line may go away because economic circumstances change.
I am saying that, no, I'm not saying that. I'm saying that the requirement that is here being discussed is that the railroads would have to continue to maintain a line to a certain standard, even if economic circumstances changed. So if all of the traffic on this line went away, say there was massive advancements in automation, in dynamic block, and energy usage that completely changed rail routing in this country. There was complete changes in commodity markets. There's economic shifts 25 years from now. What we are discussing is a requirement that these companies continue to pour money into a line that is not used potentially. And in the unlikely event so that's the first thing. Second thing is we are ignoring the economic incentive. And I think that the parties are telling us that the economic incentive they have to maintain the line. CSX is going to use this line for economic reasons. In addition to the sunk cost that Bill mentioned, NS is going to use the line for economic reasons. Their trackage rights over the CSX are not unlimited. And so in fact, a good portion of their traffic is going to continue to use the line. So I say that even as economic circumstances change, there will still be that economic incentive that they will have in addition. So I don't think it's necessarily that we should analyze as though it's going away. I think that we should think about the possibility of what would happen if it did.
Yeah. If they wanted to abandon the line, I just come to the STB and ask for an abandonment.
That's exactly one of the protections that would be in place. Exactly. If there was a line that parties wanted to come in for, there would be potentially, well, first of all, there would be processes in place. If something were economic, parties would be required to continue service at reasonable rates and reasonable practices. And in some circumstances, the board has authorities to for people to step in for economic lines that parties, for whatever reason, are not fulfilling their obligations on. So again, the board has statutory protections for the types of scenarios in the distant future.
Well, that would be true, wouldn't it, Patrick, even if we impose the condition that they shouldn't let the quality of the line deteriorate from its present day. They could always come in and ask to abandon it.
Right, that's my point.
Mr. Chairman, again, to try and, I guess, move along the CP mediation here. We've already guaranteed them a rate. We've guaranteed them that we won't discriminate against them. We've guaranteed them this, that, and the other thing. They're guaranteed a right to run on, to get on our train. As I said earlier, this is not like it's a CP train, an NS train, a CSX train. This is a mixed train with freight moving for multiple accounts in it.
We're talking
So
about PAS, Jim, right?
Yes, well, that's any railroad. Any railroad. When a car shows up for interchange, if the customer wants to move it that route, we interchange. So if CP shows up, they got a guaranteed rate, and they show up with a car for interchange that's going to a local pass destination, or it's got a bridging across, it just gets switched like everybody else's cars onto the train, and it goes. They're not discriminated against in any way, shape, or form. And if we upgrade it to FRA standards, so it's a 3, so that it's upgraded significantly, because we have worked our butts off to grow the business on the line, and it justifies the capital investment, then so be it. They get to go on the faster railroad. If the traffic for some reason diminishes, then we would make the appropriate level of investment, probably close to what's there today, and the train would move at a different speed. Their cars move in the same train with ours. They are in no way, shape, or form discriminated against by moving their freight over that line.
Well, I guess, Jim, from my perspective, I agree with you wholeheartedly on that. I guess from my perspective, that's why I said it. You know, it's this condition is probably in my mind doesn't make sense. I mean, so to add it on, because hey, it's still going to be on the same trains, it's still going to move the same speed as you're saying, and get to the same destination, no different than any other car. So they're not asking
we can't refuse to accept a car in interchange.
But that's what I'm saying. I mean, they didn't ask you to improve it to FRA like level 3. All they said was, just keep it the same way, keep it going, and that's good enough. I like I said, I think we're going around in circles on it. I mean,
the big thing here by maintaining open gateways was a protection for shippers, so that they did not lose competitive options in being able to route traffic on an interline basis. Today, they have an option to go CP pass and CSX pass, and that we would somehow raise the rate for the interchange, for CP, and economically close the gateway. And so to protect the shipper, not CP, to protect the shipper, so they always have their shipping options, we said we won't do that. And that's been the norm for 20 years. So
I don't think anybody disagrees with you. Like I said,
right. So, and they're not discriminated against in any way, shape, or form by saying that we have to have some magical FRA standard to maintain the railroad, or they're dissatisfied. This is just craziness.
Well, I would say this, and then I'm done, because I think we do need to move on, and I don't want to keep you guys any longer than we have to. I think what I agree with you, as I said before, and I don't think they're setting any higher standard or making you guys jump through any more hoops. They're just saying, hey, if you just keep status quo, we're just good. And I don't have a problem with that, because they're not asking you for anything. Just keep status quo. So however you're doing it, keep doing it. That's all they're saying. And I don't see how, that to me is a problem, because you can come back and say, hey, we got to stop that. And that's fine too. They didn't say you couldn't come back and say, hey, but we have to do this, or we have to do that. They just said, hey, going forward, we like it at least to keep where it is for right now. You guys can come back, and you're free to come back and say, we're going to change. They didn't say you can't change. Now, other people said in perpetuity. I didn't hear that.
I think we're talking about imposing a condition to the transaction that's going to maintain, that's going to require us. And I guess the question, the way it's been presented to me today, will I agree to an artificial level of capital investment in a line in perpetuity to satisfy CP when CP doesn't want to negotiate anyway. We could have all kinds of conversations.
I didn't hear them say in perpetuity, and I didn't hear them say that there's got to be a set amount. All I heard them say was, what I read was they want to continue at the same pace that you guys are going now. It didn't say that you had to raise it. Didn't say you had to spend the same. Didn't say you had to go on and forever. What they're saying was that it is, with this deal there, it's not like, okay, we signed the deal and then all of a sudden we start cutting back.
Mr. Chairman, can I?
I didn't hear, correct me if I'm wrong, but I didn't hear a limit.
Well,
Said it was limitless.
I would.
Bill, hold
No, if I-
on, Patrick, go ahead.
I would say, Robert, I do want applicants to, well, if the applicants have sorry, Robert, could the applicants have a answer to that question? Whether or not, I don't think CP set a limit one way or the other, did they?
No.
I would argue just as purely as a pure legal matter that if you're putting on a condition that says maintain status quo, I guess it's the definition of what's the word status quo. The status quo allows the current partners of PAS to either increase investment or decrease investment, to increase maintenance, decrease maintenance. If the status quo means that we have the complete flexibility to change the FRA classification of the line, to make it better, to make it worse, if that's what the definition of status quo is, which is the status quo today, we have that flexibility. I guess then that's not a problem. But if,
I just want to come back, Marty, if I could, because you helped me understand a point that Karen made, and I just want to clarify or put forward what I think about it. Just the whole notion that the party can come back for an abandonment. There is a gap between where the line is today and where traffic would need to be for it to be abandoned. And so if traffic gets to a point in that gap, and it's got to be here, we would be forcing the parties to operate uneconomically, even if they could, by reducing capital investment, make it an economical line so it didn't have to be abandoned. So the treat just an uneconomical line, it's not a binary, it is an adaptable concept, and railroads can scale investment when traffic demands and scale down investment when it doesn't. And I'd hate to see that if that the choice is between maintaining something uneconomical up until the point that it has to go away. There's an ocean between where it is and abandonment. That's the only point I wanted to make.
Yeah, and can I make two more legal points? One, such a condition is not narrowly tailored. That's number one, precisely for the reasons that Member Fuchs just said. Number two is you would be imposing a condition on Norfolk Southern. We are a non-applicant party. You do not have the legal authority to impose a condition on a non-applicant party, such as Norfolk Southern. And so I would caution you as a legal matter, if you try to impose a condition that would require that, you are imposing a condition on a 50% owner who is not an applicant in this proceeding. That you do not have the legal authority to do.
And I'd like to make the economic point that Mr. Fuchs has made, that the imposition of some arbitrary level, specific at the current level, in perpetuity, can readily be anti-competitive, can raise costs, does not allow the railroad to adjust the service quality to the traffic. If you force a railroad to basically maintain a railroad to a level greater than the service calls for, that actually is anti-competitive and harmful for shippers. Things have changed a lot in the rail industry over the 40 years I've looked at it. And there's been a revival, but you can imagine that the LPG, and in a world with carbon limitations, LPG disappears as an important commodity. Limestone, for paper making, could disappear as an important commodity. You could see shifts in traffic on this line that would cause either more investment or less investment for it to be economically efficient. And imposing artificial conditions over long periods of time, is
can be very both anti-competitive and economically inefficient. And that
Listen,
was the lessons of the Staggers Act.
Yeah, I appreciate what you're saying. I do think we need to move on. Let me just make this observation. This discussion, I know it began by CP this morning, but it really isn't, and CP just focused our attention on it. It is not unique to CP. If CP wasn't here, I think we'd be having the same discussion. The applicant came in and said, we recognize that by taking a 50% ownership in a competing line, there are concerns about incentives relating to competition. And in response to the DOJ has come in and said, if you're concerned about PAS having the same incentive to keep this line up, then we suggest that we will go into arbitration about the level of investment. Nobody likes that. And the applicant said, and if you don't like that, we'll appoint a fiduciary to make all the investment decisions on PAS. People like that even less. So I am interested in this discussion, although I think we have beat it to death, in the context of how do we substitute independence for this concern about a change in the incentive because of a change in the ownership. So it could be, we have to deliberate on this, and I do not know where even I would be, much less where the other 4 members would be. But you have given us paths to deal with this concern about how to keep the viability up of PAS over the long run. So if you appointed a fiduciary, I find that somewhat awkward. Presumably that fiduciary would take into account the concerns that I think Patrick has very reasonably raised about how the markets may change in terms of what to do with this line, but at least it won't be a self-interested decision versus a competing line. So maybe that is the way to go if we can't get agreement on some kind of conditions. So I would invite everybody who's at the table and CP and anybody else to try to come to grips with how we assure that there isn't this kind of conflict of interest going forward, and what's the best path forward. As I said, I would much rather it be something that everybody could agree to, and I am sure CP is still listening. And Bill, I'm not going to, as I said, negotiate an agreement. But if CP wants to accomplish something, maybe they'll be motivated to come to the table. Whether we will impose a condition that's not by agreement, I can't tell you today. There's obviously some sentiment for at least coping with this problem. But I think we ought to keep the context in. And while I appreciate very much what Jim said, I, for one, and I don't think anybody else on the board, is raising these issues as some kind of a sop to CP. I am raising these issues up in terms of the public interest of having that line stay viable and competitive. I heard a lot from a lot of speakers today, including the 2 potential owners of the line, about the importance of this line. So we're not talking about the STB trying to keep a line open that's moribund. It's the opposite. But the incentives are changing if this deal goes through. So I think we should move on. There are a couple of other fine points on this that I wanted to cover. Jim, in particular, I'm very impressed by what you said about the Berkshire Flyer. Is that a Berkshire Flyer?
Yes, sir.
I'm looking at your letter of January 10, and I just want to be clear. If you're willing to engage in this 1-year limited experiment, putting that train on there this year for this limited time period, even without the 1,000-foot track being built. But what I thought I heard you say is you want a commitment from Amtrak to build a 1,000-foot track in the future, or you only want a commitment from them to being at least willing to consider it? What are the preconditions to your putting the Berkshire Flyer into operation solely this year from Memorial Day to Columbus Day, as you said?
Well, first of all, let's make sure we understand why we need a 1,000-foot track.
I'm not debating whether you need it. I just want to get your position.
Well, otherwise they have to park their train on the main line.
Yeah, I understand.
So, and then they still don't have any of the arrangements made in New York and all this to actually do this. So what we have said was, if you want to do it, we'll do it without the siding. For now, park your train on the main line. We'll figure out a way around it. And if you decide then to go forward with, because this is a test case on their part.
Got it.
This is not our kind of limiting what they can do. This is a test case on their part. And if they decide to make this a permanent service, then they'll have to put the 1,000-foot siding in to get to park the train on when they take people on and take people off and switch ends of the train and do all that. So
unless, as a result of this experiment, both of you come to the conclusion that maybe it isn't needed. Is that a fair?
Well, we don't decide whether it's needed or not. This is some marketing strategy and of who knows who.
I just want to, I understand, and I'm not questioning the validity of your concern about the 1,000-foot track. I just want to make clear, because it sounds like you and Amtrak are not apart on this, but I don't want any uncertainty going forward. So if tomorrow Amtrak says, as to the 1,000-foot track, we aren't committing one way or another, we want this year's experiment, you'll do the experiment for 1 year.
Yes, sir.
Okay. And as to whether to go forward in any future years, that's open to this, whether Amtrak and you can work out the 1,000-foot track or any other alternative.
Yes, and I assume it's because they want to make sure, from a marketing standpoint, if this is a viable service or not. And at the end of the year, I guess they will know, or at the end of the season, we've already decided where the track goes and, how we're going to put it in, and it's going to need a crossover. And, so we're all ready to go. I assume it's because they don't want to lay out the money for the siding if they don't know whether or not the service is going to be a permanent or not.
Makes sense. But I wanted to get this clear as you just clarified. The second thing that I thought I was clear on, but I've gone back and reread the letter, and Amtrak raised the question of uncertainty. The letter that was filed on the 12th by Tony says that CSX agrees to the indeed request that we impose as conditions 1 through 5 and 7 as requested by Amtrak as they relate to the PAR system and the existing CSXT network.
Yeah.
I guess I read system to include PAS. I don't know if that's true or not.
Mr. Chairman,
Amtrak has asked that it, in fact, these conditions include PAS and PAR. The lingo gets confusing. So can we have some clarification on that?
Absolutely. Mr. Chairman, this is Peter Denton. So the issue here is that we've agreed on behalf of CSX with respect to the PAR system, which CSX will own and integrate into our CSX system and CSX's system. At this time, we simply can't obligate at Norfolk Southern in order to make a similar commitment to the Pan Am Southern network. We're certainly willing to have those conversations, but given kind of the late breaking nature of these commitments, we wanted to make sure that we were able to do so with respect to CSX and the PAR system.
Can you commit to supporting implementing those conditions on the PAS system to the extent you have anything to say about it, i.e. CSX has anything to say about it?
Right, that's right. We would commit to taking that same commitment and working within paths to effectuate those. And frankly, we're going to have a conversation with Norfolk Southern about this when we have an opportunity.
Can you have that conversation before the record closes?
Sure, yes.
I mean, I think if we're going to try to make progress in the passenger rail area and not invoke a lengthy legal debate about our conditioning authority, if you could work it out, that would be good.
Understood. Thank you.
To have the letter apply to PAS as well as the PAR system. That's really what we're focused on. And I don't think Amtrak asked for anything more than what you said in your letter. They just wanted to apply to everything.
Agreed.
So,
And Marty, I would second that. And also hope is that, again, the parties, Norfolk Southern too, would agree to sit down and sort of make sure that, since they're part of PASS, to hammer that out.
Mr. Vice Chairman, I can absolutely commit to you that we are more than willing to sit down and have good faith negotiations and discussions on this.
Thanks, Bill.
Mhm.
all right, is there, so first of all, Jim, Matt, Bill, do you have anything more to say to us by means of rebuttal?
The only thing I'd have to say is I owed Member Fuchs explanation on transit times, and I would say that the hub representative, Mr. Paparello, I believe, he knows his business extremely well. So the filet to pay operation adds a day or two each way to the train. So by moving these trains, that's the types of savings that you are going to have. And that was entirely consistent with what he said. So that's the only thing I think I owed on this record. And I've just appreciated the opportunity, and we will definitely sit down, Mr. Chairman, Vice Chairman, and members commit to that on behalf of NS. And I thank you for the opportunity to appear.
The only thing I would say, Bill, is that I hope someday somebody comes up with the $300 million so I never have to hear filet and toupee again, because I find it a very disturbing phrase.
Yes.
So is there anybody else on your team, any of the three of you, that needs to say anything? And is there anybody else on the board who wants to say anything at this moment?
And I just want to thank, all three groups. I think everyone made a great presentation. I appreciated the back and forth. I think, as Marty said, we did learn a lot. I learned a lot, certainly, sort of my maiden voyage with these hearings. And so I appreciate everybody's time and indulgence with the questions. Thank you.
All right, I'm going to, if I could indulge people here, and I know Bill's trying to get out of here, but there's so many things and my desk is so filled with notes. I would like to take a 10-minute recess just to make sure that tomorrow morning I say, oh my goodness, I forgot to ask one more question. And that I invite everybody else to do the same thing. We'll come back into session and probably close this hearing with the understanding, I think, I can't remember the date, we said the record was going to stay open till the 21st, I believe, which gives people time to get some of these agreements done, if nothing else. So let's do that if that's comfortable. I see people nodding. It is 5:49. We will come back at 5:59 and hopefully close this hearing. Thank you very much. All right, we are back on the record. I, for one, have no further questions, and if no other board member has any further questions, or no member of the team of Foote, Mullins and Walsh, new law firm, has anything to say, I think we can wrap this up. So
we would just thank the board for all our time today.
Well, let me say this. I'll take the lead on this, but I'm sure each board member will want to say a few things. I want to thank everybody for their participation. This is a very intense 2 days. I hate to say it, but I think you can all anticipate that this is the way this board is going to operate. We are thorough, intense. We want to get to the bottom of every issue, and you have all been very responsible and thorough in responding to us. So I, for one, appreciate it. I congratulate everybody who's participated in this hearing. And once I think other board members have their final say here, we'll close this hearing. And I am right that we will keep the record open until January 21. If anybody discovers something that they feel really just needs to be corrected, or to respond to something new that you hadn't heard before, but really we don't want any more new arguments. With that, Michelle, it looks like you are seeking to be recognized. And I didn't want to cut you off if you had another question.
It's not a question, Marty, and I'm sorry to have jumped in.
No, that's okay.
I just wanted to echo your comments on the thoroughness of the presentations of all the parties, and thank you for all the hard work that's gone into this. But I did want to take the opportunity to underscore what I believe Chairman Oberman has said, and so has Member Fuchs, which is that I too agree that the best outcome for the network will be if the parties themselves can actually hammer out the terms of an agreement in this instance.
Okay, thank you, Michelle. Do other board members have any closing remarks? Karen?
Want to thank you all for the extraordinary level of discussion today. It was enormously enlightening and intellectually stimulating. This is the reason I wanted to join this board. So I just want to thank you for everybody's efforts today, both the chairman and my fellow board members, but also all the participants. It was just a really extraordinary experience. So thank you.
Karen, I'm glad to hear you say that, because I was afraid you were going to come on and say you were going to ask the Senate for a recount. All right.
Hey, Marty, I do want to come back and say, I know I thanked the participants for their time and attention, and it was a great and intense 2 days. But I think none of it would be possible without the team, at the STB. Matt, I want to thank you for doing that. Usha, all the IT people for making it. I mean, we didn't have one glitch, and I'm really happy, proud of that. Our teams, attorney advisor Elizabeth, on my team, and others who helped prep us and get us ready. All the people who aren't on camera. I mean, even the folks on the other side. All their teams as well. I mean, it was a well-oiled machine on both sides. I think it went well, and and especially I'll leave the best for last, Marty. I think you did a fantastic job moderating and keeping us in line and keeping us from going off the rails. And yes, I used the pun, but it's it's been an honor to be able to be a part of this hearing, and I want to thank you for your leadership. And sharing it and bringing it forward. So thank you.
Thank you. Much appreciated. Patrick, you're going to get the last word.
Well, no, I'll leave that to you, Marty. But my colleague said it extraordinarily well. So I'll just say excellent testimony. I want to especially recognize the witnesses that had to adjust their schedules as a result of the inquiry. It's much appreciated and value everybody's input. And I too want to thank my colleagues for the wonderful questions. Staff and IT were phenomenal throughout the 2 days. My attorney advisor, Lisa Novins, was excellent as always. And Mr. Chairman, you pledged transparency, openness, and rigorous debate when you took the gavel. And I think you fulfilled that the last 2 days. So great job to everybody.
Thank you much. And I will close by saying it's like the Academy Awards. There are too many staff people and support people to thank, and name them all, we'd be here for another hour. But I'm going to single out Adam Kress. It says, if you think I'm a tough questioner, it's only because Adam told me what to ask. Not entirely. We worked it out together, but he has worked mightily, and I'd like to single him out. But really, everybody, you have no idea, all of you out there in Zoom land, the amount of work that our staff has put in leading up to the hearing and over the last 2 days, and we couldn't function without them. They're fantastic. So thank you all. This hearing is closed. Have a good weekend.
Thank you, Mr. Oberman.
Thank you.
Thank you. Well done, Jim.
Thank you. Bye.